Good morning, everyone. We're here for day 3 of the Sarah Boone trial, the Suitcase Murder Trial. Day 3 is likely going to be an exciting day. Yesterday, we learned that the state was presenting its last witness. Now, that witness is still on the stand as of the start of today. The defense has not yet cross-examined the witness. The court concluded yesterday while the witness was still on the stand. They kind of got started a little late yesterday, so they went a little late yesterday evening. And when they finally ended, the court said, you know, you all told the jury, you all have to get out of here. You all have to go home. So I'm not going to keep you any longer. We'll pick back up to tomorrow, which is today. And so we should see the end of the state's case in chief fairly soon. After that, we're likely going to see motion practice, the obligatory, request for a judgment of acquittal. Basically, I'm sure that the defense team is going to say the state hasn't proven their case, so just let her go. We'll see how the judge handles that, but I doubt that motion's going to pass muster. But we'll see. We'll see what they argue. Perhaps there's some element of this criminal case that I'm unaware of that the state hasn't made a showing of, but I don't think that to be the case. Jeff, good to see you. Carol, good to see you as well. So after the motion practice is done, assuming, of course, that the judge doesn't grant any of the defense motions that may be coming, we will get into the defense's case in chief. Now, when the defense begins, I believe that they're going to be starting with Miss Boone. And because I believe they're going to be starting with Miss Boone, I've moved some things around this afternoon, try to free some things up so that hopefully I don't have to stop the video, stop the stream in the middle of her testimony. I want to, kind of get her testimony in its totality out of the way. If she ends her testimony, and then my afternoon activities begin after that, then I may pause the stream at that point. But I'm going to do my level best not to stop this stream in the middle of Sarah Bone's testimony. I may be able to move some things a little bit more while the stream is going on, if it looks like Miss Boone is going to continue to be on the stand when my afternoon activities begin. With that said, I think we can just jump on into this thing. So I've fast forwarded the stream to where the court begins. So we're kind of going to pick up in the middle of the judge's judge statement. Don't worry about what he said before that. Nothing has happened at this point. So we're about to, I think, hear from counsel or something. I don't really know. I haven't watched yet this morning. Tread, great to see you here. Let's jump into it.
And while the jury panel enters and exits, my understanding is that our panel is here this morning. State, do we have any housekeeping matters we need to address before we bring back in our panel?
As we've done in the past, I'm going to speed this up a little bit. Again, if there's any issues with you all hearing, or if you want me to turn closed captions on, just let me know in the chat and I'll make that happen.
Yes, sir. 3 discovery issues, and then I filed a motion late last night requesting an in-camera inquiry into a potential conflict of interest. I copied your JA.
I did review the motion.
Okay. The 3 discovery issues are these. One, on October 5th or October 4th, I believe the defense was provided with the body-worn camera 911 calls from the prior incidents, and there was a request made to tell us what, if anything, should be redacted from their point of view so that we could either reach an agreement or use the court's resources to decide any conflicts in those issues. Yesterday morning was the first actual response I got from the defense team, and it was incomplete. It was about 3 of the 5 incidents. I do agree with 2 of the redactions, and we're getting those taken care of. But obviously, just like connecting to the court's screen, it takes time, and I'm not the person that's going to be doing it. Somebody else in the office has to do it. The 3rd incident, I think we're still not on the same page as to what the state's planning on introduce. So I resent the email with the screenshots of what files the state plans on introducing to the defense team again this morning. I have not heard anything yet from the defense team about the 4th and 5th incident. I was told that Attorney Beck was going to handle it. It is now Tuesday, day 7 of trial, and he has not handled it. The second discovery issue is Friday I was given a hard copy of the 119 pages of the second copy of the Winter Park Advent Health
On
records.
10/18, October 18th, that would have been the preceding Friday.
I was given the hard copy after court at about 5:30, 5:45. I emailed the PDF of those records back to the defense as they requested. I put Bates numbers on them. I understand from court what pages they indicated that they want to use and what pages the court indicated should be included at the state's request, which is pages 26 and 48 out of the 111. I would just appreciate if I could get a copy of the intended.
So it doesn't sound like any of this is really matters to anything. So I'm gonna fast forward through this.
And given any narrowed down version of that so that we can confirm we're on the same page or use the court's time if there's a conflict. Thank you.
Okay. Responses to the first discovery issue regarding body-worn camera and 911 calls is to the, my understanding, 5 prior incidents. Defense.
To isolate which incident is.
Let's see if it looks like they're about to start another motion. Let's see if this one is a little more interesting.
My understanding is the state is talking about the 3rd incident. That would be June 18th.
So there's 2 attorneys for the defense here. This guy is Tony Henderson. Both of these attorneys are from Milton, Florida, and that's up in the Panhandle. And this case is going on down in Orange County, which is in the Orlando area, which is more central Florida. So they are likely staying in hotels during this entire trial, including the time that they were impaneling the jury. They were doing voir dire. And they are pro bono. They are taking this case pro bono, likely because they know it's going to get media attention. I mean, that's probably one of the things that they took into consideration when they took on this case. But these 2 attorneys don't work together. They each have their own law firms. I believe Mr. Henderson has a single female partner, and the first chair attorney, I believe he has one partner as well, but they are not partners in their business. It's interesting that they found each other as opposed to using their partners. I'm guessing that it's to kind of absorb the cost of this between 2 different defense teams. But they did find each other likely because they're located in the same city up in the Panhandle.
Here's the problem. I sent these pictures over with OCSO case number, and then I get a response based on incident dates. So we have to kind of cross-reference. So we can just make the record entirely clear. OCSO incident 18-067501. There was no 911 calls and apparently no objections.
They're still talking about the same thing. Who is that?
August 28th, 2019. What say the defense?
John, I don't know about the state's position on this. There's a portion of this video at the very end that's very personal to the investigating officer that they may want to redact. We're not asking.
So this lady may
Is the
be
state seeking any redactions?
this lady may be Mr. Henderson's partner. And this gentleman here, it looks like she may have a 4-attorney defense team. you're not allowed to talk to the court if unless you're an attorney or one of the witnesses. So if these people are talking to the court, they're attorneys, and this may be his partner, the Mr. Henderson's partner, the woman at the table, and this gentleman with his back to the camera may be First Chair's partner as well.
Clarifying what their redaction requests are in that particular file.
Okay.
If they don't have any, then
So are there any redaction requests with regard to that particular file?
No, Your Honor.
Okay. I'm just keeping notes. Give me a moment, y'all. Is there anything that I stated incorrectly, Mr. Beck, Mr. Henderson, or Mr. Owens?
No, Your Honor.
Okay, thank you very much. Moving to the next issue with regard to the 119 pages from Winter Park. Defense are you in a position to provide, I believe we discussed it either Friday or I think it was last week, we discussed it as to the how.
We're talking about all redactions of things in certain evidentiary documents. Without seeing what these documents are, it's kind of hard to determine what they're redacting. So probably nothing that we care to hear. And now the jury's entering. So look, we just skipped over almost an hour. Hey, Natalie, good to see you. Glad you joined us.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, everyone would be seated. Thank you. Members of our jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. Thank you again for your time, your attention, and your sacrifice in this matter. Just by a show of hands, if you could confer that you complied with the court's instructions last night. The record will reflect all juror members have raised their hands. State, if you could please recall Detective Kepsel.
State would call Detective Kepsel.
You swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Ma'am, good morning again. Could you state and spell your name for the record?
Yes. My name is Chelsea Kepsel, Chelsey, Koepsel.
Mr. Capstory, you may proceed.
Your Honor, we had tendered the witness to the defense.
Okay, thank you. Mr. Henderson, you may proceed with any cross-examination.
Good morning, ma'am.
Good morning.
Now, it's my understanding that on February 24th of 2020, you responded to this crime scene, is that correct?
Yes.
Were you the first officer to respond to the crime scene?
No.
So there were other officers who were there prior to you arriving, is that correct?
Yes.
Were you the first detective to respond to the crime scene?
Myself and my partner, we all arrived at the same time because we left from the same location at the same time.
Okay, and who was your partner that day?
Detective Scott Lowen?
And throughout the whole time, you and Detective Lowen worked on this case together, is that correct?
Yes, he assisted me with this case.
Now, when you arrived on the 24th, approximately how many other officers were there?
Including, like, deputy sheriffs, like in uniform?
Yes, ma'am.
Yes. Oh, approximately 4, maybe, I would assume.
Had it been designated a crime scene at that time, and had tape or security measures been taken to protect the scene?
Yes, they had.
So that had already been done by the time that you arrived, is that correct?
Yes, that's correct.
Okay. Now, in the investigation, one of your, or what you're trying to accomplish in the investigation is basically get the basics of what took place. Would you agree with me there?
Yes, I would.
All right. And you can do that one or two ways, or a combination of ways. One is to take testimony of potential witnesses, is that correct?
Yes, it is.
All right. On this day, did you in fact do that?
Yes, I did.
And one of those potential witnesses was Sarah Boone, is that correct?
Yes, it was.
And you took a statement from Sarah Boone because we've all seen it, is that correct?
Yes, we have.
And at that point in time, Ms. Boone did not have to talk to you if she didn't want to, did she?
No, she did not.
So she agreed to talk to you at that point in time?
Yes, she did.
Okay. Were there any other witnesses besides Ms. Boone that you talked to on this initial date of the 24th?
Just Brian Boone.
And Mr. Boone told you what? You had a chance to talk to him. He told you his involvement. Is that correct?
That's correct.
And in fact, wasn't Mr. Boone's testimony, was that recorded too?
I conducted an audio recording, yes.
Okay. Is that standard procedure when you do your interviews to try to record the interviews?
Yes.
What's the benefit of that?
So I know what was said.
Okay. So, and if something goes on for a long time, you can refer back to it, is that correct?
Yes.
Okay. All right, so, and out there, that's part of talking to witnesses or potential witnesses. Okay, also, is your job too to identify potential physical evidence in a case?
Yes, it is.
All right, and in fact, on the 24th, did you do that?
Yes, I did.
Okay. Did you have anyone assisting you in doing that aspect of it?
Yes, crime scene investigators and digital forensics investigator.
All right, and was Miss Melissa Rothengarten, is that how it's pronounced? Pronounce it for me.
Rough Garden.
Rothgarten, okay, thank you. Did she help you in that area?
She was the lead crime scene investigator, yes.
Okay. So were y'all walking around together? Give the jury an idea of how that process takes place, please.
So yes, when I
So, Ms. Carroll, that's a interesting question. So why would these people come 8 hours away to take on this case, especially when they're doing so pro bono, when they're not getting paid for this? So there's a couple answers. One, I forgot the lead attorney's name. It is James Owens. James Owens had a couple of interviews with the defendant when she was in jail prior to taking on this case. And this is after she had already gone through 8 other attorneys. Now, before he came on this case, she had gone through these 8 attorneys, and the judge told her, you're done with your right to have a court-appointed attorney. We're not giving you any more court-appointed attorneys. Basically, the judge ruled that she was using the court-appointed attorneys and acting in such a way that they kind of had no choice but to withdraw from the case in an effort to kind of stymie justice, in an effort to prolong the matter so that she wouldn't end up going to trial. So basically, the judge ruled you can either proceed pro se or you can find your own attorney. Now, at that point, she draws this up from a jail cell. I'm going to hide your comment here. She draws this up from her jail cell. Let me blow this up for you. And as you can see, this is a court document. It says inmate seeks attorney looking for a prosperous challenge. These people are taking this pro bono, so it's not prosperous. Ready for your close-up on national television. Are you zealous with a side of keen? Show the world who you are with your original creativity, extraordinary expertise, confident ingenuity. And then she goes through the qualifications that you have to have. You have to be trustworthy, honest, passion-driven, open-minded, with exceptional problem-solving skills. This is because her case is a problem, and you've got to figure it all out. And you don't have much time to do it because the judge said we're not postponing trial. Extreme efficiency in listening, communicating, understanding. So when she says extreme efficiency in listening, communicating, and understand that this woman was in jail. And one of the issues that her attorneys were having with her, she's sending letters to the judge saying that her attorneys are not effectively communicating with her. At the same time, she is calling her attorneys 10 times a day, expecting them to drop everything and talk to her. She is accusing her attorneys of setting up false judges as if they are somehow colluding with the state. I don't really understand the charge that there are these false judges involved in this matter who she accuses her attorney of making it seem like these other judges are presiding over the case. I'm at a loss to understand what these letters are purporting in specific, but that's essentially what she's telling the court. You also have to have a dedication to success, possessing a winning mindset, capability of excellence and representation, committed, maintaining faith. And she's drawn this in her jail cell. And she's bold in the word faith, maintaining faith in the client. So you have to believe in her. Despite all of this evidence, you've got to believe in her. Not just that you can get her off even though you know she's guilty. You got to believe in her. And the case with the ability to think differently, overcome all circumstances. Epic opportunity awaits. And then she has her name and her prisoner number. And she is an inmate with the Orange County Corrections Department. She invites the attorneys to invest in the oppressed and believe. So this is the advertisement that this attorney responded to. And obviously the one of the first things that she says on this is ready for a close-up on national television. Now, these attorneys are from Milton, Florida. If you weren't from the Panhandle, Carol, would you know where Milton, Florida is? I didn't even know where Milton, Florida was. I was in Tallahassee for what, 8 years? So these probably are not big name attorneys. I've never heard of them. So this is their opportunity in the spotlight. So they went 8 hours out of their way. Likely one of the driving factors was exactly what she advertised for. They want their time on television, on national television. They want their time in the spotlight. So that's pretty much all I've got for you as far as an answer to your question. I'm gonna put that question back up just in case anybody tuned in after the fact and wants to know what question we're answering. So yeah, let's get back to the trial though.
I initially arrived on scene. I introduced myself to Sarah Boone and explained that I wished to go inside her residence, which she gave me consent to go in and look around. I went in, looked around, and then when my CSIs arrived, they would go in, take pictures, and then I kind of leave them to do what they need to do as far as taking pictures and documenting things and measurements. And then that's when I conducted my interviews. And then I would meet back up with my crime scene investigator after interviews were conducted to kind of follow up with like things that I was told that would help us like identify things from the scene. And so, I mean, there's like multiple occasions where I would have met with my crime scene investigator inside the residence.
So this is an ongoing process during that day. You get information, you consult with them, they have information, they consult with you, and you're making a determination of what potential physical evidence that y'all at least like to document by camera, correct? Pictures, or actually collect and take away. Is that correct?
Yes, that's accurate.
All right. In that case, the suitcase was some evidence that y'all agreed on that we need to take this suitcase from the scene. Is that correct?
Yes, it was.
Okay. How about the baseball bat? Was that done that day?
The baseball bat was collected, yes.
All right. In your viewing of the suitcase, did you view the suitcase while it was unseen?
Yes, I did.
All right. Did you notice that if there was any items, other independent loose items in the suitcase?
There were, yes.
Were those items collected?
Some of them were, yes.
Who made the determination what items of that suitcase would be taken or collected and what would not be collected?
I would say that I have the final say on what is to be collected or not collected, but we do discuss it together to make that determination for me to give the final yes or no.
Do you recall which items you decided to collect from the suitcase?
Do you have the property form that I can refer to?
No, I'll try to find it.
I know some of them, but
Ma'am, I don't have it, but to the best of your memory, can you tell? And I would understand there would be some stuff that if you had the property report to refresh your memory, you can give me more detail.
yes, to my understanding and to my recollection, we collected things that had blood left over on it. I want to say there was like a necktie potentially. I do recall there being a small amount of clothing and miscellaneous paperwork, but I do not think that we collected the paperwork. There was also a cell phone in there. It was not, it was dead, the cell phone. And then, like I said, there might be one, I think we collected 5 to 6 items from the suitcase itself, but obviously the property form would tell you specifically, but that is what I recall.
Correct, and I understand, and that's fair. Okay. So potentially you collect these items because you believe they're evidence for the case potentially, is that correct?
Yes,
And some of these items you actually collect with the potential that you might need to have them examined in greater detail, is that correct?
yes,
Okay. An example of something like that would be in this case, if you found blood on something, you might want to potentially examine that, is that correct?
yes.
And also the stuff that you're learning outside of these items also helps you in making that determination, isn't that correct?
I'm sorry, one more time.
The stuff that you learn, the information that you're getting or you're receiving about what happened at that time will lead you to determine what items might need to be collected and what items might need to be tested.
Correct.
Is that correct?
Yes.
All right. So out of the items that were collected at the house or the apartment, at those items, was anything, to your knowledge, sent off for further examination?
I believe so, but if it was, there would be, they would be sent to the Florida Department of Law Enforcement for further testing.
Okay. And do you have an independent memory of what items that were collected from the house that were sent to FDLE for further examination?
I don't recall specifically without looking.
Okay. Now, are you aware at one point in time, there were some fingernail clippings or fingernail swabs taken from Ms. Sarah Boone? Is that correct?
Yes,
All right. In fact, that was done on her interview date, on the, would have been the 25th?
yes, sir.
Is that correct?
Yes,
Okay, and that's what we witnessed in the video?
yes,
That's what they were doing at that time, correct? And I'm sure at the autopsy, which you were present at, is that correct?
yes.
And those, there would have been some fingertip swabs of Jorge Torres. Were you familiar with that?
They do swabbing of the hands, to my understanding, and clippings of his nails.
Okay. Do you have an independent memory of the fact that Sarah Boone's fingernail swabs were sent to FDLE for comparison?
I would believe so.
Okay. How about the one from Mr. Torres? Do you have knowledge that those were sent to FDLE for comparison or identification?
Well, they would have come from him, so I'm not sure what we would have compared him to.
Okay. Were they there to see, or at least they're sent there to see if they can extract DNA?
Oh, okay, yes. I mean, I'm not sure if they did that testing for his nails clipping specifically, but it would be in the report if so.
Okay. Who would make the decision about sending his finger swabs to FDLE for comparison or evaluation?
I would request it from, or I would request it to the crime scene investigator, and she would author the, I guess, procedure for them to do so.
Okay. And then as to Sarah Boone's swabbings, who requested that those be sent to FDLE for evaluation?
Again, I would assume that I would have done that. I would have requested the CSI to do that.
Are you aware of the results from those evaluations? I'm not asking you for the results, just if you're aware of the results.
I believe I'm aware, but would love to see a report before I specifically answer.
Yes, I'm not going to ask you a specific question
Okay.
about it, okay? All right. But basically, you're aware that it was done, the procedure was done?
Yes.
The analysis was done, okay. Now, ma'am, so you're through the first day, then we get to the second day, which would have been, I believe, the 25th of February, is that correct?
Yes.
And on the 25th of February, was Mr. Torres' autopsy done at that time?
Yes, it was.
Were you present during the autopsy?
Yes, I was.
And did you communicate with the medical examiner at that time?
Yes, I did.
During the course of things, is that where you found out through the medical examiner at the autopsy that there was blunt force trauma injuries?
Yes, that is where I learned more about his injuries.
Now, initially, when you were on the scene on the 24th, did you view Mr. Torres's body?
Yes, I did.
Did you notice in and of yourself on your own something that caused you concern that there might be blunt force trauma injuries?
Yes, I noticed injuries to him, yes.
Okay, so after the autopsy, you had additional information, is that correct?
Yes, I did.
Now, there was an interview, well,
So it seems like he's trying to find out if it seems like he's trying to glean information from her that he can possibly poke holes in, because he doesn't have anything to poke holes in up to this point. So he's kind of asking her questions, it seems like, to say, well, to go back and say, well, why did you make these decisions at the crime scene if you didn't find out about this, all of this other stuff, until later? So that's likely going to turn into like the cell phone video. Why were you looking at their cell phone? You had no reason really to look at that. With respect to the blunt force trauma, he first asked, did you learn about the blunt force trauma at the autopsy? He probably should have crafted that question a little better, because he followed it up with, and she answers yes. He follows it up with, did you notice injuries to the decedent at the scene? And she says yes to that too. And those are two different questions, right? So she can notice injuries, but not know exactly that they're blunt force trauma injuries, and decide to collect the bat just in case they are. Had he asked, did you learn of injuries at the autopsy, and she said yes to that, then that would call into question why she collected the bat at the scene of the crime. But the way that he asked the questions, there's still there's no room there for him to dive into, well, why did you collect the bat?
I don't know if it was an interview. There was a meeting set up for Sarah Boone, is that correct?
Yes.
On the 25th? Is
Yeah.
that correct?
Yes.
Can you tell me how that meeting was arranged or how that meeting was set up, please?
So either before I left the scene, the night of the incident, I obviously met with Sarah and told her that we were leaving. We had to go make next of kin notification. And I would have either at that time said I would like to meet tomorrow and arranged it then, at least to like let her know that I would like to meet after the autopsy. And then obviously from watching the video towards the end, she said something about like recalling a conversation that we had, like calling me. So there may have been a phone conversation that occurred later that evening where I either would have confirmed the time or told her the time then. I just don't have that like on an audio. But I know it either took place before I left the scene, because I obviously would have, said my goodbyes and told her, hey, we're leaving, we're going to make next of kin notification. She was very concerned about that, so I would want her to know that we were doing that. So it either took place then or it took place on that phone conversation that we had.
Okay. All right. The day prior to that, on the 24th, ma'am, you received Sarah Boone's phone, is that correct?
Yes, her phone was on the scene, yes.
And when you received that phone, Sarah Boone had given you that phone, is that correct?
No, she was not allowed in the apartment to give me the phone.
I'm sorry, did she give you permission to take the phone?
Yes.
Okay, is that correct?
Yes, I was given permission to go through her phone, yes.
Because at that time, you hadn't applied for any type of search warrant to get or search the phone, is that correct?
No, it was based off of consent.
Okay, so she had consented to you for you to have her phone, is
Yes,
that correct? She also provided you the code to get in the phone, is that correct?
yes,
So at this point in time, Ms. Boone is cooperating with you, isn't that correct?
yes.
Now, ma'am, do you recall telling her, Ms. Boone, that she could get her phone back the next day?
I don't recall specifically telling her when she would be able to get her phone back, but I did say something along the lines of we were now going to be taking the phone. I obviously had digital come out for consent to go through her phone. There was evidence on her phone that I needed to be downloaded. And at the time, I was willing to give back her phone before going through it. And then once we had gone through it and those videos were found, I felt like this was very different. And it changed my perspective on consent. And I decided at that time that it was best to write a search warrant. So consent couldn't be basically like.
So they obtained the phone by consent, but she's saying that she was going to keep the phone in her possession. The problem with keeping the phone in her possession when she's going through the phone by consent is that once the phone leaves the individual who owns the phone, how does the individual who owns the phone withdraw consent? So she assumes that because the consent is being granted and there's likely nothing of evidentiary value on the phone, that consent won't be, this is likely what she's thinking at the time. Consent won't be withdrawn because really we're just collecting stuff out of the phone just to dot our I's and cross our T's. But once she finds that video, then she says, well, when I found the video, I changed and now I want a search warrant. So at that point, she's probably keeping the phone and not going through it until she gets the search warrant, because now she knows there's this stuff on the phone that is of evidentiary value. I want to keep the phone. I want all of this stuff to be admissible still. So I'm just going to get a search warrant just to make sure. That way we don't have to worry about her attempting to withdraw consent later on, because we'll have a search warrant in place and I will no longer require her consent to look through the phone and obtain evidence off of the phone.
Like I knew I was going to take her phone. So consent has to be basically. And I decided at that time that it was best to write a search warrant. So consent couldn't be basically like I knew I was going to take her phone. So consent has to be basically given to me throughout the entire period. So she would have had no way to contact me to tell me she no longer consented. So therefore, because there was evidence on the phone, I took the phone. Basically, I potentially told her, maybe we didn't get a full download. I may have said something along the lines of that. As far as me taking the phone, and then I wrote a search warrant. I either started writing the search warrant the night of, but it wasn't signed until, I didn't submit it until the next day. And then it was signed the next day, on the 25th.
So basically what you're telling us is that she could have withdrawn her consent at any time prior to that search warrant being received. Is that correct?
Well, while I was on scene, but at the end of the day, there was evidence on the phone, so I knew I could get a search warrant to go through the phone based off there being evidence. Like the 911 calls, and her explaining to me that they had spoken to family members.
Please silence your cell phones.
Since they had explained to me that they spoke with family members the night prior. So I wanted to obviously corroborate her statement. So I knew that I would be able to get into the phone through a search warrant. But yeah, she could have not consented and she could have not signed the paper consenting while we were on scene.
But before you left scene, you knew that Sarah Boone was not going to get that phone back. Is that correct?
Yes, that is correct.
Okay. So when Sarah Boone called you,
So basically what she's saying is, look, she gave me consent to go through the phone. Once I saw that there was evidence on the phone, remember the prior witness who actually had the phone and was doing the download testified. Once I found the video, I took it to the investigator. That would be the woman on the stand now, Detective Kopsel. And she told me to stop the download until she gets a search warrant. So at that point, they had already downloaded the video and seen the video, but they didn't want to go any further until they had the search warrant. But because they had already found the evidence pursuant to the consent that had been granted, at that point, they are allowed to keep the phone because they don't want to risk any further evidence being deleted if they turn the phone back over to the defendant in this case. So she is well within the state's rights to retain the phone, even with or without consent at this point, because there's evidence on the phone.
The next day, asking you about bringing her phone back, did you just tell her, Ms. Boone, you're not getting your phone back?
There was not a conversation about her not getting her phone back. She may have inquired about her phone, and I would have explained that we will talk about it when we meet that afternoon.
Okay. So, did you reach out to Ms. Boone that next day, or did Ms. Boone reach out to you?
I don't recall a specific, if she reached out to me the night of the 24th or before the interview on the 25th. I don't have my call records for that. I'm just basing it off of the interview where she had basically said that, yeah, I have your business card and I can contact you like I did. So my assumption would be that we did have some sort of conversation either the night of the 24th or before the interview on the 25th.
On the 25th, did you make arrangements with Sarah Boone to meet with her on the 25th?
So I either made arrangements on the 24th with her before leaving the scene, and I would have told her I would like to meet with you the next day, or I said, and I may have given her a specific time at that moment, or when we spoke later that evening on the phone, I may have confirmed the time or given her a time then, but she definitely knew that we were meeting at 3 p.m. on the 25th at Orange County Sheriff's Office Central Operations.
And ma'am, you just don't remember at what point in time you informed her or set up this meeting with her. Is that correct?
It's one or the other.
One or the other?
Yes.
Okay. As to it being one or the other, you did you prepared the investigative report in this case, is that correct?
Yes, I did.
And the investigative report, you basically summarized everything that took place on this case, up to a certain point.
Yes,
Is that correct?
it was a summary, yes.
All right, as far as evidence, as far as witnesses who were talked to and synopsis of what they said to you at that time, is that correct?
Yes, things that I did specifically. It was a summary of that.
I found your investigative report to be in great detail because it helped me track this case from basically beginning to, not to the end, but to the point where the report stops. And it seems like in your investigative report, you are very thorough about details. Is that correct?
I would say I'm a detailed person. Yes, thank you.
Okay. So being the detailed person you are, and absolutely doing your law enforcement training, they tell you, they train you that your report should be very much in detail. Is that correct?
Yes.
Okay? Because you might have to refer back to them at a later time. Is that one of the reasons? Is that correct?
Yes, I'm to prepare myself for depositions and trials.
Okay, and just to give an accurate picture of what you did and what took place and what people told you. Is that correct?
Yes.
Okay. Being as thorough as you are with these contacts with people, I didn't see in the investigative report when the arrangement was made with Sarah Boone to meet you that.
The attorney is making a mountain out of a molehill. So let's assume that the conversation, scheduling this interview never happened. So what? Let's assume that the investigator called Miss Boone. So what? Let's assume that Miss Boone called the investigator. So what? We know that the interview was scheduled. We know the interview happened. What does it matter how that schedule came about? What does it matter who called who? What does it matter when the interview was scheduled? None of this matters. Essentially, I think where he's going with this is going to be, you all tricked Miss Boone into coming in to do this interview, and therefore she should get off because this was all trickery. So the defense has to work with the evidence as presented. They've been given a really tough hand here because Sarah Boone is not, even though she says she's a straight A student and she's extremely smart, she is not the best criminal in the world. Obviously, she videotaped parts of the crime. So they've been dealt a pretty bad hand. They're doing the best they can. This isn't, this can't go anywhere good for the defense.
And where did y'all meet?
The Orange County Sheriff's Office Central Operations.
All right. To meet you at the Orange County Sheriff's Office. I did not see that in the report. Do you have an explanation why?
It's not typically something I would put in my report.
Okay. Do you remember in having the conversation with Ms. Boone about this meeting that was supposed to take place, that you said that you could not return the phone to her that day because you were not feeling very good? You remember telling her that?
That never happened.
Okay. Ma'am,
No, I don't remember telling her that because it didn't happen. She's lying once again.
Judge, if I could have a moment.
Yes, sir, of course.
Ma'am, during this time frame, were you pregnant at that time?
Yes, I was.
Okay. All right. Well, anyway,
Why is that relevant? What does it matter if she was pregnant at the time? And now, I will say this. I think most police departments take people off the street, take officers off the street when they're pregnant, likely so that if they are injured on the job, to prevent injuries on the job that are going to cost the city, the county, the state tons of money if the unborn child is injured as well. But what does it matter if this individual was working while pregnant? No relevance here whatsoever.
Ms. Boone, there was a meeting arranged. Is that correct?
For the 25th at 3 p.m., yes.
Yes, and Ms. Boone showed up for that meeting.
She
on
did.
the 25th.
Yes.
That we saw. Okay. Now, ma'am, I'd like to talk to you about some other investigation. On witnesses, other witnesses.
Let me just also point out that this woman was pregnant at the time that this incident occurred. Her child is like 4 at this point. It's been a long time, and she's been able to judge that time based on her child growing up.
That you took their testimony or statements, recorded statements at different times. Okay? Do you remember Abraham Marino?
Yes.
Okay. Did you take his recorded statement?
Yes, I did.
All right. At the time that you took Mr. Marino's recorded statement, was there anyone else with you?
My partner should have been with me, Detective Scott Lowen.
Excuse me?
My partner should have been with me, Detective Scott Lowen.
Okay. Ma'am, as to who was with you, would it help refresh your memory if you were to see your investigative report as to that interview?
Your Honor, I would object. She hasn't said that she needs any aid in refreshing her memory.
Objection sustained.
Ma'am, was Detective Scott Lowen with you during that interview?
Yes, I believe so.
May we approach?
Yes.
Perhaps her partner was not with her during that recorded statement. And so now defense counsel wants to refresh her recollection of the fact that her partner wasn't with her. And he just wants to get permission from the judge before there's another objection.
Ma'am, do you have an independent memory of Detective Scott Lowen being with you at that interview?
I believe my partner was with me on the interview. Yes, I typically wouldn't go and do some follow-up without my partner being with me.
Thank you very much. Now, ma'am, what date did that interview take place on?
I believe the 26th, February 26th of 2020.
Okay, thank you. Ma'am, was that interview recorded?
It was audio recorded.
Was the entire interview audio recorded?
Yes, the entire interview was audio recorded.
Ma'am, are you familiar with a witness by the name of Brandon Moats?
Yes, I am.
On February the 27th of 2020, did you interview Brandon Moats?
I believe so. It was either the 26th or 27th, yes.
If you were to see your investigative report, would that help refresh your memory?
All right, I'm going to again object. She hasn't indicated that she needs assistance with her memory.
Approach.
So notice that this detective doesn't answer any questions immediately. She pauses. She's been on the stand before. She has to have been on the stand multiple times before. She pauses before answering any questions, and that gives the state the opportunity to raise their objections and have a ruling on those objections before she answers any questions. This is a great witness. I'd love to have. I wish all witnesses were like that.
Ma'am, if it was the 27th, you would not disagree with that, would you?
Well, I just stated that it was either the 26th or 27th.
Okay, thank you. Ma'am, Mr. Moats, he was the neighbor living in the apartment, or the connecting apartment, wall apartment, with Ms. Boone and Mr. Torres, is that correct?
Yes.
And he's the one who told you about the loud noise, is that correct?
Yes.
Okay. Did you interview anyone else in reference to that loud noise?
So I was interviewing Brandon, and then my partner was interviewing Vincent, the other witness, and I came in at the end of the interview with Detective Lowen.
Okay, so that's Vincent. Do you know his last name?
I would butcher it.
Me too, but Tagalog, something like that. We're talking about the same person?
Yes, sir.
Okay. And did that interview take place on February the 27th of 2020?
I believe so. I interviewed witnesses after I interviewed Sarah. The 26th or 27th would be my memory.
Okay, thank you. And then, did he also talk to you about a loud noise?
I believe that I was refreshed on the conversation, and yes, he expressed hearing a loud noise as well.
Okay, thank you. Now, and those interviews were actually audio recorded too, is that correct?
Yes, they were.
Now, let's go to Ms. Boone's interview. And that would have took place on the 25th, is that correct?
Yes.
Okay. And Ms. Boone came down. And, ma'am, prior to Ms. Boone coming down for the interview, had y'all made the decision that Ms. Boone was going to be arrested?
Yes, I plan to arrest Sarah Boone.
Okay. Did you tell Ms. Boone in a range?
So here it comes. before the interview, had you decided to arrest Miss Boone? Sure, I did. He's about to try to convince the jury that it was somehow improper for the police department to conduct the interview, knowing that they were going to arrest her without first telling her they were going to arrest her, regardless of what she said in the interview. That's got to be where he's going with this. And yeah, that does not comport with the law. The police can ask you whatever they want, whenever they want, until you say, I am invoking my right to remain silent. Where's my attorney? So yeah, I don't know what. At some point, the state is going to have to, tell the jury, is likely going to have to tell the jury that the police can basically lie to you. And until you invoke your right to counsel, you're pretty much stuck with whatever you say. So unless this detective gets through that in this testimony, the state's going to have to address that on redirect. So let's see what happens.
Changing the meeting that when she came down there, she was going to be arrested.
Your Honor, I'm going to object this for relevance.
Approach.
I don't think I'm going to sustain that objection. So what we're witnessing is the trickery defense. The police tricked me into saying all that stuff I said in the interview. And I wouldn't have said all that stuff if they had just told me that they were going to arrest me. I don't think the trickery defense works.
So, ma'am, at that time, you did not tell Ms. Boone, prior to coming down there, that she was going to be arrested. Is that correct?
No, I did not.
Okay. Why did you not tell Ms. Boone that she was going to be arrested?
We planned to meet at 3 p.m. and go over the autopsy and have another interview. So, I mean, I'm not sure why I would tell her that she's going to be arrested. That would potentially cause her to flee, not come, and then we have to go find her and make it more difficult for everyone.
Or potentially get an attorney to come with her?
She was read her rights that said that she has a right to an attorney, and if one cannot be provided for her, she will be appointed one.
I understand that. You read her those rights when she got there. Is that correct?
Yes, I did.
You didn't read those rights to her before she got there, though, did she?
I wasn't in contact with her, like physical contact with her.
Okay. So, but you said potentially for fleeing. My question was, potentially she could have got an attorney too to come with her. Is that not correct?
I misunderstood your question. I didn't hear potentially bring an attorney with her, but yes, I guess she potentially brought an attorney with her.
So Ms. Boone shows up, and you tell her there's some things that we need to talk about. Is that correct?
Specific verbiage, I know I said something along the lines of, obviously the autopsy had been conducted, and there were things that we needed to talk about in regards to that.
And prior to discussing it with her and asking her questions, you did read her Miranda warnings. Is that correct?
Prior to, I'm sorry, one more time?
Before you started asking her questions, though, in this interview, before you started asking Ms. Boone's questions, you read her Miranda warnings. Is that correct?
Yes, before I started asking any sort of potentially incriminating questions, she was read her Miranda warnings, yes.
Okay. Ma'am, do you remember, as part of the Miranda warnings that you read to Ms. Boone, did you read her the one that states that if you decide to answer questions but want to stop answering and consult with an attorney, you may do so. Do you independently remember reading Ms. Boone that instruction?
I don't recall that specific, but I do have my Miranda card on me, but
All right. So, what does Miranda require? So, every jurisdiction has different Miranda cards. Well, I don't want to say every. There are a lot of Miranda cards that police officers are given, and they vary by jurisdiction. There may be some that are the same, but with respect to Miranda, it's based on a case called Miranda v. Arizona. Miranda v. Arizona is a Supreme Court case in which basically the defendant said she was not informed that she had these rights, these constitutional rights, and therefore she did not knowingly waive those rights when she was being interviewed by the police. So the Supreme Court said, yeah, that's a problem. So I figured this was going to come up. So I pulled up Miranda v. Arizona, and the court in Miranda v. Arizona held this. Prior to any questioning, the person must be warned that he has a right to remain silent, that any statement he does make may be used as evidence against him, and that he has a right to the presence of an attorney, either retained or appointed, period. Those are the three things that the defendant has to be, or the witness has to be told before the questioning begins. Otherwise, the statements that they make are subject to being thrown out. Now, what this attorney is asking is something a little different. Let's go back to what his question is.
I don't recall that that's what.
To Ms. Boone, read her
One more time.
Okay, but prior to discussing it with her and asking her questions, you did read her Miranda warnings, is that correct?
Prior to, I'm sorry, one more time.
Before you started asking her questions, though, in this interview, before you started asking Ms. Boone's questions, you read her Miranda warnings, is that correct?
Yes, before I started asking any sort of potentially incriminating questions, she was read her Miranda warnings, yes.
Okay. Ma'am, do you remember, as part of the Miranda warnings that you read to Ms. Boone, did you read her the one that states that if you decide to answer questions but want to stop answering and consult with an attorney, you may do so? Do you independently remember reading Ms. Boone that instruction?
Now, the question he's asking is, do you have any independent recollection that you read her the warning that states that if she begins answering questions but wants to stop at some point and then consult an attorney, that she has a right to do so? Again, there's only three things that Miranda v. Arizona requires. Anything else that's on anybody's Miranda card is superfluous. It's added language. It's to add potential extra protections to the witness that are not necessarily required by the case law. So one of the reasons that those additional things are added, or that states and jurisdictions vary with respect to what's on the Miranda card that each officer is given, is because there's another sentence that follows that first sentence that I read, and it says, the defendant may waive effectuation of these rights, provided the waiver is made voluntarily, knowingly, and intelligently. So in order to bring about that waiver, now that waiver doesn't have to be read to them. It is a totality of the circumstances thing. So a lot of jurisdictions will have additional Miranda warnings regarding the waiver, specifically regarding the waiver, but it's not required because it's based on a totality of the circumstances. And to avoid any questions later on about whether there was a knowing waiver, they include those waiver things. So there are additional things. Essentially what this defense attorney is saying There are additional things over and above what Miranda v. Arizona requires that are included on your Miranda card. Did you read those additional things? And it seems as if he's trying to get the entire interview kicked because of failure of the officer to read the Miranda rights correctly. But under Miranda v. Arizona, that likely didn't happen. In fact, we all heard her read the Miranda rights, and she gave off each of those three requirements. Now, whether or not there was a knowing waiver, that's up to the judge. The judge gets to determine, was the waiver knowing? And he's already determined that it was a knowing waiver. He's allowing this case to proceed. He's allowing the evidence to come in. He's allowed the interview to come in. So all of this is likely for the appeal, and it's probably a losing argument. The 11th Circuit if the 11th Circuit ever gets a hold of this, first they'd have to get past the state appellate court, and then they'd raise a constitutional argument, and that might get up to the Supreme. Nobody's going to believe any of this. That she did not make a knowing waiver of her rights based on what we heard in that interview yesterday. So just to correct, the 11th Circuit wouldn't hear this case, but the appellate court that would hear the appeal in this case would rely on 11th Circuit precedent because that's the federal jurisdiction that we're in here in Florida.
Those Miranda warnings.
Your Honor, I'm going to object as to relevance.
Approach.
Apologies, I forgot to put the
Now, ma'am, at that point in
court
time,
back on on you all's screen. I've been watching it on my own.
Ms.
my
Boone
apologies.
wasn't under arrest. Is that correct?
Ms. Boone was not going to be free to leave once she was in my custody.
At that point in time, had you told Ms. Boone that she was not free to leave?
No, I did not.
At that point in time, had you told Ms. Boone that she was under arrest?
I told her at the end of the interview.
Okay, before the interview.
No, I did not tell her before the interview.
Ma'am, why didn't you tell her before the interview?
Your Honor, I'm going to object as to asked and answered.
Overruled.
So I have to read her Miranda warnings, and that's what I did. I do not have to tell her that she's under arrest at that time.
Was there a reason, could you have told her that she was under arrest before reading her Miranda warning?
Your Honor, I'm going to object as it calls for speculation.
Sustained.
Ma'am, was it a strategic decision not to tell Ms. Boone that she was under arrest prior to reading her those Miranda warnings?
Your Honor, I'm going to object as to relevance.
Approach.
Whether or not it was a strategic decision on the part of the police is probably not relevant. But if I'm the judge, I probably let it go because it doesn't really matter one way or the other. And I want to give the defendant all the rights I possibly can in the trial. So if her defense team thinks it's relevant, just let it in.
Ma'am, and we were able to see the video of the interview. As a process of interviewing people such as Ms. Boone, or well, let me specifically, in the process of interviewing Ms. Boone, is law enforcement free to give information that might not be accurate or true during the interview process?
Are you asking if we're allowed to lie to her?
Yes.
Yes, to an extent.
Was that done at any time in this interview?
Did I lie to her? I don't recall lying to her, no.
May I confer, Judge?
Yes, sir.
Did you all hear any lies yesterday in the interview? I don't remember hearing any outright lies by the investigators.
Thank you, ma'am. I have no further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released? State.
We have her subject to recall.
Okay.
Subject to recall.
All right, ma'am, be released subject to recall. Thank you.
Great, thank you.
All right, so
State, any
what
other
did they get out of
witnesses,
this?
evidence or testimony to be produced?
Your Honor, at this time, the state would rest.
Okay. Members of the jury, it is 10:22 a.m. I have some matters with counsel that I need to address, so we're going to excuse you for a short while. It's a great opportunity for us to take our morning break as well. Similar instruction that I've given to you over the last couple of days. Please do not discuss this case amongst yourselves or anyone else. Do not conduct any independent research or investigation as the person, places, things, or charge involved in this case. We'll bring you back in as promptly as possible. Thank you.
Jury exiting.
I don't think the state, I'm sorry, the defense team got anything really great out of that cross-examination. I don't think they got anything helpful out of that cross-examination. We should be going into motion practice at this point.
Okay.
If we do that, because it may be fairly lengthy.
Agreed. Let's go ahead and take that break. Court's going to be in recess for 10 minutes, and then we'll pick up any motion practice
All right,
at that point in
so-
time. Court's going to be off the record. Thank you.
There's going to be some motion practice, but we have a brief break. And we're going to pretend like we don't have any spoilers. And we're going to listen to this motion. Let's see where we are. All right, the court should be picking back up here in a second. Jeffrey says, heard lie after lie after lie from the defendant, not law enforcement. He said defendant showed up to the interview with a list of questions, so she waved right. No, the defendant showed up to the interview and talked, so she waved. Just be quiet. Don't say nothing.
Yes, sir.
All right, here we go.
The defense would move for a judgment acquittal. I'm going to start with just a real quick couple of comments, Your Honor. We know that JOA motions have become essentially pro forma, which may be why I've been assigned this responsibility today. But in this instance, I want to make an argument that I think has some merit. I've been paying close attention to the testimony in this case, and I want to point a couple things out. First of all, we know that the court has essentially has assumed the role and is assigned the role of becoming a gatekeeper in this matter. We know from the testimony that's been presented in this matter that not only did law enforcement, but also the Office of the State Attorney had knowledge of these parties prior to the event having occurred. And despite that, the state has proceeded with this prosecution based upon criminal information as opposed to having taken it to the grand jury. That kind of places the court in a special position to evaluate the nature of the evidence that's been presented. I want to focus on the second-degree murder allegation. And one thing that occurred to me while watching the evidence as it was presented, watching videos, particularly of the interrogation, was part of the dialogue between Ms. Boone as well as Detective Scott Lowen at the end of the interrogation. And I'm going to paraphrase. I apologize. I should have written this down verbatim. I did not. But she's advised that she is being placed under arrest. Something to that effect. And her response is, "Why are you doing this?" The detective's response to Ms. Boone is, "Because George is dead."
I'm sorry.
Because George is dead. That's not enough. It's not enough to support.
All right, so right off the bat, he basically says, look, the only reason we're here is because George is dead, but that's just not enough. Is that really all we have? All we have is the fact that the decedent is dead? There's nothing else. Nothing else has come out during this trial. Just the fact that George is dead. That is a preposterous argument.
A second-degree murder, prosecution, conviction, or should it even be enough to allow this matter to go to the jury? Now, there are three elements of the second-degree murder information. The first is that the victim is dead, that Mr. Torres is dead. We stipulated to his identity. There has been no argument to the fact or the idea that he died in this incident. However, the state also has to show that it was caused by a criminal act and that the act was imminently dangerous and demonstrated a depraved mind. Now, the fact that it was imminently dangerous, I think, is belied by the fact that Jorge Torres voluntarily entered the suitcase, albeit under the influence of alcohol. But the perception of dangerousness that's attributable to the victim, apparently he did not perceive it to be a dangerous.
Again, another totally off base argument. It's not inherently dangerous because he got in the suitcase. He didn't zip himself up in the suitcase. She did. She told the cops that. That's what we have seen. She zipped him up in the suitcase. At the moment that it gets zipped up, now it's inherently dangerous. It's not dangerous to be inside of a suitcase that's open.
Or an imminently dangerous situation in having entered the suitcase, possibly because of the influence of alcohol on his capacity to make decisions, should necessarily be attributed to the defendant as well. But I also want to focus on the depravity issue, which the state must prove, and pursuant to the jury instruction in this matter, depravity is equivocated, is made the equivalent of ill will, hatred, spite, or evil intent. And that's not enough. Not only does the state have to show depravity, but it has to show, because it's in the conjunctive, that the act demonstrates an indifference to human life. The state has presented testimony, an argument in this matter, not argument, but testimony that in fact George Torres was suffering. Suffering does not equal hatred. It does not equal ill will. And even if they were to establish negligence, that's not homicidal. We know.
Really, the only indicia of hatred that he's saying we were presented with, or ill will that we were presented with, or spite that we were presented with, or evil intent that we were presented with, was his suffering. That is not an accurate representation of the facts that we have seen up to this point. We saw the video. We saw him inside the suitcase begging for his life. That is suffering. But we also saw her responses to him begging for his life when she was cursing at him, when she was saying that he deserved this, when she was saying that she was getting back at him for what he had done to her. That is where we learned of the ill will, the hatred, the spite, and the evil intent, not just his suffering.
That suffering is something that the courts have been very, very cognizant of and very sensitive to. We know it from the field of capital punishment and incarceration. The idea that somebody suffers is not in and of itself homicidal, nor should it support the idea that there was indifference to the life of George Torres by Sarah Boone. Was she angry? I think there's clear evidence that she was angry. But that's not hatred. And that's the element that has to be proven here. And I don't think that there is prima facie case that, in fact, she demonstrated hatred so much as she demonstrated anger. Doesn't establish a prima facie case of second-degree murder. It's for those reasons, Your Honor, that I think that this matter should be, the motion for a JOA as to second-degree murder should be granted, and this matter should be allowed to proceed solely on a manslaughter charge because, in fact, they have not established prima facie elements as required by law. Thank you, Your Honor.
Thank you. Response.
Yes, thank you. Standard at this time is just a prima facie case. Whether any trier of fact, in taking all the facts in the light most favorable to the state and the inferences drawn from them, establish the.
So the judge has to give the state the benefit of the doubt at this point. The defense does not get the benefit of the doubt. So if there's any possible way that any possible jury could, in any way possible, decide that they have proven the elements of their case, this motion goes nowhere.
Elements of the crime. There are 3 elements to this crime. George Torres is dead has been established by a prima facie case. The death was caused by the criminal act of Sarah Boone that has been established. There was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. It's not Ms. Boone's subjective statements on February 25th. I had no idea you could die from being zipped into a suitcase for 13, 15 minutes before she goes to bed. 2, is done from ill will, hatred, spite, or an evil intent. We heard what she said. The 2-minute video starting at 11:12 p.m., 45 seconds, should be linked in Merriam-Webster's digital dictionary for the definition of depraved mind. Fuck you, I don't care, laughing is of such a nature that the act itself indicates an indifference to human life. Sarah, that's my name, don't wear it out. Judge, there's no question that a prima facie case has been laid. In addition to the 2-minute video and then the 22-second video 11 minutes later, we also have the defendant's inconsistent statements that she has made in regards to these events, and therefore we have that factual issue for the jury to decide. She made statements on the 911 call and to law enforcement both on the 24th and 25th that I have no idea what happened. I just went to sleep, everything was good, and then when confronted with her video on the 25th, we see that there are 2 distinctly different sets of statements that were made. So this is sufficient at this stage in time for a jury question. Thank you.
Thank you. Any other additional argument, Mr. Beck?
No, Your Honor.
All right, thank you. Thank you both for your arguments. The court, in viewing the light most favorable to the state, the court finds that the state has presented competent but rebuttal evidence to establish each of the elements of the charge contained in the information to the required level of a prima facie showing. As such, the defense's motion for a judgment of acquittal is denied. Defense, do you intend on putting on a case?
Yes.
Ms. Boone, I have a couple of questions to go over with you.
So if I may.
Yes, sir.
In a normal criminal trial, my position has always been to put on the defendant last. Call whatever witnesses, put on the photographs, and then the client would be the last person to testify. Because of the nature of this charge and our defense, self-defense and battered spouse, we understand that we have to put on her first, Sarah first, in court to then consider whether or not we've established enough evidence for self-defense instruction. So she's going to have to be going first as the witness. I'm going to need a few moments with her based on everything that's going on and based on that denial of that motion for judgment of acquittal to just go through it again because I know you're going to ask a colloquy about all that. So I'm going to need a few moments with her. I don't know if it's 10 minutes maybe for the 3 lawyers, 4 lawyers to meet with her. I don't know if we can do it here or maybe back there, but just a short meeting.
Sure, I'll give you that opportunity, but before you do that, ma'am, I don't want to go into any specifics of any conversations that you've had with any of your attorneys in this case. Mr. Owens has identified for the court his normal practice of calling a defendant last in a criminal case. In this case, he has advised that he wants to call you first. without going into any discussions of any strategy that you've had with your attorneys, do you understand the strategy that Mr. Owens and your team will be utilizing in your defense?
Yes.
And are you in agreement with that strategy?
Yes.
All right. Counselor, you can have that opportunity to speak to her. The court will remain here. I don't know if they can, Officer Jones, can we let them back to have that conversation? Okay. All right. You can go back and have that conversation. The court will remain here. We'll be in a short recess for approximately 10 minutes. Thank you.
All right. So the defense attorney is saying, look, I would normally call her last, but we have this issue of her having this battered spouse defense, and I'm not allowed to present other witnesses that would testify regarding the battered spouse defense unless and until there's essentially a prima facie showing by the defendant herself that the battered spouse defense actually will appear on the jury verdict form. So I got to call her first. And so they're about to go out and likely discuss whether or not they want to continue with the battered spouse defense. And if they do, they're probably going to discuss the testimony that she's going to be offering and kind of what she can expect from the state regarding that testimony. Tread, I hope you're watching us on your television, but it's great having you here. I'm going to miss you in the chat. Let's fast forward through this short break and get right back into it.
We're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State, appearances for the record.
Dave Kester on behalf of the state.
William J. for the state.
Defense?
James Owens from Ms. Boone.
County Henderson from Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same black blazer and dark blue blouse from this morning. She is in custody, however, not wearing any restraints, so she'll be able to stand when our jury enters, and if she is called to testify in this matter, she will be able to walk to the witness stand. Ms. Boone, I have a couple of questions to go over with you. Similarly to our conversations earlier today, I don't want to know about any of the substance of any conversations you've had with your attorneys, just whether or not you've had certain conversations. So far, you've been present throughout the entire trial process. You've been seated at counsel's table. You've had the opportunity to observe the evidence presented by the state, as well as the direct and cross-examination of the state's witnesses. Are you satisfied with your attorney up until this point?
Yes.
Now, I'm going to ask you some questions again about specific conferences and conversations you have with your attorneys. I don't want to know those specifics, just whether or not those things have been had. Have you had the opportunity to discuss with your attorneys whether or not you would like to testify as a witness in this case?
Yes.
Do you need any additional time to discuss that matter with your attorneys?
No.
Have your attorneys discussed with you the potential benefits and potential harms of testifying as a witness in this case?
Yes.
Are you satisfied with the advice from your counsels?
Yes.
Do you understand that attorneys can make most of the decisions about trial strategy? They cannot determine whether or not a defendant testifies or not. Do you understand that?
Yes.
Not even the court can interfere with the defendant's right to make that decision. Do you understand that?
Yes.
Do you understand that it is your decision and your decision alone?
Yes.
While counsel can give you advice on whether or not it would be wise for you to testify in this case, do you understand that you can ignore counsel's advice because the final decision is yours?
Yes.
Do you understand that you have the right to remain silent?
Yes.
Did you hear me explain to the jury at the beginning of the trial how the right to remain silent is absolute, and the fact that a defendant did not testify cannot be considered as evidence of guilt or influence their verdict in any way?
Yes.
Before a jury begins its deliberations, the court will read another jury instruction if you decide not to testify. This instruction orders the jury not to consider your silence as evidence of guilt or to consider your decision at all. Would you like me to read that instruction for you at this time?
Yes.
It is instruction 3.9a, entitled Defendant Not Testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Do you have any questions about this instruction?
No, Your Honor.
Do you understand that if you choose to testify, you are waiving your right to remain silent?
Yes.
That means once you begin to answer questions, you have to answer all questions unless I instruct you not to answer a question. Do you understand that?
Yes.
You cannot pick and choose which questions you want to answer and not answer. Do you understand that?
Yes.
Do you understand that if you refuse to answer any questions, the court can impose sanctions, such as holding you in contempt, striking your entire testimony, and instructing the jury not to consider any of your testimony? Do you understand that?
Yes.
If you choose to testify, you will also be subject to cross-examination and impeachment. That means the state could ask you about any prior felony convictions or convictions for crimes of dishonesty if you have any such convictions. If you have any such convictions, the questions will be limited to whether you have such convictions and the number of same. Do you understand that?
Yes.
Are you aware if you have any such convictions?
Yes.
State? Are you aware of any felony convictions or convictions for crimes of dishonesty?
No, I believe she's answering an affirmative. She's aware that she doesn't.
Okay, so you have no such convictions. Okay, thank you for that clarifications, ma'am. As there are no convictions, and that number is not in dispute, the state will not be permitted to inquire into those matters. Have you had enough time to discuss your decision to testify or not testify with your attorneys?
Yes.
Again, do you need any additional time?
No.
Has anyone forced you, threatened you to get you to testify or not testify in this case?
No.
Has anyone made any promises to you to get you to testify or not testify in this case?
No.
Are you satisfied with your counsel's advice so far in this case?
Yes.
Are you making this decision freely and voluntarily?
I am.
Did anyone force you, threaten you, or coerce you to testify in this case?
No.
Would you like to testify or not testify as a witness in this case?
Testify.
Okay. And ma'am, similarly, after you've had the opportunity to converse with your lawyers again, I want to confirm that you're on board with the strategy that they've utilized in your defense in this case,
Yes, I understand.
including calling you first.
Yes.
Okay, all right. I want to remind you, ma'am, that you can change your mind. You just have to let your lawyers know before the jury comes back in. Do you understand?
Yes.
State, anything else we need to address?
Just that the law of the case is that there should be testimony from the defendant of an overt act that particular day before there is testimony about reputation evidence, prior instances of violence, or any of the ancillary things that come with self-defense.
Holland case speaks for itself. Anything further?
I do want to talk about that, but as it relates to her right to remain silent or testify, I have nothing about that.
Okay, then what do we need to address with regard to Holland?
Well, I've got three issues. One is Holland. The other is, I've got these gloves. My client and I would like to take a few moments to look at the suitcase and to look at that. And then the third thing is, that the state had filed that motion for the in-camera hearing. I don't know, maybe we need to hear that before she testifies?
Court's not going to address that at this time.
Okay.
We'll address that later in the proceedings.
So the two things, number one, of course, I've got a lot of photographs about the prior violence that Jorge Torres committed on Sarah Boone, and there's a dispute about whether or not I have to establish an overt act that she responded to, that she considered an imminent threat, and that she took evidence, or she took action to either block or physically restrain Jorge Torres from committing an act of violence on her. But Judge, if you'll remember, during the 2-hour interrogation, the officers make mention that they are aware of the prior incidences of violence. So I believe the door has been open, that I can go into that based on those statements by the two detectives. If you remember, they introduced this 2-hour video. She says, he comes at me all the time. I think eventually Sarah Boone realized that they had her phone and they were going to see pictures, they were going to see videotapes of evidence that Jorge Torres committed acts of violence on Sarah Boone. I think at that point she changed her tone about Jorge. She was trying to protect Jorge, but then she realized she would have to disclose some of the acts that had been committed on her by Jorge Torres, and so she did talk about him coming at me, and we've had issues before. And the officers gave, I can't remember exactly what they said, but yeah, we're well aware of, I don't know if they said the prior acts or we're aware of the domestic violence, whatever the case may be. I submit that opens the door. That was during their case in chief. They chose to play that entire video. And so I think I can talk about the prior bad acts before the event in question chronologically. And I've got a bunch of photographs that go into physical evidence of her injuries as a result of Jorge's George's violence.
Okay. Response, if any.
Judge, we're asking for the court to maintain its ruling. We already read an instruction that the police are allowed to tell her things to try and get reactions from her. She affirmatively denied there was an overt act that night to the police. And the court, in its ruling pre-trial, as we're trying to get some guidance on this, reviewed Ms. Boone's most recent statements on the matter, and there is no overt act thus testified to. So we are hopeful that we will maintain that ruling, and I don't know how it prejudices her or her team in any way to establish an overt act on February 23rd, 2020, before we go into reputation evidence, prior instances of violence, or matters of syndrome evidence.
Any other further argument, Mr. Owens? All right. I don't find that the officer's statements are character evidence, and you're looking for specific instances of conduct, which are going to be utilized for those specific purposes for reputation or violence to establish the fear component that the case law speaks about. Florida Supreme Court decision in Holland is clear that that overt act needs to be established before any of that evidence is submitted. I don't find that it's an opening of the door, and I'm going to rely on what the Florida Supreme Court has told us to do.
Judge, I've got to get the clerk to mark some photographs, and then my client and I need to take that suitcase out of that box and inspect it, play with the zipper a little bit, and then also take that bat out of that paper bag and inspect it before she testifies.
Any response?
I'm just confused why we haven't utilized the nearly half an hour or more that the court has been off the bench to get these photographs marked. The defense team has been on board for quite some time. They did not request a second evidence view of the physical evidence that Ms. Boone already had an opportunity to do while she was pro se. It's 11:25. We need to try the case.
Judge, I think that she had that evidence view, I think, with Billy Lane. I believe that was the day after I filed my notice of appearance, or maybe it was the day I filed my notice of appearance. I don't remember exactly, but it had already been previously scheduled. I was in Milton, so they went ahead and did it that morning, I believe at the jail. I believe the evidence,
Any particular reason why it hasn't been done in the last 45 minutes?
because
When I sent my jury out?
I've been meeting with my client about
Okay.
her rights to testify or not, and other related matters. So in terms of not giving her this evidence,
In terms of anything that the state just discussed?
I've just been busy with my client.
Okay. How much time do you need in order to pre-mark these exhibits and look at the baseball bat and the suitcase, which have been entered into evidence?
I would think 15 minutes.
I'm very concerned because it is 11:25 and I discharged our jury some time ago, and I don't want to be in a position where we have to break in the middle of testimony.
May I suggest that we just take an early lunch? It's 11:30. Let's take an early lunch. We've got witnesses coming this afternoon anyway. If her testimony ends before 5, we've got 1 or 2 witnesses that are here, and then I believe tomorrow is Wednesday. We've got Dr. Brannon that's going to be here first thing Wednesday morning, and then I believe Dr. Harper's not going to be here till Thursday morning. So we're going to have a little gap in time unless we've got to put on several officers about prior acts and all that. But I think for purposes of this, Judge, in the abundance of caution, I feel like I need to go over this evidence with my client before she testifies. And I have not had a chance to view that evidence, other than seeing it here today. But I think I need to do that with her before she testifies.
Okay, can the parties approach for a moment?
So I don't want to fast forward through this because this is all kind of good stuff, in my opinion. Kind of gives you a look behind the curtain, so to speak, as to what goes on between the attorneys and the court. Something that most people don't usually care about, but since you guys are here, you likely care about these things. So this is kind of what goes on for the 4 years leading up to trial. It's, us and the judge going back and forth, us and the other attorney going back and forth. We are both trying to convince the court of certain things, and the court eventually has to make a decision, a ruling on those things. And this is kind of your behind the scenes look. In civil cases, civil cases can go on for anywhere from 6 months to 16 years, or longer. And this is a lot of what is going on during that time. Those long cases are, I've never been on one that's, lasted more than, I want to say 5 years. But those longer cases, I can't even imagine having to go before a judge in those long cases, because the judge eventually gets sick of you. They want the case to end, and then you also run into the situation where the judge retires, or the judge doesn't get voted back into office, and you get switched to another judge because judges change positions. Some might get elevated to other courts. I hate it when judges get elevated to other courts in the middle of a case that is pending, and we essentially have to tell a new judge everything that's going on in the case, because this new judge has a docket that's entirely new to this judge and doesn't know any of the backstory regarding the cases. This judge, though, Jeffrey asked what my opinion of this judge is. This judge is excellent. I kind of alluded to that yesterday when I was talking about the people that were sitting behind him. Those are students, and for years this judge has been mentoring students at I believe Barry University up there in Orlando. So Barry is at one of the universities in Orlando. There's also Florida A&M University's College of Law. I don't think he does anything with them. They're fairly new to the scene. Florida A&M has only had a law school, I want to say, for the past roughly 15 or so years. They had a law school long prior to that. So you will meet older attorneys who graduated from Florida A&M University Law School. They then, their law school was then closed by the state just before Florida State got its law school. And then Florida A&M University got approved for a law school, I want to say roughly 15 years ago, but I could be wrong on that. And that's also in Orlando, not in Tallahassee. But I believe he does stuff with Barry University. And they keep going back to him. How do you get the new judge up to speed in those instances? So Jeffrey wants to know, how do you get the new judge up to speed in those instances? So essentially, we have to we don't relitigate old matters, but we'll have a motion that kind of relies on what the court has ruled previously in these other motions that have gone before the prior judge. And we kind of have to go through each of those motions. So what would have been a 15-minute motion hearing before the prior judge ends up being a 30 to 45-minute motion hearing before the new judge, because we have to inform the court as to what has happened up to this point. Not only do we have to inform them of the facts of the case, so very early in the first couple of hearings before the new judge, we'll have to essentially inform the judge of the facts of the case, but we'll also have to piece together the prior rulings for the judge. We can't expect the judge to go through the entire docket for every one of the 1,000 cases that have just been dumped on the judge's lap. So we kind of have to, give a summary of the facts, and we also have to give a summary of all the rulings that have led to where we are here today. The worst bits are when we are asking the judge to essentially undo a prior ruling by the prior judge. Judges are very hesitant to do that because they weren't there for those initial hearings. But a judge, as long as a case is before a judge, that judge can undo anything that an appellate court has not already ruled on. When the judge changes mid-case, that new judge still retains the authority, the authority to undo what the prior judge did. So depending on the demeanor of the judge, depending on how we feel the judge might rule in certain instances that is different from the prior judge, attorneys will use it to try to take tactical advantage of this new judge and the new judge presiding over the case to kind of undo what a prior judge has done. Discovery issues are usually something that we'll try to get relitigated. But judges are typically hesitant to undo what the prior judge has done.
It is 11:35. Councils have matters that they need to address with Madam Clerk for the pre-marking of exhibits and along with the review of the suitcase and back, which were previously entered into evidence. I'm going to bring based on the agreement of the parties, I'm going to bring our jury panel in at this time, release them for lunch, give them a similar instruction to the instructions they've been provided earlier, and we will commence promptly at 1 o'clock this afternoon. State, any disagreement with the battle plan so far?
No, sir.
Same question, Mr. Owens.
No, sir.
All right, let's go ahead and stand by, bring back in
All
the
right.
panel.
So they're going to bring the panel back in, break for lunch. I'm going to take a comfort break. I'm going to leave this playing on screen while I do that. And then we'll fast forward through. They are breaking until 1 p.m. So once we get back, we should be about 15 or so minutes behind, maybe 20 minutes behind. So we'll pretty much be caught up with the court. So give me a couple minutes and I'll be right back and I'll leave this playing.
Jury entering.
State, do you recognize our jury?
Yes, sir.
Defense, do you recognize our jury?
Yes.
I thank you all can be seated. Members of the jury, again, once you're seated and comfortable, if you could raise your hands to confirm that you complied with the court's instructions. All right, thank you very much. Thank you for your patience. Matters with counsel took a little bit longer than we anticipated. We're going to take an earlier break today. It's 11:35. We anticipate the defense putting on a case this afternoon, and we don't want to get into it and then have to break a half an hour into it. So we're going to go ahead and take that break at this time. I'm going to give you a similar instruction as I've read to you over the last couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your time and your service and your attentiveness, and we'll see you at 1 o'clock this afternoon. Thank you.
Jury exiting.
Y'all may be seated. Thank you. State and the defense, if you could please review those items, and please mark every defense exhibit at this time with Madam Clerk, and I will see you all to
All right,
commence promptly
I'm back.
at 1 p.m. Court's in recess. Thank you.
Let's get this thing fast forwarded and get back to the case. I'm ready to hear from Sarah Boone. How about you guys? Let's see what she says that's different than what she said previously. I'm going to try to get it right up to where they're talking. So as not to burden you guys with extraneous stuff. So, Miss Carol, I don't think this is a a crap show like the YSL trial. In that trial, the prosecution is. I haven't watched much of it, but the prosecution just does not seem to have its stuff together. And I believe recently they just brought in another attorney to argue some motions, and that attorney seems to know what he's talking about. And it's like they brought in somebody new to kind of give everybody a fresh take and try to get the judge to believe the state. The judge is making some rulings that are siding with the state that I don't necessarily agree with, but at least the last attorney they brought in seems a little bit more credible, a little more on top of his game. But that whole thing is just, I mean, it's bad. I can't sit down and watch the YSL trial, which is why I'm not covering. I can't take much of it. I think both sides are very professional. I think the state has its ducks in a row here, and I think the defense is probably doing the best job with what it has. It just doesn't have anything to work with. So yeah, but let's get back to the trial. They're about to start talking here, so let's get back to it.
State of Florida versus Sarah Boone. Let me get appearances for the state.
Dave Castro on behalf of the state. William J. for the state.
Defense.
James Owens for Ms. Boone.
Connie Henderson from Ms. Boone.
Ms. Boone is seated at counsel's table, wearing the same black jacket and blue blouse from this morning. We will be standing when our jury enters. She is in custody, but out of any
We're about 17 minutes behind.
restraints. As she is testifying first, once we bring in our jury, she will walk to the jury box and be sworn in front of the jury. State, are we ready to bring in our panel?
Yes, Your Honor, I was able to get the redactions done. I put a disc on Mr. Owens' notebook there, has the case number on it and 3 black dots in Sharpie, just so that a random way of saying what it is.
Excellent, appreciate it. Thank you for getting that done over the lunch hour. Defense, are we ready to bring in our jury?
I've got a couple of issues.
Yes.
Number one, Kevin Beck is working laundry.
Let the record reflect that Mr. Beck has appeared.
For the record, I'd like to make 2 points about this issue, about whether or not I can bring in evidence of prior acts, prior bad acts, prior to the overt act. And there's 2 reasons that I believe I should be allowed to do so. One is,
All right, so he's about to argue essentially the same thing he was arguing before. So that tells me he probably took some of the time during that break to look at some case law and try to shore up his arguments. So let's see if he has anything new to say here.
Judge, in that 2-minute video, Sarah Boone makes a statement, "That's how I feel when you choke me." And then some moments later, "That's how I feel when you cheat on me." And she's angry at him, and she's talking to him. She's talking to him in an intoxicated state, and she's expressing her anger and why she is angry. And I ought to be able to elaborate on what that is that she's angry about as it relates to when you choke me. That's my first motion.
Okay.
The second one is, Judge, on this.
Before you proceed with the second, is the second intertwined with the first?
No, I mean, it's a similar argument, but related to something else.
Okay, response.
Judge, I don't disagree that they should be able to bring that in once they've established an overt act that is imminently dangerous to an objectively reasonable person. I believe that's the law in our home.
Any other further arguments, sir?
Not on that issue.
Motion's denied. Court again is going to rely on the Supreme Court's guidance in these situations based on Holland 916-72750 at 1.760 through 761.
My second argument ties into what he just said about what a reasonable person would do under the circumstances facing an imminent threat, whether a reasonable person would perceive the overt act on the part of Jorge Torres that was witnessed by Sarah Boone. Would that be perceived by someone as a imminent threat? And to some degree, you have to understand the history of Jorge Torres and Sarah Boone. They were together 3.5 years. They were engaged, but there had been a history of violence. And from the evidence that's been presented, facing the circumstances in total, if you take what she said at various times, you would understand that she became concerned when he came back from Publix with that second bottle of wine, because she knew when Jorge Torres gets to a certain level of intoxication, he gets sad, he gets moody, and eventually he gets belligerent, and sometimes he can be violent. So she knew when he brought home that second bottle of wine that it was not going to be a good night. And she tried to keep him occupied and tried to keep his mind off of his troubles, because she knew that if he reaches a certain level and is dwelling on his hardships, that he will react to her in a violent way. So she had that state of mind with that understanding of her history and his history in his overt act, which she's going to testify to, coupled with the fact of her state of mind based on her past experiences with him in that intoxicated state and the fact that he is violent. So she was hypersensitive to danger and fear. And I think that ought to be allowed in as part of her collectively an overt act. So it was culminated by his state of intoxication coupled with his overt act created the well-founded fear for her to block the attack, to self-restrain or physically.
So he just said, coupled with the overt act that created the well-founded fear. And the state is just saying, you have to prove that there was an overt act first. So what's this overt act? Show us what the overt act is and then bring all this other stuff in. Without the overt act, none of this other stuff matters, because without the battered spouse defense, all that other stuff about her having been battered in the past is irrelevant to your defense in this matter. The only way that that becomes relevant, potentially relevant, is if you can have the battered spouse defense. And in order to have the battered spouse defense, there has to be the overt act. And the judge keeps relying on Florida Supreme Court case law to essentially say you have to prove that there was this overt act that occurred at or immediately prior to her taking whatever action she did in defense of her person.
Physically restrain Jorge Torres in the suitcase, to actually use the bat to prevent him from getting out of the suitcase, because she knew she was going to get attacked.
And the basis of the opinion of about to be attacked is predicated on the prior incidences of violence, correct? Based on
Well, there's an overt
knowledge.
act committed by Jorge Torres, but she was heightened because she knows when he gets to that level of intoxication in that scenario, and that's an issue.
So I need clarification. What is it that you're asking me to do?
For me to be able to elicit from Sarah Boone that she was concerned once that second bottle was brought, and that's why she tried to placate him over the course of the evening, and that's why she had a heightened sense that he was capable, Judge, due to his degree of intoxication, that he may act violently towards her. And a lot of the problem is, Judge, he doesn't remember battering her the next day. That's part of the reason that she videotapes him and photographs him. She starts to document what happens so that she can show him. She loves the man. She adores the man. She wants to marry him. She wants a life with him. But she's tired of being beat on, and so that all ties into her behavior, her sense of nervousness at that point. The reason she was so confident during that 2-minute video is because she knew, okay, this is my chance. He can't get to me. I can tell him exactly what he does that bothers me, that hurts me, and how I feel. And so that's all tied together with then he starts to try to get out of the suitcase, and she reacts the way she does.
Response.
We held these arguments already. The court has ruled. There are no new arguments being made. The court understands exactly what Sarah Boone, the defendant, said to Dr. Werner on October 2nd. The court knows exactly what the defendant said to Dr. Harper over the period of a number of months and years, and there was no overt act. The overt act has to be something that is objectively reasonable to cause a reasonable person to believe there's an imminent fear of great bodily harm or death. What the testimony is not that that's what has occurred, that there's, her new testimony is this generalized fear, but you've already read that and you've already ruled on that. And I'll just remind the court that her previous testimony is, it's all fun and games, we're laughing, I zipped the suitcase shut, we're still both laughing, it's funny, and then the decedent says, I can't breathe, and then she flips a switch, gets angry because it reminds her of all the times before where she is asserting that the decedent made her feel like she couldn't breathe, And then that's when she starts beating and shuffling the suitcase so much that it flips over and hitting him with the bat. We've covered this ground. Aggravated assault, aggravated battery, 2 independent forcible felonies. She's committing false imprisonment. She is the initial aggressor after there being no overt act. She can't start it and then say, well, I'm in fear of retaliation, because that's what her testimony was, is once I started doing these things, once I wouldn't let him out of the suitcase, I was afraid he would come out and harm me or kill me. Well, Judge, if I pull a gun on you and I say, give me everything you own on you right now, and then you in turn pull a gun on me and say, bam, 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 and shoot and kill me, and I shoot, let me strike that, you pull a gun on me to defend yourself, and then I shoot and kill you, I can't assert self-defense. I can't say, well, Judge Kranick pulled a gun on me and I was in fear of death, because I was the initial aggressor, I was committing a forcible felony. That's the facts of this case here, according to her previous testimony. And the state concedes if she wants to change her testimony again, that's one thing, and then we'll cross that bridge when we get there. But if she testifies as she previously has, the court has already ruled there's no overt act, and you've read the transcripts, you know what she has said.
Judge, she hasn't testified.
So look, just to explain what he's saying, look, Sarah Boone zipped up this suitcase. And once she zipped up the suitcase and she starts taunting him, at that point, she then fears for her life because the taunting has occurred. And she's afraid that if she lets him out of the suitcase, he's now going to commit violence against her. But you can't put somebody in a position that makes them then want to commit violence toward you and then say, well, because I put them in that position where they want to commit violence, now I'm justified in using violence against them. No, it doesn't work that way. There has to be an initial act before you begin committing the violence, and the violence occurred as soon as she zipped him up in the suitcase. She restrained him prior to some overt act on his part, and the defense is saying no, the restraint, keeping the restraint in place was essentially the in response to her prior bad acts of Jorge Torres. So you can't use those prior bad acts unless there was some overt act by Jorge Torres before you restrained him. Show us the overt act, then you can use that stuff. So essentially the state wants her to get on the stand and start changing what she has said, because that's helpful to them. If she doesn't get on the stand and start changing what she has previously said, that's helpful to them. So essentially the state has anything she says on this stand is going to be helpful to our case. So let her take the stand, and whichever way she goes, we'll deal with it at that point. But if we're going to deal with it one way, she has to prove this overt act and essentially change her statements. If we're going to deal with it the other way, she has to stick to her prior testimony, and we'll deal with that. So they get to have their cake and eat it too, is essentially what they're saying here. And in this instance, they kind of do.
She hasn't testified. Dr. Harper's testified. Dr. Warner's testified.
They have not testified. They've given depositions.
Well, given depositions, but she hasn't testified about the act in question. She hasn't testified about the event in question. She had consultations and evaluations by Dr. Harper where they had discussions that Dr. Harper could relate in her testimony. Dr. Warner can say what was said during the evaluation. Again, both of those were not reported. There may be disputes. I disagree with his characterization of that assessment. But it's up to Sarah to tell the truth here today. She's under oath. She's under oath today. She's got an obligation to tell the truth. If he thinks she's made prior inconsistent statements, it's up to him to impeach her with those inconsistent statements.
To the extent that you are requesting permission to go into presumably and seemingly prior bad acts, vis-a-vis, he got the wine, and I know what happens when he gets it, and everything that follows from that, those are bad acts. That is character. And the Florida Supreme Court has provided guidance in circumstances, specifically in Holland, on what needs to be done. You're attempting to provide information that the defendant was apprehensive of the victim at the time of the homicide by virtue of the wine, etc., as you've proffered. That's bad character evidence that you're going to be bringing in. Historic bad character evidence. This is what happens when he drinks. This is what happens when I don't placate him. This is the situation that I find myself in, which inevitably may dovetail into prior incidents of abuse. That's all prohibited character under 404, 9404. And the carve out for that is if a overt act is established. It's not a subjective standard, it's an objective standard. The jury instruction, 3.6F, identifies it being an objective standard, and the Akendo case specifically tells us that it's an objective standard. In Akendo, the second DCA in 2020.
So you can kind of hear the judge's demeanor kind of changing here. He's like, I've gone over this with you multiple times at this point. Read the cases. I keep going over these cases with you. He's gone over these cases at least 3 times at this point. I keep going over this with you, and you keep arguing the same thing. That's not the law. What you're asking for is outside the bounds of the law. I am confined by Supreme Court precedent, and I'm ruling based on that precedent. I'm not going to change my ruling no matter how many different ways you say the same thing, unless you come to me with something new, some case law that we haven't discussed already that will change my ruling. I'm confined to this Supreme Court case law. Let me present it to you again.
23 stated, the conduct of a person acting in self-defense is measured by an objective standard, but the standard must be applied to the facts and circumstances as they appeared at the time of the altercation to the one acting in self-defense. I'm going to rely on Holland. Holland is the law of the land. It is what the Supreme Court has told us to utilize. That's what I will be relying on. The overt act has to be established.
Ms. Boone, do you understand that?
I do.
Okay. Anything else?
We cannot talk about any prior bad acts or anything of that nature until we talk about the actual event, the attack. Correct? You understand?
Do you understand that?
I do.
Okay. Anything else, State?
Okay.
Defense, anything else, sir?
All right. So if you heard Mr. Owens essentially, even though we didn't see it on camera, just turned to his client and said, do you understand that? So perhaps he's going through all of this again, just because the client is trying to get him to go a different way than what the way that the judge wants it is telling him he has to go. So that may be why we're hearing this over and over and over, because when they got out during lunch, the client said, no, but we got to get into these prior bad acts. And the attorney is saying, no, we can't get into the prior bad acts. And she said, no, but we have to. He said, no, we can't. The judge said we can't. And now he's going and making the judge say it again just to placate his client. That may be what's going on here.
All right, let's go ahead and stand and bring in our jury. State, do you recognize our jury?
Yes.
After seated and comfortable, hands have been raised. With that, State has rested.
Raise your right hand, please, sworn. Please, do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, ma'am, you can take a seat. And if you could, state and spell your name for the record for us.
Sarah Boone, 101077.
And could you spell your name?
SARAHBOONE.
All right, thank you very much. Sir, you may inquire.
Ms. Boone, would you please tell the jury where you were born and raised?
Atlanta, Georgia.
You were born in Atlanta?
I was born in Atlanta.
And how long did you stay in Atlanta before you moved here to Florida?
I was 3 years old, 3 or 4.
Okay. And from that time, y'all moved, you and your family, your mother and father, moved to Orlando?
And my grandparents.
Okay. Y'all all moved down from Atlanta down to Orlando?
Yes, and my 2 brothers.
Okay. And were you raised here essentially from that time on?
Yes,
And you resided here in Orange County, Florida that entire time?
yes.
Okay. And where did you go to high school here locally?
I did.
Where did you go to high school?
Edgewater.
Okay. And tell the jury, how old were you when you graduated?
I was 18 years old.
Now, I know you lost your mother and father.
Overruled.
I know you lost your mother and father in your teens and in your 20s. Is that true?
I lost my grandfather when I was a sophomore in high school, and I lost my father when I was a senior. And then my mother passed away a few years after that, and then my grandmother passed away after my mother died.
Or so you were in your 20s when all that was going on?
Yes.
Okay. And then at some point in your 20s, you met Brian Boone?
I did, yes.
All right, and how long did y'all date before you married?
A good handful of years. I helped my family with paying mortgage and bills for the house since my father had passed away and my grandfather, so
So you worked outside the home?
I did.
Okay. Can you tell the jury when, you said you and Brian Boone dated for a while, do you remember when y'all married?
I do.
Could you tell the jury when y'all were married?
The year?
Yeah.
Um,
You remember the date?
It happened to be, yes, that after my mother passed away, that he had waited to ask me to marry him because he knew it would be,
Objection, non-responsive.
Sustained.
Just answer the question if you can, Ms. Boone. Are you a little bit nervous?
a little bit.
Okay. Well, just tell the jury if you remember the date that you and Brian Boone married.
August 21st, 2004.
Okay. And had y'all lived with each other for a short time before that?
Short time.
Yes. Okay, after you married, how long was it before y'all had any children?
Gosh, 6 years?
Okay. And y'all have one son.
Yes.
What's his name?
Lucas.
And how old is Lucas now?
Lucas will be 14 years old on the 28th.
28th of this month?
Yes.
So you and Brian were married, and y'all lived in Orange County. How long were y'all married?
For 13 years.
All right, and y'all divorced?
Yes.
And as part of the divorce, were y'all to share custody of your son?
Yes.
And so y'all would split days, would that be fair to say?
Yes.
At some time after you and Brian split up, did you meet Jorge Torres?
Yes.
All right, could you tell the jury how you met Jorge Torres?
I met George when I decided to buck up, I guess, and was tired of trying to patch things up with my ex-husband. And I decided to go one day for a walk across the street and go have a beer by myself and sit and people watch just to get out of my house and a change of scenery.
All right, now is this your apartment?
No, this is the marital home.
Okay. Where is that marital home?
Winter Park?
You're no longer living in that marital home?
No.
Who lives in the marital home?
No, and it has been sold.
Okay. So you met Jorge Torres before you got the apartment?
Yes.
Okay. And you met him at a bar across the street from the marital home?
Yes, we had a mutual friend there.
Were you introduced?
Yes.
All right. How did you and George get along when y'all first met?
Very well. It was strange how quickly we hit things off and had so much in common, and I never thought that he would be interested in someone like me, and I just couldn't believe that he was actually interested in me and said a lot of nice things, and 1 hour ended up being 4 hours from when we had first met, and then we would always have something to talk about.
Why couldn't you believe that he would be interested in you?
He was very handsome. He was very funny. He was smart, and I would show up in workout clothes and disheveled hair, and I guess I kind of felt broken from being in the process of the divorce that he knew about. But then one of the things that we could relate also was the fact that he was here in Florida because he had just been divorced from his second wife. So that was another topic that he and I could compare notes on.
So eventually, the divorce was settled. Did you get your own place?
Yes.
Is it fair to say that after at first you lived in your parents' home, correct?
Yes, until I was married.
And then you moved directly in with Brian,
Yes.
and then y'all lived in the marital home, correct?
Yes.
And then you got this apartment.
Yes.
So that was the first time in your life that you actually had your own place.
Yes.
And what was the address?
4748 France Court, apartment number 3.
And what city is that in?
It's in Winter Park.
How far is that from here?
20 minutes?
Okay. So you got that apartment, and initially, were you by yourself?
No.
All right, tell the jury.
In the almost year, about 10 months of separation from Brian, my ex-husband, that is the time when I met George. And my ex-husband was trying to buy me out or force me out of our marital home, and I needed to find somewhere to live. And
So
George-
did you and George agree to rent the apartment?
Yes, I needed extra income. We could not afford it, just on my own.
You were receiving some income from the marriage settlement, were you not?
Yes,
So you did have a consistent monthly income coming in from the marriage settlement,
for the most part, yes.
but you needed more to live.
Yes, to pay the bills and for rent.
So did you and George have some agreement?
We did.
All right, what was the agreement?
The agreement was that if I decided for he and I to live with one another, because it would be under my name, that he would help with the monthly bills and on a regular basis where it wouldn't be something that I would have to argue with him about. It would just be an automatic, make sure that everything's paid first, and then from there, hopefully have some fun with it.
Okay. And so I understand from that point on, would it be fair to say that y'all saw each other on and off for about the next 3.5 years?
No, I would consider us a couple. At some point, he asked me to marry him.
Okay. But y'all did have times where he left and went to live with his parents?
Yes.
Is that fair?
Yes,
And there were times where there was an understanding that y'all were going to break up?
multiple times.
Okay. All right, so, again, on again, off again.
Yes, this was actually before we had our apartment. That was, I guess, our dating phase.
Okay. So y'all were together for 3.5 years, is that fair?
Yes.
And y'all had actually agreed to marry?
He had asked me, yes, a couple of times to marry him, and one time I agreed to yes.
Okay. Now, I want to get directly to the date of this event so that the jury can hear your testimony. All right, so tell us, I believe the date is February the 23rd of 2020. Explain to the jury that whole day, from the time y'all got up, the whole thing.
Approach.
So she is not testifying by narrative. She's testifying by question and answer. You can't testify by narrative if you are testifying in a question and answer format. So the objection is that this question, tell us from the beginning of February 23rd until the end of February 23rd, what happened, that calls for a narrative testimony. And we are awaiting a ruling on that objection. And I would likely sustain that objection just based on what we're hearing at this point, just based on the general nature of the question.
Objection's overruled for now.
Now, Ms. Boone, let's just, instead of one long speech, let me break you up over the course of the day. So, do you remember the date of February 23rd, 2020?
Yes.
Do you remember getting up?
So the objection was overruled, but as you can see, he's kind of breaking it down. So it sounds like there was an agreement when they went up to the judge's stand that he was going to break down the question into smaller subparts.
Yes.
All right, just tell the jury about that morning, what y'all did that morning, what you and George spent the night together at the apartment.
Yes, at that point, he was living there.
Yes. So y'all slept in the bed together upstairs, February, so y'all would have gotten up that morning, February 23rd of 2020.
Yes.
All right, tell the jury what happened when y'all got up.
He was already downstairs, and I went downstairs, and he wanted to start the day off by drinking because it was a day off from his job. And I talked him into cleaning and tidying up the house for a sense of accomplishment. So that is what we did for however long that it took. So we did tidy up the house and got everything in order, and it was kind of a reward, I guess, to be able to sit and enjoy ourselves and sit on the backboard.
All right, what do you mean by cleaning up the house? What did y'all do?
We swept and mopped. We folded some of the laundry. I know that we did the dishes, emptied the dishwasher, just general run-of-the-mill tidying up.
And did you have your son coming the next day?
Yes, that was one of the reasons why we were able to do that.
What was the arrangement you had in terms of the next day would have been your day to pick up your son from school?
Yes.
What time would you pick Lucas up from school the next day?
I believe his school ended at 3 o'clock.
Okay. So you would have been responsible to pick him up, and he would be spending the night with you that night?
Yes.
So you wanted to have the house nice and clean?
Yes.
How many bedrooms are in the home?
2.
And you and George had one bedroom?
Yes.
And who had the other?
Lucas.
All right. Is that exclusively his bedroom?
Yes.
All right, so how long would it have taken y'all that morning to clean?
I don't really remember what time we woke up, but maybe a good 2, maybe 3 hours.
Okay. And would it be fair to say that you and George both smoked cigarettes?
Yes.
And would it be fair to say that you and George both drink alcohol?
Yes.
All right. So at some point, y'all finished your chores,
Yes.
right? And then y'all were going to enjoy the day.
Yes.
All right, what was the plan?
It was just kind of, you know, we've got the day to ourselves. Let's just kind of relax and go with the flow.
Did y'all make a decision that y'all were gonna start drinking?
Yes, we had a half of a bottle that was already in the refrigerator, and I did not want to go out afterwards. I, again, had Lucas coming the next day, so we went over to Publix to purchase another bottle of wine, so we could not have to go out later on that evening.
Now,
So there's the first inconsistency with what she told the police officer. She just testified that we went to pick up the other bottle. She previously told the police officers that that he went and picked up the bottle of wine.
you were here in court when the state played the video of you two and the Publix purchasing the bottle of wine?
Yes,
Is that what you're referring to here with the jury right now?
yes,
Okay. And that was around noonish?
I believe so, yes.
Okay. Had y'all started drinking the leftover bottle before going to the Publix?
No,
Okay. So, y'all bought a bottle of wine?
yes,
All right. And how did y'all get to Publix?
my car,
How far is Publix from your apartment?
5 minutes.
How would you get there from your apartment?
What do you mean?
Did you have to go across any major highways, or is it right there?
You just come out of our apartment complex and you do a little U-turn and then you come up and it's right in that complex.
Okay. But it's easier to drive than to walk?
Yes,
Okay. Now, I know at some times y'all would simply need cigarettes and it was in walking distance. Can you tell the jury about that?
yes. There was a AutoZone convenience store with, in the same, I guess, parking lot of our townhome, our complex. And it was just a straight shot from our apartment to a back gate, and you could get right into the convenience store from right there.
Okay. But y'all went over to get that bottle of wine around noonish, and how did you took your car?
Yes,
Did George have a vehicle?
we did not.
And how did you pay for the wine?
With my debit card?
And then y'all came back and started drinking?
Yes.
Okay, tell us what you did when you got back from the Publix.
Just went on the back porch where we usually spend our time because we're able to smoke cigarettes outside as opposed to inside. And
Is cigarette smoking not allowed indoors?
it is not.
Okay. Do you have pets?
Yes, I do.
Well, did you have pets?
I did, yes.
Okay. Were they with y'all there that day?
Yes, my dogs were with me all the time when I was there.
How many dogs do you have?
I have 2,
And just, what are their names?
Penny and Tess.
And
I believe it's still the case in the state of Florida that apartment complexes cannot prevent you from smoking within the dwelling that you have rented. But most apartment complexes still put it in the lease that you can't smoke in the unit. It's just a non-enforceable provision from what I understand. That could have changed within the last couple of years, but that's my understanding of the state of the law.
what is the breed?
They are red Boston Terriers.
And are they both disabled?
Yes, Penny is blind and Tef is deaf.
So when y'all went out to smoke on the back porch and drink, I assume, as well, correct?
Yes.
Did y'all take the dogs out?
Oh, yes.
All right. Is there a place for them to do their business out there?
Yes, I extended our back porch for them to have a little bit of area as opposed to going from a large backyard from my marital home to our little townhome. And they would come out there and do their business, and I could sometimes I would open the gate and then walk them in the back part of our apartment.
So you and George were just going to enjoy the day together?
Correct.
Is it fair to say y'all don't have a lot of money?
Yes.
And so y'all were going to do something there in the home? Y'all weren't going out for dinner or?
Yes, we primarily, I would consider us homebodies as opposed to going out and partying and doing this and that.
Okay. And how long do you think y'all were out that afternoon outside?
A few hours.
All right. Could you tell the jury what y'all did during that time?
We have a dartboard that's out there, and we just had drinks, and we're just really enjoying each other's company and talking about, you know, things upcoming. You know, we both were looking for a job, and just kind of, I guess, encouraging and supporting and planning. And
Well, now you said he had a job. Was he looking for a job, a second job?
no, the job that he had was very unstable, and at that,
So he was looking for something new.
yes, at that time, yes.
Okay. And so during that 2 or 3 hours, would it be fair to say that y'all drank the bottle?
Yes,
Okay. So would it be fair to say that y'all were feeling the effects of the alcohol?
yes,
Okay. At some point, who made the decision to come in?
I did.
Okay. Why did you want to come in?
I felt that George needed a change of scenery.
Okay. So y'all came in, and then did y'all do anything else before he left again? Were y'all doing anything? I know y'all did some arts and crafts. What did y'all do? At some point, he went to get another bottle at Publix.
Yes, after, I believe it was after we had, it was right before, I believe, that we had gone inside. Because he called his daughters. I was trying to encourage him to call his family.
Okay, now where are his daughters?
His two daughters are located in Pennsylvania,
And what are their names?
Anna and Destiny.
And how old are they?
I believe that Anna is in her 30s, and Destiny may be in her early 20s.
All right, does he have any more children?
Yes, he has a son.
And where does his son live?
He is in Pennsylvania also.
Okay. So part of that afternoon is y'all came in to call relatives, call family.
No, I had him call outside, just trying to, I guess, boost the mood. The first daughter didn't answer, and I don't remember the reason I didn't speak to the second one. I believe if he did, it was just for a moment.
All right, now whose phone were y'all using?
My phone.
All right. And is that common for y'all to use that, for y'all to share that phone?
It was because George said that he didn't have a phone, so it would either be lost or given to him by his mother. So I didn't know he had a cell phone, so we would use my phone.
So it was primarily your phone?
Yes,
Okay. And you took a lot of photographs that were on that phone?
yes,
Videotapes,
yes,
text messages,
yes.
phone calls?
Yes, he and I both on the phone calls.
So he would use it as well?
Yes,
And that phone, is that the one that was seized in this case?
yes,
All right, so y'all called his daughters, and then during that phone call period, did you also call his brother?
yes.
Okay, and which brother was that?
John,
All right, now, how many brothers and sisters does George have?
I'm going to list them if that's okay.
Okay,
It's John, Pharrell, Isaac, Mo, and his sister.
okay. And do they all live here in Florida?
Yes,
Are they close by?
as far as I know, yes.
What about his parents?
Yes,
They live here as well?
yes,
Okay. But his ex-wives and his children live up in Philadelphia?
yes,
Okay. So you called the girls, then you called, or George called his brother.
yes.
Was that conversation that long?
No, it was not.
Okay. And then after that phone call, were y'all inside by this time?
Yes, at this point, I believe that it was a good time to get a change of scenery. So I thought George would be better off inside, and frankly, I didn't want to be outside any longer either.
Okay. So just to get an idea, about this time is when he went to get the second bottle, or did y'all stay inside for a while before he left?
No, from what I recall, it was, I thought the day was over, and it was going to be, get ready for the evening, for the day, what do you want for dinner, you know, do you have an extra load of laundry that you need to throw in, kind of thing, and that was my understanding, and he said,
This was about 5-ish or something?
I don't remember the time.
Okay. At some point during that time period, did George go to Publix again?
Yes, I thought he was going to be walking to the convenience store, but apparently, when he returned, he had gone across the street with my car and my debit card to buy another bottle of wine.
What was your understanding of where he was going?
To the convenience store, walking,
For what?
cigarettes.
Okay. And you learned obviously that he came back and you learned that he'd used your vehicle
Yes,
and he'd used your debit card
yes,
and he'd brought back a bottle of wine from Publix.
correct,
And you saw the Publix video of that.
yes.
So he comes back with the other bottle of wine, and did he want you to drink with him?
It was expected, yes.
Yes. And you agreed to consume the second bottle with him?
Yes.
Okay. So over the course of that evening, drinking the wine, what did y'all do for time-wise? Watch a movie, music, just kind of tell the jury what you remember. I know it's obviously been a while, but
It was kind of a regular thing where I would always try to come up with entertaining activities for George. And I bought a puzzle. We started off at one point doing a smaller puzzle, and then we did that very quickly. So then I purchased a larger puzzle, and I believe it was 1,000 pieces. So I thought to get his mind off of things and to focus on something, it would be smart for us to do the puzzle. So for however long that took, we finished the puzzle. So that was one.
did you, every piece was finished, or was it?
Every piece was finished. It was strange that we couldn't find one piece, and we thought it was funny that it was like in like the perfect place on there. But yes, every one but one piece.
All right, after the puzzle, what did y'all do?
I decided to continue to maintain and focus him, and I have a bunch of paints that I used of my son's that his grandmother bought him. It's a very big art wooden box, and it's got pastels, pencils, paint, any kind of whatever. And he and I were very much into art, and with this resource, it got him very interested in being more creative.
How long have you been into art?
Ever since I can remember. As a child,
You like to draw?
I like to do anything artistic.
And I know, we saw some of the pictures of your apartment, but it looks like there was pictures and artwork up. Is that all your work and George's work?
The majority of it, yes, are belongings from my home, and then also some of George's, yes, on the wall.
Was he pretty good at art as well?
Yes,
All right, so you both enjoyed doing that.
very much.
So y'all got out Lucas's art set. What did y'all do with that?
We were just, I guess, doodling, whatever. I would always tell him that everything that you make is a masterpiece. So just let loose and just let it go. And we would just paint and,
And drink.
paint and drink, yes, and listen to music sometimes, and yes.
Okay. Now, with the dogs, did y'all get the dogs involved?
Oh, yes, my dogs follow me everywhere, yes.
Was there some dancing going on with the dogs?
Yes, after we had completed the puzzle and I guess we're painted out, I thought that it might be a good point for us to maybe listen to some music. And the music that George listens to is it's very fractious to me, and it was definitely not going to lighten the mood. So we ended up finding some channel on the radio, and he was feeling it. And then we ended up, my one dog gets very active and was dancing with us, and we were just having a good time listening to music.
And I guess it's getting pretty late in the evening.
Yes.
Anything else I've missed?
I don't believe so.
All right. So tell us where y'all ended up before you started the game of hide and seek.
We were there. I couldn't think of anything else possibly that I had to continue entertainment. But I remember sitting at the end of the couch and him sitting in one of my son's chairs that was in the living room and just kind of doing this. Like, what are we gonna do now? Like, I very much would like to go to sleep.
Had y'all finished off that bottle that he had bought?
I don't remember, to be honest with you.
Bless you.
Would it be fair to say that as the day wore on, the more y'all consumed?
Yes,
All right. And would it be fair to say that as the day wore on, the more you consumed, the more effects you felt from the alcohol?
of course, yes.
Both of you?
Yes,
Okay. So you would agree, would you not, that at the time y'all were trying to figure out something to do and you put your head on the couch, that would it be fair to say that y'all were intoxicated?
yes.
Tell the jury what happened.
There's another inconsistent statement. She told the officers that she was not intoxicated. Now she's saying that she was intoxicated.
At one point, I guess he knew that I couldn't come up with anything else, tapped me on my knee and said, "You're it." So from there, I ran up the stairs and hid into our shower.
I am so confused by this game of hide and seek. If you're it, why are you hiding? The person who's it doesn't hide.
Just waiting for him to find me so we could hopefully go to sleep soon at some point. And
Now, your shower, is it a tub or just a walk-in?
it's a tub, but it's in the master bedroom, and you have to go all the way upstairs, you have to go in the bedroom, and then you have to go into the bathroom part, and then there's the shower part.
So did you lay down in the tub?
At one point, yes, I was.
So you were hiding?
I was trying,
Okay. And did you believe that he was going to come try to find you?
yes,
Did you wait?
yes, for quite some time.
All right, then what did you decide to do?
That I decided that I need to go to sleep. I'm picking my son up the next day, and we need to start wrapping up the evening. And I went downstairs to find where he was.
And what, I think the jury has seen pictures of your, would you call it an apartment or
It's considered a townhome.
a townhome? So you walk down the stairs, right? And at the bottom of the stairs is a bookshelf here?
Yes, at the very end of it, yes.
Okay. So you walk down the stairs and you turn and look in the living room. What did you see?
I don't even think I made it all the way down the stairwell because I was just looking for him as soon as I could, to hopefully go upstairs as soon as we could. And I looked over and I saw him settling himself in the suitcase.
All right, tell us about the suitcase. How long, is it an older suitcase?
Yes,
Whose suitcase was it?
this is George's suitcase.
All right, and did he use it for traveling back and forth to Philly?
Yes,
If he tapped her on the shoulder and said, "You're it," and then she goes and hides, and she's up there for a long time. She doesn't know how long. She's up there for a long time waiting for him to come find her. And then she comes downstairs. Why would he just be settling into the suitcase? If she's it, he's hiding. Wouldn't he have been in the suitcase hidden all this time waiting for her to come find him?
I had recently taken him on a trip to go see his children in Pennsylvania, who he hasn't seen in years, and we took that with us. And because of how dilapidated it was, how broken it was, in the end, after that trip, we decided that we would donate it.
All right, and I understand y'all kept the suitcase upstairs.
Yes,
How long did y'all keep it upstairs?
since we had moved in.
Is there a closet up there you kept it in?
Yes, it was in the master closet. the master bedroom closet all the way in the back because of the size of it, and there was nowhere to put it, so it's all the way in the back.
So when did y'all decide to move it down from upstairs to downstairs? Was it that day or sometime earlier?
No, it was maybe a week or so prior.
Okay. And so what, y'all were gonna donate that to Goodwill, or?
Yes, we were going to do, I guess, a spring cleaning. Anyone who has children understands that they grow quickly, and there was a lot of clothes that I needed to go through of my sons, and then also from George and I moving in and just kind of putting everything in there, at one point where we just needed to actually go through it and organize it and get things more in order.
So is that the reason it was downstairs? You were gonna donate it and a bunch of things that you were gonna put inside of it?
Correct, yes.
Okay. So it'd been down there a week, so it was already down there?
Yes, George brought it down.
Okay. So you said that you got down there, you're looking for him, you see him settling into the suitcase.
Yes.
What did you do?
In my head, I said, oh man, we're obviously not going to be going to sleep anytime soon. And I walked over, and he was trying to get himself flat, so I couldn't tell that he was in there. And then,
Now, let me stop you there. The suitcase, is it the suitcase over here in the
yes,
box? You've seen it, you saw it.
yes,
It's a pretty big suitcase.
yes.
How big is George?
George was my height, and
How tall are you?
I'm 5'3".
Okay. And how much did George weigh?
I thought it was 100 pounds.
Okay. And how much did you weigh?
I was 98 pounds.
All right. Do you agree you put on some weight?
Since I've been incarcerated, yes.
Well, at the time, though, y'all were pretty skinny.
Yes,
So from the pictures, it looks like y'all were both pretty thin.
yes,
All right. So because of his thinness, is that how? And he's a small man.
yes,
Okay. So he was able to get in the suitcase on his own.
yes.
Did he willingly get in the suitcase?
He was already in there.
Okay. When you got to him, did he see you?
Yes.
All right. Tell us what happened.
I mean, I zipped him up. We thought it was funny, and we're joking about how he was, I guess, small enough to fit inside of the suitcase.
All right. So what happened then?
From there, it was just, we were laughing about it, and it was just strange that he was small enough to fit in there, and then I kind of moved it around a little bit with him in the suitcase still. It was still funny that he was still in the suitcase, just, I think he and I were just kind of, couldn't believe that he could fit in the suitcase.
Did you eventually close the top?
Yes, well, the top was already closed. As he was settling himself in there, that's how I knew he was in there, was because the top was kind of flopping a little bit.
Okay. So he had got in there to hide, and he pulled the top
Yes,
on top of it. But you could tell he was in there.
yes,
You saw him right away.
yes,
All right. So at some point, did you zip him up? Did
yes.
you? And what was he saying or doing when you were zipping him up?
We just thought it was funny.
Were you both laughing?
Yes,
And so you zipped him up. Were y'all still laughing once you zipped him up?
yes.
Okay. Tell the jury what happened then.
From there, I moved the suitcase around a couple of times, just kind of on the wheels, and moved it around, and at that point, it was funny. We were joking and laughing about it.
All right, now eventually, did you?
I think that's the third inconsistent statement. I believe she told the officers that she did not move the suitcase around. And now she's saying she moved it around even before taking the video.
You go sit down on the couch and get your phone.
Yes,
Did I miss something?
well, the suitcase had, from me moving it around was flopped over. So while it was like that, I thought at that point I had a moment to, I guess, take the time to talk to him while I guess he was not able to get out for a moment.
So you flipped it, you got it on the top, right?
Yeah.
He gets in, but at some point you flip it over, so the zipper is on the bottom.
Well, it was just kind of how I was moving it around, then it ended up kind of flopping, so,
But it was upside down.
yes.
So after you did that, what did you do?
That's when I went over and decided to videotape to just see the, I guess, the gist in it for him to understand that right now I feel safe and right now I have the ability to actually speak to you in a manner that normally I would not have the ability to do.
And you were intoxicated,
Yes.
and you would agree that you said some things you should not have.
Yes.
Right? But you realized he could not get out and get at you. Is that fair?
At that moment, yes.
So I think that's a fourth inconsistent statement. She now recalls her state of mind at the point where she begins taking the video, when before she could not recall even taking the video.
So it goes on for about 10 minutes.
Yes.
You heard it here today, did you not?
Yes.
You heard his voice as he was speaking from the suitcase.
Yes.
That was his voice on the video and audio.
Yes.
And you heard your voice on the video and audio.
Yes.
That was your voice.
Yes.
All those things said by the man were said by George in that 2-minute video.
Correct.
All the words said by the female were said by you in that 2-minute video.
Correct.
Were you intending on showing him the video the next day?
Yes.
At the time or the next day, is it fair to say you don't even remember videotaping?
I do not.
So, from what you can tell from watching it, did that refresh your memory about that event?
It did.
So now that she's watched the video, that refreshed her recollection, not only of having taken the video, but her entire state of mind at the time that the video was taken.
Why did you say all that?
So they're approaching because why did you say all that is likely going to get into prior bad acts. And she can't get into prior bad acts because we haven't heard an overt act yet. What do you all think of her testimony so far? Are we now convinced that she is not guilty of having murdered Mr. Torres? Or are we still, I think everybody's was pretty much convinced prior to this testimony that she is in fact guilty of having murdered him. But so far, has she convinced you otherwise? Let me know in the chat. Celine Toby says never. She can never convince you, huh, of that she's not guilty of this particular crime.
All right, I'm talking about just the 2-minute video part that was recorded. Could you just tell the jury what you were feeling, what your feelings were at the time, and then explain that to the jury? You mentioned, you talked about it before. You said he was in that confined space and it was my chance, but is that, do you want to elaborate on that, or?
Sure. I want you all to know that the majority of the time, am always afraid and always scared.
All right, well, I understand that. Okay, I understand that. But would it be fair to say that you had some anger at that point?
I did.
And would it be fair to say that you wanted to tell him off to some degree?
I just wanted, yes, for him to have a better understanding, which was the whole point of the videos and documentation prior.
And you could tell that he was uncomfortable.
I'm guessing.
And did you want him to feel some uncomfort?
I did.
Okay. Now, at some point, you turned off the video.
Yes.
And then we saw a second video, which was approximately 11 minutes later. And you've seen that video that was played to the jury. It was 22 seconds long.
Yes.
And I don't think you speak in that video. You hear George say Sarah one time.
Yes.
Is that fair to say?
Yes.
So between the 2-minute video and the 22-second video is an 11-minute period. Would you tell the jury what happened?
We continued to, I guess, speak to one another, and his tone changed, and I knew the tone, and we ended up, I guess, arguing back and forth with one another, and it was, the things that he was saying very much frightened me, and cursing at me and threatening me. And
Did he want you to let him out of the suitcase?
I'm sure so.
Okay, go ahead, tell the jury.
And it just got very heated very quickly, and he continued to push on the suitcase. And my fear was that he was going to break out of the suitcase, knowing that it was a broken suitcase. And his hand started to come through, his hand started to come through this way. And so I shook the suitcase, trying to get his hand to go back in, shaking it, and telling him that, please stop doing this, please stop doing this to me, please stop doing this to me.
So his hand actually got out of the suitcase,
Yes,
and you went to the suitcase
yes,
and shook it.
yes,
Did that force his hand to go back in?
no.
So you're shaking it. Were you shaking it to try to get the suitcase, his hand back in?
Yes,
How long did you shake it?
I don't know.
But his hand was still out.
Yes,
Was he trying to get out?
forcefully, yes,
Was he angry at you?
yes.
Were you in fear?
Always.
If he would have gotten out of the suitcase, what would he have done to you?
Like he used to tell me, he probably would have made me unrecognizable, or I would have lost my life.
Did you lose the grip on the suitcase?
Yes.
Where was the bat in relation to the suitcase?
It was leaning up against the dining room table, right there.
How far was the bat from the suitcase?
3 feet, 2 feet?
Was his hand still out of the suitcase?
Yes.
And was he getting out of the suitcase?
He very much was trying, yes.
And so what did you do?
For the split-second reaction that I had, I happened to see that, and I grabbed the baseball bat and was trying to poke his hand to go back in, to please don't break through, please. So I hit his hand.
Did you hit the outside part of his hand?
Yes,
We've seen the photographs of his left hand. Did you cause the bruising there?
I'm guessing yes.
Now, you've seen the bat. It's a youth bat.
Yes, I bought it for my son.
Is this the bat you used?
Yes,
And you said you poked him with it?
yes, I kind of pushed, like I held it with the skinny part here and then
So the grip here,
prodded at it, yes,
you grabbed it with both hands here,
yes,
and then the barrel of the bat, the big part of the bat is here.
correct.
And you thrusted it into the different areas of the suitcase?
I started with his hand, and his hand, he was still trying to get out. He was still trying to do that. So I started to push on the suitcase around it, hoping to have his hand retract and go back inside.
You made those injuries.
I did,
We've seen the photographs.
yes,
We see the bruising. Is that from that bat?
yes,
Eventually, did his hand go back inside from you doing?
yes. Finally, he had subsided and retracted his hand.
So in your mind, did you prevent him from attacking you?
Absolutely. Split-second decision.
Now, once he retracted his hand, do you remember zipping it up some, or what did you do in relation? Because he was upside down, was he not, at that point?
Yes,
At some point, you flipped him back up.
I did.
Tell how that happened.
He wasn't cursing, he wasn't threatening, his hand was inside foremost. There was no more of him trying to break through the suitcase. So I felt safe enough to turn it back over. It wasn't happening anymore.
You went back to the video and the couch,
I did, yes,
and we saw the second video,
yes,
the 22-second, and he's right side up again,
yes,
and you hear him say, "Sarah?"
yes.
Had you left enough room for him to get out? Zipper to zipper.
Yes, that's how his hand was trying.
That suitcase has two zippers, doesn't it? And they meet at various places along the line?
Correct.
How much room, when you flipped it over, how much room was between zipper to zipper?
I don't know specifically. I mean, it was enough to where his hand was coming out.
After you had hit him with the bat, was he not trying to get out anymore?
No,
Did you believe that he could breathe in there?
yes,
Did you ever believe he could die in there?
no, at all,
Were you trying to kill him?
never.
Did you want to kill him?
I did not.
Remember, she removed him from the suitcase the following day. So there's no way of going back and determining how much space was left open for him to potentially get out of this suitcase. So we kind of have to take her word for it, or not believe her. Those are the only two options the jury is left with at this point. The officers have testified that they can't recreate, whether or not the zipper was open. But she's now saying that she did not believe that he could have suffocated in there, despite the fact that she heard him on the video saying that he could not breathe. And then for the 11 minutes after that video ended, she's beating him with a bat. For some portion of that 11 minutes, she's beating him with a bat. And then she wants us to believe, or wants the jury to believe, that after he says he can't breathe and after she's beating him with a bat, at that point, she does not know that he cannot breathe inside the suitcase. I call BS.
Did you walk upstairs?
I did, yes.
Why didn't you let him out before you walked upstairs? Were you afraid?
Terrified is more of the word.
As long as he was in the suitcase, he couldn't harm you.
Correct.
When he's... Did you want him to calm down?
Yes, I wanted him to stop being angry because I know what it is for him to be angry.
You went upstairs. Where were the dogs?
The dogs ran upstairs with me.
And where did they go?
On the bed.
Did you have the phone with you?
Yes,
I know at some point you called your husband Brian, did you not?
I did.
Do you recall how long that conversation was?
Not very long.
Can you recall what was said?
I don't remember exactly. No, I don't.
One moment. Ms. Boone, Sarah Boone, you said that when he was in the suitcase, he was threatening you. Can you tell the jury what he was saying?
I don't know. Am I allowed to curse?
Yes.
But he was going to fucking end me. And that's what made me ask him please to stop doing what he's doing to me. That he was going to, I'm guessing, try his best that night to probably take my life.
But what, the threat you heard was
He's going to
say the
fucking
word.
end me.
Excuse me?
Fucking end me.
End you?
Yes.
One moment.
Yes, sir.
Judge, can we approach the bench?
Yes.
So that's the most that this attorney can get out of her that might show an overt act. So the overt act at this point is his entire hand leaving the suitcase and him trying to get free of his confinement. So during that initial 2-minute video, his hand is not free. We do not see his hand. But after the two, and then in the 11th or the 22nd video, we don't see his hand either. So she's asserting that during that 11-minute interval, he gets a hand free, and that point at which he gets his hand free and begins extricating himself from the suitcase is the overt act. That is the threat, and that is the justification for her beating him until his hand goes back into the suitcase. Not only beating his hand, she said that's
Members
what
of the jury, it is 2:14.
that's what I started with, but also beating him about his person. At which point he pulls his hand back into the suitcase, and she, I guess, stops beating him at some point, returns to the couch, and begins the second video. And on the second video, all that we hear is Sarah. There are no threats. At no point during the first video did he threaten her. At no point during the second video did he threaten her. But she wants us to, one, believe that he got his hand out. Two, believe that he was yelling at her, cursing at her, and threatening her, instead of just pleading for his life like he was doing already on the first video. And that all of that was justification for her actions thereafter.
I have a matter that I have to discuss with counsel at this point in time outside of your presence. So I'm going to ask you to retire to the deliberation room. We'll bring you back in as promptly as possible.
So they're about to kick the jury out so that they can talk about whether or not this counts as an overt act.
State, you can proceed with any argument at this point in time.
Judge, I believe that's pretty close to what we already knew from the deposition testimony, from the doctors relaying what she said for the proffer. What we have here is testimony from the defendant. Her timeline is she comes downstairs after having gone up to the shower and hiding, laying down, after being declared to be it. She comes back downstairs, and before she gets back to the bottom of the stairwell, she can see that the victim is in the suitcase trying to get flat because the lid is flopping and he's not hidden just yet. And so she comes over, and I believe she testified she was moving it around before actually zipping the lid shut, but moving it around, everybody's laughing, it's all fun and games still, and then she zips it, and it's still fun and games, and everybody's laughing, and then at this point she testifies that this is now her opportunity to get on her pulpit to express her true feelings about everything. And that's when she sits down on the couch and opens up her phone device and begins recording what later turns out to be IMG _1062.movie at 11:12:45 for 2 minutes and 3 seconds. During this period of time, the decedent is expressing meekly that he can't breathe. The only time he ever curses at her is, Sarah, I can't fucking breathe. Babe, I can't fucking breathe. He is demonstrating under the law that he is in fear of losing his life. She has committed an aggravated assault. She has committed false imprisonment. She was the initial aggressor. There was no overt act to justify these actions that she took against her boyfriend. She then goes on to say that during this period of time between the end of the movie at 11:14:48 seconds and before the next one starts at 11:23, that it's now at this time, while he's still constrained and clearly unable to get out under his own power despite having his hand out, she begins beating him with a bat, poking his hands, poking the suitcase with a deadly weapon. A bat is used for baseball, but it can also be used to harm another person. And according to the medical examiner's testimony, there was great harm caused to him, deep ecchymosis bruises. She can't start to do this out of fear, like the analogy I gave earlier. If I pull a gun to rob you, Judge, and you pull a gun, I can't shoot you in self-defense. She started this. She started this. There was no overt act.
So essentially, I think what the prosecution is saying is, look, what caused the death is him suffocating from being confined inside of a suitcase. That's what the ME said. She confined him in the suitcase as soon as she came down the stairs. That is the initial act. She doesn't have to do anything else, and he dies. But she does other things after that. Perhaps he does other things after that. But that initial act is what eventually led to George's death. And if that initial act is what initially led to George's death, then anything that happens after that can't be an overt act that caused her to commit that initial act, because the overt act has to come first. She's saying that she left him in the suitcase. So essentially, she did nothing after the fact. She did not take an additional step of removing him from the suitcase because of the overt act of him getting his hand out of the suitcase. But in this prosecutor's judgment, that doesn't matter because the initial act had already occurred without any acts that would have caused her to commit that initial act in the first place.
And therefore, we're asking for you to prevent, under the case law, any prior instances of violence, any reputation evidence, and any battered spouse syndrome evidence, because that's simply just what the case ended up being. Thank you.
Response.
Judge, this was a game by two intoxicated people. When people are drunk and intoxicated, they do silly and stupid things. The evidence is uncontroverted that Jorge Torres willingly, by his own choice, elected to hide in the suitcase. By their interaction between the two of them, giggling and laughing at each other, he consented to her zipping up the suitcase. And the playful nature of what was going on during those few minutes prior to the video. When the video is turned on, there's a 2-minute period where they're talking. He's saying, I need to get out, I can't breathe. She's not taking him seriously. As you've seen from the videos, I thought it was the boy crying wolf. She did not appreciate the fact that he could be actually having trouble breathing. And this was a chance for him to be heard by her about how she felt about some things involving their relationship.
It's interesting how all the pieces of the defense's case are lacking in the video evidence. What the defense needs to demonstrate here today is all lacking in the video evidence. So they need to demonstrate that he consented somehow to her zipping him in the suitcase. The video evidence doesn't demonstrate that. They need to demonstrate that he punched his way out of this zipper at some point. The video evidence doesn't demonstrate that. Everything that they need in order for this defense to end up on the jury verdict form is lacking in the video evidence. And the video evidence is showing everything that the state needs to prove their case in chief. It's interesting how that played out.
A short time later, the video was turned off, and then that period has been testified to by my client. And that period...
Exactly, Natalie. If you want to stand up on your soapbox and tell your partner who you live with about everything that you're feeling, get some counseling. Don't do it when he's trapped inside a suitcase and telling you that he's about to die because he can't breathe.
It is uncontroverted. That's a second period of time. We've got that time for the video. We got the 11 minutes. We got the 22 seconds. And there's no video. There's no audio. There's no eyewitness. There's nothing but Sarah Boone's testimony. And she's testified here today that they had words. There were threats. He got his hand out of the suitcase. She knew by the threats and him getting his hand out of the suitcase that he was about to get out of the suitcase and he was going to hurt her. A reasonable person under that scenario would believe she was about to be harmed. She was an imminent threat of harm. She blocked that attack by grabbing the bat, hitting his hand. When that didn't work, she started poking him with the bat in the suitcase. Eventually, she poked him several times. He put his hand inside the suitcase. She put the bat up. When she realized he was not going to do that any further, she flipped him over right side up. She still had a fear, knowing that if he got out, she would be harmed. He would beat her up. She went upstairs. That is an overt act based on the discussions, coupled with the fact that he threatened her, using the word, I'm going to fucking end it for you, or some words to that effect. I don't remember her exact words, just before she went upstairs while he was still in the suitcase. If she would have let him out, and this is now this is an event involving an omission, failure to act, failure to unzip him at that point, before she went upstairs. The failure to act, the failure to unzip, which would have let him out, which would have created a situation that she believed was imminent bodily harm to herself. And I guess I'll get a couple of examples. Let's say that a police officer is called to a scene and the only thing he hears is there is a suspect and the suspect may be armed. So of course the officer pulls out his revolver and he's walking around. Well, then eventually he finds the suspect and the suspect reaches for his waist. The officer doesn't see the gun, but the officer sees the movement to the waist. The officer fires and shoots the suspect. The officer is justified because there's an immediate threat of harm. The officer has to react instinctively. There's no time to think. Similar to the actions that Sarah Boone had to take. Another example, you're in a bar with your buddies and you've had something to drink and another group has had something to drink and one of your buddies gets into an argument with one of the buddies on the other party. And one of your friends, seeing that it's being escalated and the guy that's arguing with your buddy is aggressive, more aggressive than your buddy is. Your buddy's trying to settle the thing, but this other individual, maybe he's had too much to drink and he's more aggressive. So you go around behind this individual, and before he's able to strike your buddy, you grab him. You lock him up. That's physical restraint to block an attack. Or you grab him by the neck and you choke him. Physical restraint to block an attack. That's what she was doing with the suitcase. If she let him out of the suitcase, she was going to be harmed based on...
So no, Natalie, there were no threats that I heard on the video. I've listened to the video at least 3 times now. There were no threats.
Him trying to get out with his hand based on the threats he made while he had his hand out and based on the threats he made while he had his hand inside just before she went upstairs.
Thank you. Court's going to review all the case law that it's obtained in its research in this matter and come back with an oral ruling momentarily. Thank you.
I love this judge. He's doing exactly what he should do. Go look at the case law, see if there's any cases that are similar to this one that he can rely on, justify his ruling. I don't know what he's going to decide, but let's get to it. Here we go.
All right, we're back on the record. State of Florida versus Sarah Boone, case number 2020 CF 2603. Appearances for the state.
Steve Ketchtor on behalf of the state.
William K. the state.
Defense.
James Owens from Miss Boone.
Connie Henderson from Sarah Boone.
Kevin Beck on behalf of Sarah.
Ms. Boone is currently seated at counsel's table, wearing the same clothing from this morning. The court has the opportunity to review the case law, review the arguments provided by both the state and the defense. The court finds that an overt act has been established. The case law is clear that a scintilla of the providing of an overt act is sufficient to provide the self-defense jury instruction. An overt act is not something that's specifically defined in Florida case law. It's something that's from the totality of the circumstances, seemingly under the authorities that the court has reviewed. As such, the court is going to find that under Holland, a overt act has been established and will allow the defense to proceed with evidence of reputation and specific instance of conduct and battered spouse evidence, so long as the necessary predicates are established for those items.
So if you remember the motions from earlier, the state kind of got the benefit of the doubt because the defense was raising the motion against the state, and the state only had to put forth a prima facie case. Here, this is essentially a pleading. They're pleading this defense, and there has to be a prima facie showing of each of the elements of the defense, and one of those elements is the overt act. And even if we don't believe anything she said, and even if the video evidence shows everything except what she said, the fact that she said he pushed his hand out of the suitcase, and at that point I feared for my life, and he was threatening me by threatening my life, and therefore I left him in the suitcase. As long as she says that, according to the case law that this judge has read, that's enough for a prima facie showing. And I have to assume that this judge, who has been an excellent judge thus far, and who has done his due diligence with respect to every ruling that he's made that I've seen, is relying on the correct case law. So I assume that he got it right here. And based on what he said, he did get it right.
Items. Any questions or clarifications with regard to the court's order state? Defense.
I think it would help if we went through my exhibits involving the blow-up photographs and these other photographs, because I think some of it was contingent on the court's ruling. So I don't know if you want to try to deal with all of them one at a time in front of the jury, or whether we want to just talk about them ahead of time so that we know.
Are there any objections to those items?
It depends on the items. I was shown a lot of different things, including like a rap sheet between the victim and the defendant. So
I've taken that.
we need to, I'm happy to take care of some of this stuff in advance.
I'd rather do it now.
Yes.
So that it's not up, down, in and out with the jury.
So,
All right, go ahead, Mr. Owens. What do we got?
Well, I had the clerk go ahead and mark everything. Some of it is a composite. Is this it here?
Let's see if we can get through some of this and catch up.
Defense identification K, it's 4 pictures involving injuries to the.
All right, here we go. We are caught up.
Ms. Boone? So I think we left off. You had called your ex-husband?
Yes.
All right. After you called your ex-husband, what happened after that?
I ended up falling asleep.
Okay. Do you remember waking up the next morning?
Yes.
Did you sleep in?
Not intentionally.
Okay. But you didn't get up at 8 o'clock, did you?
No.
Did you wake up closer to noon?
I believe so, yes.
Did you check the time?
No.
There's another inconsistency. She told the officers that she woke up early, but she was doing a bunch of stuff up in her room. Now she's saying that she woke up closer to noon.
Now, did you hear your phone ringing?
Yes, my phone was ringing.
And did you answer it right away?
No.
Do you know approximately how many times it rang before you answered it?
I believe the call was about 3 times.
Did you know who was calling?
I figured it was my ex-husband.
And why would he be calling?
To make sure that I was still on schedule to pick up our son.
At 3 that afternoon?
Correct.
And he goes to school there close by?
Yes.
All right. When you woke up, did you stay in bed for a while?
For a little while, yes.
Or tell the jury what happened when you got up.
I knew it was my ex-husband calling repeatedly. I didn't answer right away because one of our problems is that he doesn't understand that I'm doing things around the apartment and looking for jobs and so on and so forth. So I inevitably just let it ring, and I laid in the bed, and I figured that George was downstairs either drinking or looking for jobs, or may have just left. And so eventually I decided to get out of the bed and start moving to go downstairs. I was motivated enough to go downstairs, and when I went downstairs, it was very quiet. So I had the understanding, I believed that he had left. And
Did you check to see if he was, where would he be looking for a job at?
usually on the couch, he would have my son's laptop, and he and I, which we would share.
Y'all
to
only
look
have
for-
the son's laptop,
Correct.
and the TV was not working at this time?
The TV was not there.
So you thought he would be in the living room on the laptop?
Yes.
He was not there?
No.
Where else did you look for him?
I looked on the back porch. I went through the front door to see if my car was there, thinking maybe he had taken my car. I checked the bathroom, and when I was checking the bathroom, I saw the suitcase, and I remembered about the night prior, and I unzipped the suitcase
Let me
and
stop you there. You said you were in the bathroom when you saw the suitcase, or coming out of the bathroom?
know where our bathroom is. I would have to go to the bathroom here, and then when I turned around, I noticed the suitcase, and I remember.
How did you feel when you saw the suitcase?
I don't think I've ever experienced anything like that before.
Describe it for the jury.
I guess it was, I was aghast, and I just can't describe the feeling.
Bless you.
It was terror to
Bless you.
a certain degree.
I'm sorry, say that again now?
It was terror to a certain degree. I just can't describe it in words, the feeling of remembering. And then he was still in there.
So what did you do?
I immediately unzipped the suitcase, and I was screaming, "George, George, George," and I was shaking him, and I pulled him out, and I stretched him out flat, and then I began instantly trying to do CPR, and then was trying to look for a pulse or a breath or just anything, and was just screaming his name over and over and over again, and come on, George, and I continued CPR, and I continued CPR, and he was gurgling, and
What color was he?
what color was he?
Yes.
He was purple.
At some point, did you call your ex-husband?
Yes, when he started to gurgle, and I knew that my ex-husband is notorious for bringing my son over in very inopportune times when George is possibly drunk or doing things not appropriate for my son to see. And I just didn't know what to do. It was just a quick knee-jerk reaction. Ryan was kind of my go-to person because of my family being deceased, and I don't have anyone else that I can call. And I just wanted to ensure that he would not bring my son over in the process of all of this at some point.
So you called him.
I called him.
Did you ask him what to do? Or did you just tell him to come over?
I just told him to come over.
Did you tell him that you felt like George was dead?
Yes, I did.
And how far, you said it's 5 minutes from house to house?
Yes.
Did you call him back?
Yes, because he was taking so long. It felt seconds were hours. Yes. I'm still doing CPR at the same time in the process of it. I'm
Yeah.
doing CPR, I don't know how many times.
Did he get there?
Yes,
Did he walk in?
yes,
Did he walk out?
yes.
What did he tell you to do?
Call 911.
What did you do?
I called 911.
Is that the recording we've heard here in this trial?
Yes.
Did you love George?
To this day.
Why did you love him?
George was very passionate. George was a very real person. George was nice to me on the good days. George complimented me. George and I were two bodies with one soul, he and I would always say. I don't believe that I've ever had a connection with anyone like I have with George.
Did you have that connection with your ex-husband?
I did not,
Was it even close?
no.
George has some good traits, doesn't he?
Very much.
Did George have some bad traits?
He did.
Did you drink too much?
I did.
Did George drink too much?
Yes.
Tell the jury about George's drinking.
If George was able to, he would drink from sunup to sundown. And me having my son and trying to work and maintain the home and just have a life, a normal life as best as I could, somehow that upset George. And because I had a certain dollar amount from my divorce settlement, at one point it was from wine we could afford vodka, so a lot of the times he would take my car and my debit card and go buy the large, we call them handles, of vodka, which is the big bottle. And sometimes he would finish that all off on his own throughout an entire period of a day into an evening. That's honestly where I thought that he was going to be that morning when I came downstairs, because he's notorious for just automatically already being.
100-pound man finished off a handle of vodka in a day. I don't buy it. That's blood alcohol poisoning, and that sounds like death to me.
Being outside from drinking all the time.
All right. And you said you have an alcohol problem. George has an alcohol problem.
Yes.
How did George's drinking adversely affect you?
It would debilitate my ability to help him the way that I was always trying to help him, because it would be one good day, a day of survival, and then it would be another day where I'm having to peel him off of me and call 911.
Why would he get that way? Tell us his pattern as it relates to drinking and then
Object.
Approach.
So I'm trying to find whether or not this vodka consumption is even possible. You know, the alcohol chart for men starts at 120 pounds. They don't even have anything on here for 100-pound men. I would have to look at the alcohol chart for women that goes down to 90 pounds in order to even get anywhere close. So you all are telling us what you think of her testimony at this point, and it doesn't really sound believable. So look, the jury has the videos. They've got her the video of her interrogation with the cops. They got the two videos that she took at the time of the incident. Um, all of it is totally inconsistent. The videos of the that she took the day of the incident are inconsistent with what she's saying here. I can't imagine that somebody who is suffocating to death in that 2-minute video immediately turns to yelling, cursing, and threatening the one person who can get him out of the suitcase that is suffocating him to death. I also don't understand why he would be begging and pleading for 2 minutes, begging and pleading for her to get him out of the suitcase if he could get himself out of the suitcase. Before that 2-minute video started, wouldn't he have already gotten his fist out of the suitcase and began unzipping it himself if he could? I mean, at the point where he started
Objections
being
overruled for now.
unable to breathe, wouldn't he start trying to get out of the suitcase at that point? Why wait for her? Why plead with her to do it? And then the only person in the room that can be your savior, you're going to start threatening her life. When I get out of this suitcase, when you get me out of this suitcase, then I'm going to kill you. Come on.
You all were together 3.5 years.
Yes,
Is there times when he would get to a state of intoxication where he would get violent against you?
quite often.
Judge, can I approach the witness?
Yes, as long as you show it to the state first, please.
I'm going to show you defense exhibit for identification P. It's 2 photographs. Could you look at those photographs and see if you recognize those?
I do.
Those 2 pictures of your body,
Yes,
did they show injuries to your body?
yes,
Were those injuries caused by Jorge Torres?
yes,
Are those photographs a fair and accurate depiction of the injuries you sustained at the hands of Jorge Torres?
on this occurrence, yes.
Do you remember this occurrence?
I don't, it was so often.
You don't remember a specific date,
I don't,
but you're sure that that's you?
yes.
Is that the injuries that he, what's the injury to the rib cage?
I don't remember specifically. These may be the pictures. So, when we used to go over to his brother's house, one of his brothers and his,
Objection. Non-responsive.
Sustained.
You don't have to answer the question. Just a minute. Do you know what happened to, did George cause these injuries?
yes,
All right. Were y'all both drinking at that time?
I don't remember on this instance.
Judge, I'd like to move this exhibit into evidence.
Okay.
What was pre-marked as P will be received into evidence without objection as Defense Exhibit 2.
I'm not sure I know how to do this.
Mr. Owens, may I give Detective just a number, please? Thank you.
Mr. J, would you be so kind? Thank you.
And I need to ask permission to publish it.
Yes, sir.
Mr. Henderson's.
You may do so.
Right, well, this is nice, Judge.
Looks like I think there's a wheel on the top where you can use to, there you go.
Ms. Boone, is that you?
Yes,
Are those injuries to your arm,
yes,
were they caused by Jorge Torres?
yes,
And during the same incident, is this you?
yes,
Is that an injury or bruise to your ribcage area
yes,
and your arm?
yes.
I'll show you
Are they going to let George get on the stand and show all the pictures of what she did to him when these wounds were inflicted?
identification, defense identification Q, see if you recognize that photograph.
Yes,
Is that your thigh?
yes,
Okay, do you remember this incident?
yes.
Can you tell the jury what happened?
I wanted to take my dogs for a walk and get off of the back porch.
Were y'all drinking?
Yes. And he was upset that I would rather go walk my dogs than sit there and continue to drink. So he slapped my thigh as hard as he possibly could and said that you're not going anywhere. And it was a good smack on my thigh.
Is that a fair and accurate depiction of the wound that you suffered as a result of Jorge Torres slapping you on the thigh?
Yes.
Judge, I'd like to offer Q in evidence.
No objection.
What was pre-marked as Q will be received into evidence without objection as Defense 3.
Judge, can I publish?
You may, sir.
And for the jury's sake, is this the photograph you just mentioned?
Yes.
I'm going to show you identification, defense identification S. See if you recognize that photograph.
I do.
Is that your hand?
Yes.
Is that your blood on your hand?
Yes, it is.
Is that you standing, looks like in a room with flip-flops?
This is in the kitchen at Brian's house.
Okay, what happened there?
So George was very drunk, and I wanted to leave, and he's notorious for taking my car keys and putting them around his neck, and my phone in his crotch area, and telling me to come get them. And I really wanted to leave because of how drunk, and I knew the escalation of his anger. I didn't want to be there when it was at its peak. So I tried to take my keys from around him because he kept taunting me to take my keys, come get your keys. And so I attempted to go and get my keys. And so he ended up getting a butcher knife. And I had an opportunity to call Brian to come and help me, to please come pick me up, to come get me. And of course, he brings my son with him. And so I'm in the parking lot asking Brian to please help me get my car keys away from him, and there's neighbors, and it's a scene at this point. And George comes to the doorway of my townhome wielding the butcher knife, saying that, do I curse? That no one's going to take her fucking keys, no one's gonna fucking come into this house, and he's waving the butcher knife. And I walked up to him, and I just wanted to leave, and my little son, who was, I believe, 7 or 8 at the time, just is screaming, give mommy her keys, give mommy her keys, let her leave. Brian was even trying to negotiate with him, saying, please, you know she'll come back, just let her leave. So I went up to try and take the keys from him, and he was pulling on them, and I ended up pulling harder, and he pulled them back again to try to pull me in the house, and I pulled them even harder, and it ripped my finger. And at one point, I had lost the fingernail, and the tip of my pinky was severely gashed.
Judge, I'd like to offer this to the evidence.
Okay.
What was it pre-marked as, Counselor?
Looks like S, but Madam Clerk may have to.
What was pre-marked as defense S will be received into evidence without objection as defense 4.
Ms. Boone, for the jury's sake, is this the picture you're referring to? Is that the nail, or was it on, still on?
I believe so, yes.
Now I'm showing you a composite identification L, 2 photographs. Can you look at those photographs and tell the jury what they are?
I wanted to eat, and while he was drinking, went and made myself, as quickly as I possibly could, a microwave bowl of, I believe it was broccoli and cheddar soup. And I didn't get it out enough time, and he came up behind me and he slapped it out of my hand. And it was a 2nd-degree burn. I went to the hospital for it.
Are those fair and accurate depictions of the injury, the burn to your thigh?
Yes.
We'd like to offer identification L into evidence.
No objection.
What was pre-marked as L will be received into evidence without objection as defense 5.
Permission.
Yes, sir.
You had to go to the hospital as a result of these injuries to your thigh?
Yes. It was
Okay.
extremely
Is this-
painful.
Is that a depiction of the burn?
Yes.
Is that your thigh
Oh my God, yes.
and your knee?
Yes.
All right, I'm showing you composite exhibit for identification K, 4 photographs. Did you look at those, all 4, before commenting? This is a longer story, isn't it? Go ahead and tell me.
So, George stabbed me in my leg. I almost bled to death.
All right, well, let's go back and explain what led up to that.
I thought it would be nice to cook a nice steak dinner. We don't have 2 nickels to rub together, so I thought it would be special to make a steak dinner and make potato and go above the normal whatever's left over in the refrigerator. And so I spent a lot of time doing that, and George was drinking the entire time, and on the back porch.
You were drinking as well, were you not?
I was drinking. He was on the back porch while I was in the house and I was cooking. And it was one of those where maybe if I start making dinner now, it will be over at a particular time and we can go to bed at a reasonable time. And I even put it in the bedroom and had a movie set up for us to watch. So it would just kind of be dinner in bed. And then he came upstairs and saw that I had made the steak dinner, and I don't know how to describe how drunk he was, but it definitely was not George. And had him come lay on the bed, sit on the bed, and, you know, put the, I got the dogs out, and I presented him with the steak dinner, and sat down and was getting ready to start playing the movie. And he starts being very rude and cursing the steak and finding fault with it. And then, you know, I'm having to encourage him to eat. You know, if you want me to cut it up for you, I will cut it up for you. Did you want some more sour cream for your potato? What can I do to make you happier? And then he started to pull on me and kept saying that, excuse me, that I just want to fuck you on the steak and fuck you on the potatoes. And I took offense to that, and I kept trying to encourage him to eat. I started to
Was
eat.
this just him really drunk and saying nonsense?
I don't know why he was so angry that day. I don't know if it's because I got steak. I don't know. Most of the time, I don't know the reason why. I couldn't take it anymore. Obviously, I was not going to be able to eat, so I started to crawl off of the bed to leave, just the bedroom. And he told me again that I'm not going anywhere, and he stabbed me in my leg, and it crunched. You could hear a noise that it made, and blood just started to come out of my leg, just like a fountain. So I got off of the bed. He's starting to freak out, and grabbed me a towel. I got a wet towel, and I'm sitting here holding the towel, and it's increasingly becoming even more and more saturated by the minute. It's just minutes. So I'm going through towels, and I said, George, I think I need to go to the hospital. This is not stopping to bleed. This is serious. And he got on his knees and begged me, please don't call the police. Please don't call the police. Please don't call the police. And inevitably, he went and got my car keys and put them around his neck again, and my cell phone. So I was not able to call anyone, and I wasn't able to leave in my car. So I figured I would just go downstairs, and I'm just going to go downstairs. And I had propped my foot up on the glass table that we had, and blood is just everywhere. Blood is everywhere. I can't keep up with the amount of blood, and I'm starting to feel very weak and really weird. And he comes downstairs, and he's still begging me, please don't call 911, please don't call 911. I kept telling him, there's something, this is serious, this is something. Because he knew that he would probably get arrested or something bad would happen to him. So I couldn't take him anymore. He was just all over me, and just, I'm bleeding. I'm bleeding very badly, and he's having me try to console him. And I kept telling him, please, I need to call 911, please. And I said, okay, just give me a moment. And I crawled upstairs to my son's bathroom, which is the furthest bathroom away from everything. And I remember holding onto the sink. And I looked into the mirror, and my lips were blue. And I knew I needed help. I needed help. And he came upstairs looking frantic for me, calling my name, and then I turned to him and I said, please, I'm going to die. I've lost a lot of blood. There's something wrong. My lips are blue. Please, we don't have to call an ambulance. If you could just take me, I'll drive whatever I can do, please, to go to the hospital for this. And he said that before anything happens, I had to concoct a story in order for him to not be arrested or be in trouble when we did inevitably get to the hospital. So I'm sitting there with this blood-soaked towel with blue lips, trying to come up with a story of what I can tell them when I go down there so he's not in trouble, and telling him that it's okay. And I came up with the story of that we were sword fighting silly after drinking with our steak knives, and he accidentally punctured my leg. And from there,
How did you get to the hospital?
originally, he told me to drive, and because of the amount of alcohol that he drank, and I couldn't. So, he got into the driver's seat and drove me, and the entire time he's barking at me to make sure that I get the story straight. We're sword fighting, okay? We were drunk,
Did you go to
being
the
silly.
emergency room?
Yes,
All right, and did you get treated there?
yes. I was bloody, and
All right, let me show you the photograph. Can I show you these? All right, is this a fair and accurate depiction of the injury to your leg?
yes, I had to go to 2 different hospitals for it.
And you lied to medical personnel about how this happened?
Yes, they brought in sheriffs and everything.
Was it consistent with, they brought in sheriffs? Did you have to answer to the law enforcement officers?
Yes,
Did you stick with the story that you and George had agreed?
I did.
Judge, I'd like to offer this composite exhibit.
What was pre-marked as K will be received into evidence without objection as Defendant 6.
All right, I don't want to cast aspersions on people who claim battered spouse syndrome in general, but we now have to take this woman at her word that she went to the hospital on this particular occasion after her live-in boyfriend had stabbed her in the leg maliciously, even though she told the doctors at that time that they had been sword fighting because they were drunk. She told the sheriffs that showed up that they were sword fighting because they were drunk. And she's now telling this jury that even though we have these games that we play with each other, even though we have this, we play hide and go seek, and when he hides in a suitcase, it's all fun and games when I zip him inside of a suitcase, that it's not plausible that we were actually playing a game of sword fighting while drunk and he accidentally stabbed her in the leg. But we can never hear from Mr. Torres as to whether or not they were actually playing a game at that point, much like they were playing on the night of this particular incident. And while I've got this pause, just momentarily, I cannot get this this blood alcohol content thing out of my head. It seems like such an overt lie on her part. So I just want to, again, I couldn't find a chart, but this is Wake Forest blood alcohol calculator. That's Wake Forest. It's a university. A male of 100 pounds who drinks 40 shots. That's how many shots of liquor are in a handle of vodka, 40 shots over a 24-hour period. So hours drinking, 24, has a blood alcohol content at the end of that 24-hour period of 1.46. Now, at 0.21 to 0.4%, Wake Forest says, please get help. Get help because you feel lost, confused, disoriented, sick, dizzy, exhausted, or angry. And this is we're an entire point higher than the upper limit of get help. And this is the lowest one I found. There's 3 blood alcohol content things. This is from calculator.net. They say you'll be at a 1.56 blood alcohol content over that period of time. It'll take you another 104 hours to reach 0%. And finally, we have American Addiction Centers who say you're probably, let me blow this up for you. You're probably not reading this because there's a good chance you're unconscious. This BAC indicates alcohol poisoning and there's a very serious risk of long-term damage or death. If you or someone you're with are at this BAC level, you should seek immediate medical assistance. They say you'll be at a 1.7% blood alcohol content over that same period of time as a 100-pound male, having consumed over that period 40 drinks. Just wanted to point that out to everybody. If you were at all confused about whether or not she was lying about that particular story, he'd be dead. Like I said, he'd be dead.
You may publish, sir.
Thank you. And is this you at the hospital?
Yes.
Is this a stab wound to your leg?
Yes. My foot.
Is this a close-up of the stab wound?
Yes.
And was that, did you hurt your foot?
No, due to the injury, I had other problems with the surgery.
Okay. But you eventually recovered?
Eventually, yes.
Do you have a scar to that effect?
I do.
Judge, can you step down and show me?
Mr. J? You may. There's a lock, sir. Out.
All right, I don't know how best to do this, Judge, because we've got this bar.
They can probably see it in there.
Is this the injury here? Looks like there's an indentation. All right, I'm showing you identification T. You recognize that photograph?
I do. Yes.
All right. Looks like you've got an injury to your lip and to your face. Do you recall this event?
I was trying to sleep, and
Have y'all been drinking?
I'm not sure. I know that he had been drinking. This was one of the instances where I would go upstairs to try to go to sleep. And
But
he-
y'all drank together a lot, did you not?
Sometimes, yes.
But there were times where he wanted to stay up and continue to drink and you wanted to go to bed.
Many times, yes.
You were done, he was not.
Correct.
Was that one of these times?
Yes.
So tell us what happened.
I'm sleeping in the bed, sound asleep, and he comes into the room and grabs me by my hair a lot of the times. And from here, he scratched me from trying to grab me, and then grabbed my hair and pulled me off of the bed, and then raked my face across the carpet. These are carpet burns.
To your lips?
Yes.
What about to the, looks like the eyebrow area?
That's from where he, from grabbing me, scratched me and got a hold of me by my hair.
Why was he mad at you?
Because I wasn't downstairs with him
He wanted you to be drinking with him?
all the time.
All right, I'd like to introduce identification T in evidence.
What was pre-marked as T will be received into evidence without objection as Defense Exhibit 7.
Oh, permission, Paul.
You may, sir.
All right, you see the injury between the eyes and the injury to the lip,
Yes,
as you described?
yes, and then the blood going down my eye, yes.
Showing you what has been marked State's exhibit for identification, or defense exhibit. You for identification? describe that photograph?
I can.
Go ahead.
This was the first time that I ever called 911. George and I had gone to a bar across the street within walking distance, and at some point, I asked a guy, or he asked me, somehow or another, it was over a cigarette. And he left, and I didn't know where he went, and the bartender said, oh, he left. He took your car and he left. So,
Why would he do that?
well, I found out when I got home, it was because I spoke to another man. And so I paid the tab and I walked home, and he's sitting on the back porch with the handle of vodka, and I was walking on eggshells and terrified and kind of treaded lightly when I came in, and he acted all natural and fine. So I didn't know the reason why that he had just gotten up and left with my car. So then he calls me a whore, and then he calls me a slut, and then he calls me a cunt, and gets up and pushes me. And he pushed me with both of his hands so hard that we have this little area where our washer and dryer is, and there are metal doors that are on it. And he pushed me into the metal door. And then I fell back, and he got his knees on top of me, on my arms here, so I was pinned down, and was starting to strangle me, and hit my head up against the metal closet over and over and over and over and over it again, and calling me a fucking whore, and you're such a slut, and fuck you, and everything. And my tongue was flopping out of my mouth, and I thought I was going to bite my tongue off, and because of the amount of noise I guess my head was making on the metal door, he slid me down and got back on me, and then started to strangle me again. And it was on, we have carpet, but it's like concrete, and I was able to get my arms out from underneath and grab his throat and get him off of me. So I got him off of me, and I pushed him off, and he came up and he goes, you fucking bitch. And he stomped my face. And the next thing I know, I woke up. I obviously
Did you get
blacked
knocked
out.
out?
I'm obviously, I guess, yes. And he was passed out on the floor. And I woke up frantic, looking for my phone, and I immediately called 911.
Okay. The police arrived on that incident?
Yes, they did.
Is this a fair and accurate depiction of the injury you sustained as a result of him kicking you?
Stomping, yes.
It was a stomp?
Stomp.
With his
All I
heel?
saw was his heel.
We ask that this be identification you be admitted today.
What was pre-marked as you will be received without objection is defense 8.
Was that the next day, or is that a few days later?
That's a couple of days later.
And that's the bruising from the kicking of the eye?
Yes.
Now, the police were called, and we're going to talk about that in a minute. I want to go to the return. I'm showing you identification V, defense. Could you recognize that? You have to speak up.
Yes.
Can you identify that picture?
Yes.
Is that your leg?
Yes.
And is that was like the injury to your knee?
Yes.
Is that a fair and accurate depiction of the injury you sustained to your knee?
Yes.
Do you remember how that happened?
Yes.
Did you tell the jury?
I was trying to get off of the back porch, and he grabbed me and pushed me, and it was a rock or a really sharp piece of mold from him grabbing me and pushing me onto the ground, and I I guess I just happened to hit my knee just right on whatever it was.
Were y'all drinking?
Yes.
Why did he push you?
Because I wanted to get off of the back porch.
He wanted to stay out there?
Yes.
He wanted you to be with him? What's the deal with him wanting to be with you all the time?
Insecurity, I guess. I don't know. I don't know.
Did you do your best to please him?
And then some, yes.
All right, I'd like to introduce in evidence identification.
What was pre-marked as V will be received into evidence without objection as defense 9.
Now, Ms. Boone, were you treated for this, or did you self-treat? Let me show the jury now.
No, that was just, I got the first aid kit that I have for my son, and I just cleaned it up.
You what?
I said I got the first aid kit that I had for my son, and I just cleaned it up and put a Band-Aid on it.
All right, I'm showing you identification W. Defense identification. You recognize that photograph?
Yes.
What is that a photograph of?
This is a photograph of my arm.
And is that a fair and accurate depiction of the arm with some type of injury?
Yes.
Do you remember this event?
Multiple times, yes.
Well, I'm talking about this isolated event where this photograph was taken, the injury you sustained.
Yep.
Who injured your arm?
George Torres.
Do you remember this event?
Yes.
Did you tell the jury about it?
This was one of the instances where I would try to pull away from him, and I don't know how my arm started to do this, but from him pulling from this way, how hard he would pull, with me trying to struggle to get away from him, it would leave these bloody under the skin splotches.
So he wouldn't hit you sometimes, he would just grab you and pull you.
Yes, from me trying to pull away from him, that's the point of it doing this, from me pulling away from him.
Now, this is one of the many times y'all were both intoxicated?
I mean, I can't say for sure that, yes, but whenever it would happen, yes, we would be drinking.
Identification W in evidence.
What was pre-marked as W will be received into evidence without objection as defense exhibit 10. You may, sir.
All right, it doesn't look like a wound or anything.
Objection, commentary.
Sustained.
Tell me, I'm sorry, tell me, you said it's just from the grip, him losing his grip?
Yes, it would be from me pulling away from him, and whatever under the skin it was that it was disturbed from the amount of pressure of him holding and then pulling from me would create those on my arms.
Okay. I'm going to show you Defense Exhibit X for identification.
Yes.
And what is that a picture of?
This is a picture of my ear, the side of my head.
Is that a fair and accurate depiction
Yes.
of the injury you sustained by Jorge Torres?
Yes.
Do you remember this event?
Yes.
Were you drinking?
I at the time was not drinking.
On this event, you had not consumed any alcohol.
I mean, I may have earlier. This was another, I was in the bed trying to sleep.
Where was George?
Downstairs drinking.
All right, and so you were wanting to go to bed, and he wanted you to stay down there with him?
Yes, I was in the bed.
All right, tell the jury what happened on this event.
I believe this was the instant where I was in the bed and I used to barricade the door with our dresser.
Why
which-
didn't you just lock it?
All of the locks were broken in my home.
Why?
They were from George taking them in, including my son's. At one point, I could seek refuge in my son's room, but he broke that one as well.
Well, tell me, explain how that happens. Tell the jury. We can't read your mind.
George wants me which he has told me numerous times that I am to be with him at all times and doesn't like to be apart from me or away from me. So whenever it was even just to go to the bathroom sometimes, he would go with me. And you have to understand, I have a 2-story, 900 square foot townhome, so there's not many places to go. So it just happened to be that it would be upstairs or downstairs, or I'd be in a particular room or not. So inevitably.
Did you want some time away?
Yes, I did. Even if it were just him upstairs or me downstairs or vice versa.
So I wanted to put this this comment from earlier up here because she's now testifying that on this event that she recalls, she went to bed, he was downstairs drinking, and he apparently comes upstairs and begins his attack. She also testified that when she went to bed on the night of the incident, on the night that George died, she thought that he could extricate himself from the suitcase, and she did not intend for him to die in the suitcase. If she really thought that he could extricate himself from the suitcase, and she really thought that if he extricated himself from the suitcase, he would kill her, why did she go upstairs and go to bed? Why not continue to monitor the suitcase or leave the house or do any number of things other than go upstairs and go to bed? If he has a prior history of finding her in the bed when she's trying to sleep, why do that? It doesn't make any sense.
So I rarely got to sleep. This was one of the instances because I had barricaded the door with our, 200-pound dresser that we had. And then I had my nightstand barricaded up against the bed, to where it was even more difficult from the prior times of him breaking in. And he would, I don't know how he would ever do it, but he would get himself in through the crack of the door that he would be able to wedge the dresser in the nightstand. And he pulled me out of the bed and told me I was going to die. And I believe it's this incident, and punched me, and
Punched you in the side of the head?
yes, in
Was
my
it-
temple and everything.
Was it an open fist or a closed fist, or do you know?
It was fully closed.
Like identification X introduced into evidence?
It was pre-marked as X, will be received without objection as Defense Exhibit 11.
Part I'm showing you this exhibit. That's you? Did you get any treatment for that? Medical treatment?
I know the police came, but I don't remember. I remember it hurt for a good solid 2 weeks after that.
Was this one of the incidents where the police were called?
Yes.
Now, do you recognize this photograph, which is identification Y?
Yes.
Was that the date of the incident? The date of this event?
No, it happened prior. But this picture that was taken of the,
This picture was taken, would have been taken February 24th of 2020?
yes.
And do you recognize that as your close-up facial? Significance of this picture?
Again, because I was sleeping, George was upset with me and came in with a metal curtain rod and bent it and snapped it in half and then crunched me in the forehead with it. And it started to beat the furniture that was in the bedroom. This is probably a good month before, or after it had happened, before I really do believe that I should have gotten stitches, but I was not allowed to go to the hospital.
Judge, I'd like identification why introduced into evidence.
It was a gash.
What was pre-marked as Y will be received into evidence without objection as defense 12.
Is that the same curtain rod that you mentioned in the 2-hour interrogation video?
Which they didn't take, yes.
This was photographs that were taken, I guess it would have been the crime scene? Was it the crime scene investigator that came out and took photographs?
I don't remember who it was, but yes, someone did on the day of the incident.
Was it different from the extraction, the phone extraction expert? Was it somebody different?
I think.
But is it this wound right here?
Yes. And remember, that's a month later.
And then on that same date, they took, same time, they took this photograph as well, which is identification R.
Yes.
All right, and what does that do?
I believe it's from holding the baseball bat, and
Is that an injury to your hand?
it's a bruise.
Was that taken, February, was it February 23rd, 2020, when the investigators came out, when,
February 24th, I believe.
February 24th? Okay. I'd like to introduce identification law to the evidence.
What was pre-marked as defense R will be received into evidence without objection as defense 13.
Judge, can I publish?
Yes, sir.
All right, this is not a great photograph, copy of the copy. But February 24th of 2020, is that what you were wearing? Is that you?
Yes.
Okay. And there's some discoloration up here of your palm. You see that?
I do.
Is that from you jabbing him with a baseball bat?
Sustained.
Do you know how you suffered that injury?
I believe it's from holding the baseball bat.
When you poked him with it?
Yes, trying to get his hand back in.
I'm showing you defense identification N. Just like 5 photographs. Can you look at those? See if you recognize them. All right, well, let's in now.
Yes.
And are those fair and accurate depictions
Yes.
as a composite of the events that occurred in relation to Jorge Torres and your TV?
Yes. Yes.
All right, are those stills of a videotape that you took?
Yes.
And is that videotape, was it on your phone?
Yes.
So when law enforcement seized the phone, they would have had access to this video?
I believe so, yes.
And tell me about it.
Lucas liked to watch cartoons and play video games on the big screen, which is this is the big screen, and I would have to call Brian to come over sometimes to help me figure out the Fire Stick and whatever platform or whatever it was that Lucas was trying to view his shows and video games on. And I don't remember how George found out that Brian had come over. I believe because it was actually fixed and he knew that I didn't know how to do it. Found out that Brian had come over to fix it, and
Was he jealous of Brian?
I don't know if he was jealous of Brian. I think that he had a fear that I somehow would go back to Brian. So I think by Brian helping me with things for Lucas, he just didn't want him to be interacting with me at all.
So Lucas wasn't over here this day, was he?
No.
Brian wasn't over here this day.
He may have been, I can't remember when he actually fixed the television for Lucas.
But y'all were drinking this day.
I know he was for a fact, yes.
Chances are you were.
Probably so, yes.
Okay.
I would agree.
So how did it end up badly?
He accused me of sucking Brian's dick and told me that he was going to break my face with the bat, and that he was going to make me unrecognizable to my son with the bat. And then told me that he's going to destroy my fucking television, and then I was going to remove it from the apartment. And if I didn't, I was going to be, again, unrecognizable to my son.
So did he grab the bat?
Absolutely, he already had that in his hand, and he told me that I had to videotape it.
Did you videotape it voluntarily? All right, but there is a video, but I'm going to go ahead and ask Judge if I could introduce this identification of these 5 photographs into evidence.
Objection. Is it O or N?
I have O being a composite with 5 photos, and not having a single photo.
We're moving in O, okay. All right, what was pre-marked as O will be received into evidence without objection as defense 14.
All right, so these are some stills from the video. This was George, that particular day, holding the bat.
Yes, telling me that I'm going to take the television out once he destroys it.
He wanted you to take the television out?
That, or I was going to help him, but either way, I was taking it apart and removing it.
And what is this picture of?
In the process of him destroying my television.
While you're videotaping?
Correct.
Is that the result?
No. After that, he ripped it off of the TV stand.
Did he later pass out?
Yep, like he usually does.
What's he drinking then?
I don't know. Vodka and something, I'm sure.
I'm showing you identification N. See if you recognize that.
It's my living room in the stairwell.
All right, were those, was that a photograph taken by a crime scene?
Correct.
Is that a fair and accurate depiction of your living room and stairwell?
Yes.
And I'm going to try to introduce this as identification 9 as an exhibit.
No. It's pre-marked as M, correct?
It's got N.
N, I apologize. was pre-marked as N will be received into evidence without objection as defendant's 15.
Can you tell us a little bit about this room?
This is my living room. This wall that we have over here with the hearts, that's where we would display all of our artwork. We were in the process of taking it down to add more, so he could continue to be entertained. The bookshelf over here is my son's bookshelf with all of his toys and little guns and musical instruments. He's got his little karaoke machine down here, his guitar. The stand right here with the red bucket on it, that was the television stand. And then my back porch area and the dog bed here.
Okay. And then looks like in front of the bookshelf at the foot of the stairs is that a doggy?
It's a baby gate, but my dogs would wander upstairs sometimes and go to the bathroom sometimes when we couldn't get them out. So I would, at nighttime, or whenever we weren't home, make sure that they didn't go upstairs. And plus Penny was blind.
There's an allegation that you pushed George down the stairs
Apparently,
or got him in the suitcase upstairs and pushed him down the stairs?
supposedly,
Did that occur?
absolutely not.
Is that bookshelf disturbed in any way?
No, nor the plant next to it.
I'm showing you composite, 2 photographs, identification M. Did you look at those two and see if you recognize them?
Yes, this is me sitting on the back porch with my dogs. And as you can see that we are both drinking.
All right, who's taking the picture?
I'm guessing George's, or maybe it's one that Lucas, Lucas wasn't over here, so it had to be George.
How can you tell y'all are drinking?
Because there's a cup here and then he has a beer.
All right. And there's 2 dogs, there's one sitting next to you. Who's that?
That's Penny, she's the blind dog. I used to have to pick her up to put her somewhere so she would stay there because she was unfamiliar with the area, especially since we moved from my marital home to the townhome. So most of the time Penny would be close or next to me.
Who's next to the film?
This is little guard dog Tess. She was the deaf dog. And this is the fence here.
Well, I'll show them.
Okay, but this is Tess, and then this is deaf, blind. Penny and Tess.
All right, and then the second one.
This is Tess on the back porch, taking a nap. She was never far from me.
All right, when George was sober, how did he treat the dogs?
Nice. I don't know if he was a pet person, but I mean, he was nice. If I needed him to feed them, he would feed them.
Were there times when George was drinking where he would threaten to harm the dogs?
All the time.
All right, you're going to have to tell the jury specifically.
One of the worst threats was Penny being blind. He would actually leave the gate open in the back. He wouldn't threaten me to do it. He would actually do it on nights that I had to go up to sleep or I fled the night before or something. And would tell me that he hoped that I would come back and find her bloated body dead in the pond across the way from our townhome. And Tess was notorious if I wasn't there to go look for me, and would say that he would hope that I would have to scrape up her dead body from the street that was out in front of our apartment complex.
Why was George upset with you? Why would he threaten to harm the dog?
Anything that he could get to try to have some type of hold over me.
Control?
And he knew I loved my dogs very much, especially that they were handicapped.
Were they afraid of him?
And yes, Penny would hear his voice and instantly go underneath the dining room table that we had. Tess was always fractious and very, very quick with his movements, but she was never far away. They never showed their teeth, they never growled. Tess would occasionally bark, but it was very rare. And he used to kick them and just,
For what reason would he kick them?
Penny would try to find me because she's blind.
Speculating in the mind of a dog.
Sustained.
I'd like to move identification M in the evidence.
Any objection? Was pre-marked as M will be received into evidence without objection as defense 16.
All right. Can you describe this for the jury?
This is again, is our back porch, and this is the fence that I made for the dogs to have a little bit extra space. Penny is next to me. She's the blind dog, and then Tess is down here at guarding the gate.
Are these fake rabbits? Is that
Yes.
in here?
I used to call my son when he was a baby. He was my bunny rabbit.
Sexual relevance?
Overruled.
He was my bunny rabbit, so I used to collect bunny rabbits, and so I have rabbits here and there throughout my house and in my little garden area.
All right, this is the alcohol you are consuming,
Yes.
and this is a close-up of which one?
This is Tess. She's the deaf dog.
How old were these dogs at that time, 2020?
Gosh, maybe 9, maybe 10.
We approach.
Yes. Y'all can be seated. Thank you. If Ms. Boone needs to use the facilities, we might as well take advantage of that at this time. All right, court will be in recess till 4:20. Thank you.
All right, so we've got a recess here. So what do you all think of this testimony so far? She is putting forward a lot of evidence of domestic violence. So here's my big problem. My big problem with this entire thing is she had to be in fear of imminent violence before she committed the act that caused him to die. The defense is saying that the act that caused him to die is her failure to act in removing him from the suitcase. If I'm the state, I position it differently and I say the act that caused him to die was her zipping him in the suitcase. Everything after that doesn't matter. And she's testified already that up to the point that he got in the suitcase, she wasn't in fear. She wasn't in imminent fear of anything. So there was nothing to defend herself from. So she said she came down the stairs. She zipped up the suitcase immediately upon coming downstairs and noticing that he was hiding in the suitcase. She zips up the suitcase, and upon zipping up the suitcase, they started joking with each other. Now, the defense is saying that them joking with each other was consent. Well, even if we take that and say he gave consent. Let's go down that rabbit hole. At some point before he withdraws his hand from the suitcase, excuse me, before he withdraws his hand from the suitcase, he withdrew consent because he's on that 2-minute video saying, Sarah, let me out. I can't breathe. Sarah, let me out. I can't breathe. So if he withdrew the consent at that point, well, she still was not at a point where she was in imminent fear. Because she said the point of imminent fear was when he was punching his way out of the suitcase, when he was getting out. Then she began to fear, right? So that's kind of contradicts what they're saying. So if I'm the state, that's where I push at. These photos are a lot of new evidence, though. And granted, I'm here in the chat and I'm saying that we don't have George's side of the story at all on this. We never will. But based on all of these pictures, is this enough to convince one juror, that because of the history of domestic violence, coupled with her fear, her imminent fear at the time, that's enough for an acquittal? What do you all think? Let me know. What do you all think the jury's thinking about this? Do you think anybody is buying what she's saying? So we're here on the outside looking in. We have a couple of advantages. We have we can pull news articles. We can pull a bunch of stuff. We can hear what's going on in the colloquies between the court and the attorneys. The jury doesn't get to hear any of that. So we naturally have more information than the jury has. All the jury has is the evidence at this point. Is there one juror? Is there one juror at this point, as we sit here today, right now, before cross-examination or anything, is there one juror who says this is enough? So Celine says yes. I don't know if that's in answer to my question or not. Let me know, Celine. But she says yes. Natalie says, I think those pictures definitely got to some jury members. So her story about getting stabbed in the calf, that entire story, and the pictures, and then the demonstrative, right? She essentially used her leg and the wound on her leg as a demonstrative to show that this caused permanent damage. I think that was impactful. Miss Carroll says, I believe that at least one juror will be affected. Yeah. The chances that there's one juror there, we don't know the makeup of the jury. We could find out how many males and females there are in the jury, but that's about all we would be able to find out. We don't know what these jurors have been through, who in their families might be victims of domestic violence, whether any of the jurors are victims of domestic violence. But the chances that somebody is believing her at this point is pretty good, right? Celine says one juror or more will believe her. Gentlemen, what do you all think? We've heard from Celine, Natalie, and Carol at this point. Natalie says that each DV survivor has their own reasons for staying in a relationship. We don't have George here to share his side of this DV relationship. We don't. We don't. We're likely going to get some of that, at least as much as we can, on cross-examination. But you saw somebody had already commented about the 2018 incident where the police were called out and there were marks on George's neck. And you already saw how the defense and the defendant tried to combat that in the direct examination. She basically said that George was on top of her and she was pinned down and she, forced her hands out and grabbed him by the neck and threw him off of her. Now, what happened after that I didn't really understand, because after she threw him off, then he stomped her and she passed out. But then when she woke up, he was passed out. I'm confused as to how all of that happened. And it didn't really, that chain of events after the fact didn't really jive with what I would think, how I would think that those events would have played out in real time. But she did at least make some attempt to deal with the fact that she knew the police had these photographs of the marks on George's neck. So it's possible that that's all that the prosecution has. I don't know what they have, what instances they have of domestic violence. But remember, a lot of those initial witnesses are subject to recall. And the reason that the prosecution gave for them being subject to recall was we have to be able to recall them in the event that Ms. Boone takes the stand, and we have to combat whatever testimony she gives. So some of those people might be witnesses to some of these domestic violence, in some of these instances of domestic violence. Natalie wants to know if George's cell phone can be used as evidence, if there were pictures in his phone. So the short answer is likely yes. So they would have to get past a hearsay objection. So they would have to have someone introduce those exhibits. The person introducing those exhibits would have to be able to identify those photographs. Now, it is possible that the police department can identify the photographs, can identify that the photographs were taken from George's cell phone, but her pictures were of her, but you couldn't tell that a lot of them were of her because they were pictures of specific parts of her body. So without her being there to say, that's me in that picture, those pictures would be inadmissible. Here you're asking, can George's pictures, if George took pictures of himself, would they be admissible? If they can be authenticated by someone other than George, assuming that he took those pictures using his own cell phone like she did. And the only way that I could think that would be possible is if there is some identifiable mark. So let's say he takes a picture of his arm and there's a tattoo and a wound from domestic violence. If someone can come in and say, that is George's tattoo, it was on him when he was in the morgue, and that, then we can kind of authenticate that this is the person and that wound was there. But then we run into the problem of someone has to then testify that those pictures that were taken were taken after an event of domestic violence perpetrated by the defendant. And who's going to come in and say that? So essentially, because of those hurdles, the likelihood of these of cell phone pictures from George's cell phone being brought in are slim to none. It's possible. The most likely scenario where such pictures would be brought in is if he had someone else use his cell phone to take the pictures, and that someone else had been told why they were taking the pictures. And of course, the why would have to be because my girlfriend beat me up, right? So it's possible, not likely. The evidence is likely going to come from whatever the police have, or if he went to a hospital or some other care provider. Carol says it is possible if he took pictures and sent them to any of his family members, they could produce them. Well, yeah, but they're not. If so, the hearsay problem is they then have the pictures. But if the pictures are being submitted into evidence for the truth of the matter asserted, then the matter asserted would be not only does he bear these wounds, but that they were inflicted by the defendant. And that's the problem with hearsay in this instance. So who's going to testify as to that being the case, that she inflicted these wounds on him? And I can't see someone who would be able to say that. The best we could do is somebody having taken the pictures immediately after this happened. And thus far, I haven't heard of anybody being present during one of these instances of domestic violence. Jeff seems to be a little behind. Yes, great level-headed judge. Yeah, he is a very level-headed judge, Jeff. And Celine agrees, and Natalie agrees. The judge is great. So he's probably back where the comments are just where we were talking about the judge earlier. But with respect to the pictures, I doubt we're going to see pictures from his cell phone. But again, it is possible. And for those of you who may not have been here before, I'm not a criminal defense attorney. I'm not a criminal attorney. I do civil law. The evidence rules are the same for the most part, but there are some differences, and we don't run into instances like this where you got a dead person and you're trying to put in pictures that were taken by the dead person. We don't often run into those types of scenarios. So how to get around those types of scenarios, I kind of have to think on my feet with respect to that question. And there are very few ways I can see to get around those types of things. Now, what we could have is we could see instances where they date stamped the pictures from his cell phone and don't offer them as they line up the dates. So she took this photo of herself at this date and on this time at this date, at this time on this date. That's how you say that. He took a similar photo of his self at about the same time on about the same date. And so if she's saying that this was a result of DV, it's possible that this is a result of DV, but you still run into the problem of somebody has to link that together. And without somebody linking that, it's kind of difficult. I could see a way that you could bring it all together, but again, the best way to do it is if someone else took the photos. Any guys present want to give us a your indication of whether or not the jury or any member of the jury is buying any of this DV stuff, and whether that's enough to get him off. Natalie said she was comfortable enough to take a picture of him with a baseball bat smashing the TV. She wasn't that scared. Right. And she wasn't even scared enough to zip him up inside of a suitcase when he was drunk. You know, Jeffrey, I was thinking the same thing when that picture was shown. It looked like she darkened. If there was I'm not saying that there wasn't a black eye there, but it did look like before she took the picture, she darkened the area that was affected with makeup. It did look doctored to me. So yeah, I agree with you there. And yeah, there you go. It doesn't link back to the imminent threat. Yeah. If I'm the state, I pushed back a lot, and I was sitting here. I was looking for what jury instruction they were likely going to be using with respect to this defense, and depending on the wording of the jury instruction, because I'm not a criminal attorney, there's a whole lot of self-defense jury instructions that are standard in the state of Florida based on a whole bunch of different circumstances that I'm not intimately familiar with, but some of them are broken out into so many subparts that it is likely that the jury would convict if certain of those instructions are given. But if I'm the state, I am pushing for if the standard doesn't say something to the effect of, before the first overt act by the defendant that led to the death of the decedent, there had to be some threat of imminent harm to the defendant in order for her to establish this defense. Was there such a threat of imminent harm? And if I can get a jury instruction that looks something like that, or some reading of the law that looks something like that, then in my closing statement, what I'm going after is her zipping him in that suitcase caused the death. And at that point, I think that's the best I'd be able to do to overcome this defense. Jeff said, I haven't woke up close to noon since my teens. Yeah, it's been a while. Does the Torres family have a civil case here? Even if they do, what are they going to get? She has nothing. She's broke. So the civil case is yes. The answer to your question is yes. But in a civil case, in order for an attorney to take it, there has to be some indicia that there's going to be a payment at the end, because they're likely taking it on a contingency basis. If they're not taking it on a contingency basis, then the Torres family would have to pay. And nothing that we've seen here indicates to me that the Torres family has the wherewithal to pay for an attorney to take on such a case. And there's absolutely nothing indicating that Sarah Boone, if she has any family left, has the wherewithal to pay any verdict that they get. So any judgment that they get. So I doubt that there will be a civil case. Jeffrey says, never in the jurisdiction of the solar system. That's a pretty all-encompassing jurisdiction. Will there ever be a reasonable self-defense of reasonable use of force on a man who can't move or breathe? And yeah, so that's kind of my problem. The point at which she says she was in fear, he had previously told her, I can't breathe. Let me out. I can't breathe. Let me out. I can't breathe. And she later on, during that 11-minute period that we have no evidence of what happened other than her testimony, and she is not credible at this point. But other than her testimony, we have no idea what went on during that 11-minute period. But sometime during that 11-minute period, she was somehow placed in fear. But before that, he's already saying, let me out, I can't breathe. And she left him in there. Left him in there long enough for her to develop this fear. So she initially zipped him up, and then she began the process of not letting him out. She began that process that the defense is relying on, which is the failure to act. She began the process of failing to act at the very latest during that first 2-minute video, likely before that first 2-minute video. And between the initial act of zipping him up and that initial failure to act during that 2-minute video or before, that's what caused the death. Her fear that came about later on should not matter in my head. Yeah, and it definitely doesn't help that during that 11 minutes, she starts beating him with a bat. Doesn't help. Doesn't help at all. And this is the same thing that we were saying yesterday. At the scene of the crime, we saw the body worn camera footage. No tears. She had that emotional roller coaster, the act going on. Now, this is the man that she's testifying that she loved, that she had this connection with that surpassed the connection that she had with her husband, the father of her son, who she was with for a much longer time than she was with Mr. Torres. Her connection with this man was greater than that. Greater than the ex-husband that she calls all the time and texts all the time. The one who she called first when she was faced with this dead guy on her floor. Greater than that connection. But no tears. No tears when she was being interrogated at the police station. No tears here. And even if there are no tears, she doesn't even seem without tears like she's sorry, like she's... There's no remorse here whatsoever. I don't know. I don't know, people. I'm sorry. It looks like I had this thing on pause this whole time. So once again, we're behind. My bad.
Jury entering.
Mr. Owens, you may continue your inquiry, sir.
Just based on the court statements, identification A, this is one of the photographs that we introduced. Is this injury to your ear?
Yes.
And then this is your living room. This is identification C, the blow up.
Yes.
Identification D. TV. Identification E. Is that your arm?
Yes.
Identification F. Is that your knife wound?
So Jeffrey, if it's, if I'm the state, I don't even try to prove that it's a Photoshop. It's a waste of time and resources because if it's Photoshopped, the in answer to your question, then what? So it's Photoshopped. Does that mean he didn't that she didn't have a wound underneath the makeup? Probably not. She probably had it there and she just kind of doctored it up a little bit. So it doesn't really get you anywhere. And then but it does draw attention to that incident. And my ploy here is not to draw attention to the incident at all. The prior incidences for me are a sideshow. This is all a sideshow because she zipped him in the suitcase before she was afraid. So that's where I would go with my case in chief at this point.
Identification G. Is this the curtain rod?
Yes.
Identification H. This is the eye. Identification I. See your face shot
Yes.
with the lip and the eyebrow. Identification B. And this is the back patio with the dogs.
Yes.
Okay, I'm gonna bounce a little bit, Ms. Boone. Let me go back to the night earlier in the evening when I think y'all may have been out on the back patio and you had suggested to George to call the children, but then I think, did he call his brother or his brother called George? Do you remember?
George called his brother.
Okay. And you made a statement about tell him something. Explain that to the jury.
I told him to tell his brother about you choking me the other day. This is a separate choking incident. We had been drinking, and I wanted George to tell him, but he didn't tell him, so I said it in the background, so he would be aware.
What did you tell him?
Tell him why you choked me, or that you choked me.
Okay. Now, You heard the testimony of the two neighbors, the boys that lived next to you,
Yes.
and you heard that they were actually questioned. I think the audio, they were audio interviewed. You heard from Detective Copsel. I think it was a couple of days later on the 25th of February, or 27th of February.
Yes.
And you heard their testimony earlier this week,
Yes.
where they hear a kind of a thumping sound starting at the top of the steps, ending at the bottom.
Yes.
Have they got the night wrong?
Yes.
Explain to the jury that.
So it was the night before. Again, I was sleeping, and in the middle of the night with the door barricaded, he came in and ripped me out of the bed. And first got me with one hand, and then got both hands and pulled me completely off of the bed. And then, like a caveman, had my hair like this and was going down the stairwell, taking me with him to come downstairs so I could sit and drink with him.
Do you believe that's the noise that the two neighbor boys heard,
I absolutely do.
and it was just the night before?
Correct.
Now, some of the time when this abuse occurred,
So, with respect to the noise that the neighbors heard, I don't know what it was, but I do think that the defense did a good job of pointing to the picture that was taken by the investigator on the scene of that bookcase, pointing out that that bookcase was undisturbed. I doubt that this lady would have cleaned up after the bookcase, cleaned up all that stuff on the bookcase had she tossed George down the steps and he, knocked everything over. So I thought that was a one good thing that came out of his examination.
you called the police,
Yes.
and other times the police were not called.
Correct.
I want to refer to you the first time, I believe, you mentioned the 911 call. I believe that was July 25th of 2018.
Yes.
And that was the incident in which George had kicked you in the eye,
Stomped me, yes.
stomped you in the eye, and you had grabbed his neck.
Yes, I was able to get my arms out from him pinning me down with his knees and grab his neck.
So law enforcement came and investigated,
Yes.
and both of you were arrested.
Correct.
You recall asking the officer when you were arrested, "Why am I being arrested?"
Many times, yes.
You recall asking the officer, "Why am I being arrested?"
Yes.
And do you recall making any other statements to law enforcement as to why you did what you did to George?
That was the first time ever that I actually officially fought back.
Did you tell the officer that you were fighting back?
There's there's nobody who can testify for George in this case. She's saying that's the first time I ever fought back. So the defense knows that this is the incident, that the police have photographic evidence of wounds having been inflicted on George. And she's saying it's an isolated incident. I fought back for the first time ever. For the first time ever.
Yes, because I was complete shocked that I was getting arrested because of it.
Now, on the 2-minute video, the suitcase video, you mentioned to him, I think you said something, I can't breathe. He said, I can't breathe, and you said, that's how I feel when you're choking me. Were you referring to an isolated incident of the night before, 2 nights before, or whatever, or were you referring to in general?
In general, the more than 2 or 3, 4 times that he had done it.
Okay. And then the part about cheating, he didn't physically cheat on you.
No, he did not.
Okay. And just, I don't want to go into a lot of detail, but what are you referring to there?
George was, I believe, addicted to pornography, and a lot of that would be found on my phone from him supposedly wanting to call about job interviews. And as a solution, I sat him down and I explained to him, to me, that's you visualizing yourself with someone else, or at least having a pleasurable moment with someone else or watching other people. And to me, I told him that I considered that cheating on me.
Okay. And so he would download that on your phone?
Yes.
How did you stay with him? You got to tell the jury.
As anyone who has ever been in love, or when you love someone, or primarily someone or something, you go above and beyond, and you tolerate and you endure and you persevere, and you try to make that person as spectacular as you possibly can, no matter the sacrifice that you may have to go through, to serve someone else in a positive light so they can be better people for themselves, and to just make them a happier person. And love is very strong, and love is very deep, and love, I believe, is not fully understood in a lot of ways for how different people react to it. And I very much, deeply, and passionately love George. I love him to this day.
Did you not want to be alone?
Beginning through my divorce, it was very nice to have him around, and he was a man to me, and I felt protected, and he's very nice, and as lame as it sounds, he used to compliment me, and it made my day. So, yes.
During that period of time, when you first started seeing George, would it be fair to say that you had low self-esteem?
Yes.
Now, we talked about this previous arrest where you told the officer you were fighting back and you got arrested. Now, I want to talk about your conversations with law enforcement, but first I want to ask you, why did you go to the police station that day when you were interrogated there? We saw the 2-hour video. Tell the jury.
The day of the incident, the detective Copsell gave me her business card with her personal cell phone number on it, and said if I happened to remember anything or anything that I would like to add to the day, for me to not hesitate to give her a call. So throughout the rest of the evening, I just something was off. I didn't feel comfortable with what she told me and how she told it to me.
How long were you at the scene?
Gosh, all day, from the moment that they were there to the moment that the coroner's van drove off.
All right, when it ended, did you stay in your home?
No, I raced inside and collected some pajamas and a toothbrush, and I went over to where my son was at my ex-husband's house.
Did you take the dogs?
I didn't even feed them, it was so fast.
All right, and then once you got over to your ex-husband's, what happened? As it relates to Detective Copsel.
Something just wasn't sitting right with me, and I had a suspicion that she just wasn't being honest with me, so I took it upon myself.
Sustained.
So you called her. Tell us about that.
I called her and I told her that I felt that she was being dishonest with me. She originally had told me that due to her being pregnant, it would just be a lot easier for her to have me come down to the station to pick up my phone. The original plan was for she and Detective Loman to return the phone to my apartment. But she said that it would be a lot easier for me to just come down and pick it up because I remember when I was pregnant. That's what she said. You remember when you were pregnant. So I said, I feel that you're tricking me, and I feel that you're being very sneaky about something, and I don't believe that you're being honest with me. And I said, regardless, I'm still going to come.
Sustained.
So you agreed to come, but you understood it was to get your phone?
Correct.
All right, you came that afternoon to the station,
I did.
and the original agreement was they were to come to you.
Correct.
All right. When you got to the station, what happened?
I thought I was just going to be picking up my phone. My car was there. I had everything in my car. It was just a regular, I'm just going to go in, maybe sign something and pick up my phone. And there's people that are over here at the windows, and I thought that I was supposed to go over there to get my phone. And Detective Lowen came down and said that my phone was upstairs. So if I would just follow him upstairs, that's where my phone was. And then I was taken into I guess it was an interrogation room, and they told me to sit down, and that then I guess the interview or interrogation began, and I just simply was getting my phone.
Sarah, tell the jury why.
Yes. You may proceed.
Ms. Boone? Ms. Boone? Tell the jury why you lied to the police.
I lied to the police, basically everyone, because I was extremely fearful of being arrested. I made the first attempt of me calling 911 by telling them what happened, and I thought they were going to help me, but instead I was arrested for calling 911.
So you made the decision to lie.
I did.
Did you stay with that lie?
I did.
Are you telling the truth today?
I am.
Now, let me take you back to the to this incident. Is it fair to say that when Jorge Torres is sober, he commits no violence against you?
No.
Is that fair to say?
Yes.
Is it fair to say that every time that he's intoxicated, or every time that you're hit by him or harmed by him, it's when he's intoxicated?
Yes.
As a result, when he's drinking, does it change your outlook?
Yes.
Could you explain that to the jury?
I'm always fearful, paranoia.
Why?
Because I try to protect and defend myself for fear something happens at the last ultimate second.
But you're always that way, fearful. Is it because of these prior incidences?
Absolutely.
Do you try to placate him?
All the time.
What do you mean?
With the puzzles and the painting and feeding the ducks across the way at the pond, listening to music, trying to go for a walk on the trail, anything that I possibly can. I told you I was running out of things to entertain him with.
Why do you think George, what bothers him?
Objection, false or speculation.
Sustained.
Does he tell you?
Objection, calls for hearsay.
Sustained.
As a result of how he behaves towards you in that intoxicated state, how were you feeling the night of this event?
Objection, asked and answered.
Overruled.
Extremely nervous, anxiety galore, just, I can never relax.
When he's drinking?
Yes.
And the state of intoxication that he was at the time of this event, is that the state that scares you the most?
It's the tone, yes. There's a lot of alarms and red flags that go on throughout the day or night or whenever it is that we are drinking.
Objection, non-responsive.
Sustained.
Tell us about that. How that does that heighten your sense of safety,
At all times.
but especially when he's drinking?
Oh, yes, all the time.
And then his mood?
Yes, it depends on what mood he's in that day.
Well, do you have like a sixth sense of how he's doing?
Yes, I knew George very well.
Objection, non-responsive. Yes or no?
Sustained.
Can you tell us what you mean by that? Sixth sense, or knew him very well?
I guess you can say that I was trained by fear with him. Just, it wasn't fun anymore when we would drink and we would hang out on the back porch. It wasn't fun anymore because I knew inevitably that something was going to happen to me, one way or another.
If I'm the prosecutor, when I get the opportunity to question her, the first question I ask is, did you tell the police anything during that interview that was the truth? And if she says yes, I go through everything she said. Was this the truth? Was this the truth? Was this the truth? Because a lot of the things that she's saying now contradict what she was saying in the interview. And I want the jury to hear just how often she lied to the police that day and exactly what she lied to the police about, because the lies are getting very numerous at this point.
Ms. Boone, you know, those bruises that we saw of him, they look pretty deep. Tell the jury what you were thinking.
From the bat, you're
Yes.
saying? I didn't want to die that night. I can't describe it to you. It's terrifying love to a certain degree, where my plan was to show him the next day, and just, I wanted him to be better and treat me nicer and be the person that he was when I originally met him, and I knew that was in him still. I knew that it could be found, and I just couldn't figure out what it was that I was doing wrong in order for it to not be back to where that was. And I was tired of living in fear and just sick all the time of figuring out how I can entertain him so I don't die, and continue a relationship with my son and try to live a normal life. That wasn't a normal life for me. And just, bottom line is I didn't want to die. I would have died, or I would have been disfigured or maimed, or if it weren't me with the bat, it would have been him, if he were to have gotten out.
That's all.
Any cross-examination?
Did George know somebody named Crystal? Did you ever mention Crystal in your text messages about being one of his bitches?
I don't know. I don't remember.
How about Christine? Did George know a Christine?
I don't know.
How about a Pamela Erickson?
These may have been people that he was communicating with on whatever the platform was.
On your phone?
I believe so, yes.
And did you find these communications?
I believe I found one or two of them from some of them.
And did you send a long letter to his family to relay to him about George and his girls that he was cheating on you with?
I believe so.
Okay, so you do know those names, right?
I don't remember them. It's been however long.
Okay. Now, on February 24th, 2020, you called 911 at about 1 p.m., correct?
Yes.
And at that point, you were still feeling a little intoxicated, were you not?
It was more shock, but yes.
So you agree that you previously stated, I was still, I believe, intoxicated to a degree?
To a degree, yes.
So 1 p.m., it's about 14 hours after 11 p.m. the night before, correct?
I'm guessing so.
Well, 12 hours prior would be 1 a.m., and then 12 a.m. is 13 hours, 11 p.m. is 14 hours, correct?
Okay.
And you were present here for the medical examiner, Dr. Zadovich, to testify, correct?
Yes.
And you heard her talk about all the effects of ethanol that it has on the human body, correct?
Yes.
And she also mentioned something that it, on average, dissipates at about 0.015 an hour. Do you recall that?
I believe so.
Okay. So, would it be fair to say that if you're still feeling the effects of the alcohol at 1 p.m., so that's 14 hours, 0.015, you were at approximately about a 0.21 at 11 p.m. the night before. Do you feel like you were 2.5 times the legal limit at that time?
I don't know how you came to that number.
Judge, I'm going to object.
Roach.
I'm going to object too. We don't have a expert here testifying as to what her blood alcohol content might have been 14 hours prior, and that's not testimony that the attorney can just make up on his own.
You may proceed.
So you testified earlier that you all had about half of one of these bottles left from the night before, correct?
Yes.
And so would you agree that this is one of the 3 bottles that was purchased between February 22nd and the 2 that were purchased on February 23rd of 2020?
I'm guessing
Okay.
it's like the bottle, yes.
All right, and it's 1.5 liters, would you agree? And when you say half, are we talking about to the top of the label was left from the day before?
Oh, goodness, no.
All right, a little less, halfway through the label?
It's too, right about.
Okay, about halfway through the label. So in addition to halfway through the label, which you began consuming after going to Publix at about 12:15, correct? So you all would have began consuming around 12:30, is it fair to say, when you got back?
I can't tell exactly.
Okay. And after finishing what you all had left over from Saturday, the 2 of you consumed 2 1.5-liter bottles, correct?
I'm not sure about the second bottle that he purchased, if it was empty or not at the time.
Well, you did mention that the police would find 2 empty bottles in the top of your trash, correct?
Yes.
And we did all see that in the photographs, correct?
See that they
Two.
were empty in the garbage, yes.
All right, and you say you were about 100 pounds at the time?
Yes.
And we all know Mr. Torres was 103 pounds at the time of his death, correct?
That's what they said.
All right, so that's 3 liters of wine between 200 pounds split between 2 people over the course of a day, correct?
Yes.
And you testified today that you were intoxicated at the time that this occurred, the videos between 11 and 11:30 at night, correct?
Yes, at some level, yes.
All right. Now, what does that mean to you? Previously, have you indicated that that means the room is spinning? Do you ever recall saying that?
I do.
So what was your level of intoxication at this point in time when the first video was filmed at 11:12 p.m.?
Do you mean from lack of sleep or alcohol?
From the alcohol.
What was my level?
What were you feeling? Did you have trouble with your balance?
I was more tired than anything.
Did you have trouble with your balance?
I don't believe so.
So you were able to flip a suitcase over with a 100-pound man in it, right?
I mean, yes, it happened,
Okay. How about your speech? Do you feel like your speech was slurred?
clearly.
How about your inhibitions? Do you feel like you were doing things that you wouldn't do when you were sober?
I wasn't thinking about that.
Well, on reflection, do you feel like this is something you would have done when you were sober?
I didn't know me and George.
I'm just asking you, looking back on this, when he's in the suitcase and you're telling him how you feel, and then you wait 11 minutes and you film another 22 seconds, and then you go upstairs, upon reflection, is that something you would have done and left him in there had you not been drinking?
I don't know. I can't say.
Okay.
If I was scared, then it would be something.
Okay. All right. Now, today you testified about the time frame between the 2 videos, correct?
Yes?
So you came down from the shower where you were hiding, correct?
Yes?
And as you're coming down the stairs, before you even get to the bottom of the stairs, you can kind of see over your shoulder or towards your right that he's trying to hide in the suitcase, correct?
Yes.
And the lid is down, but it's not closed, and you can tell he's hiding in there. It's not a great hiding spot just yet, right?
Correct.
And so you come over to him, and you're laughing, right?
Yes.
And you move the suitcase around some before zipping it shut, right?
No.
No? You immediately zip it shut?
Yes.
Okay. And you're both still laughing about it, correct?
Correct.
All right. And then it's during this course of time, how quickly is it after you zip it shut that you begin filming the first video?
I don't know without watching it. I don't know.
Okay, I mean, the video's not gonna catch you zipping him up because you're like 10 feet away, right? How quickly after you zip him up is it before the video starts, is my question.
I don't know.
Okay. And then during that 9 minutes and 14 seconds is when he begins to get angry, correct?
What, 9 minutes?
Between the two videos, there's 9 minutes and 14 seconds between the end of 1061 and the beginning of 1062 and 1063. So you got the 2 minute, 3 second video that starts at 11:12:45, correct?
I guess.
Permission to use state 17?
You may. She knows exactly how she was thinking, feeling, everything that her attorney asked her. She knows the answer to. But as soon as the state starts asking her questions, there's so much that I don't remember. I don't remember how long after I zipped him up I started that first video. Oh, I don't remember. I don't recall.
All right, so we're looking at entry 31107. That indicates, according to the phone extraction, 2/23/2020, 11:12:45 p.m. Image underscore 1062 movie begins being captured. And we have seen that that is about 2 minutes and 3 seconds. Entry 31113 indicates that image underscore 1063.move
Also, her attorney asked her about lying when she was at the jailhouse and doing the interview with the investigator there. What about the same lie she told at the scene of the crime? She was afraid of being arrested that day too, or just when she showed up to the police station?
3, a second movie is captured at 11:23:03 p.m. Your testimony was that after that first video was captured by your phone and you, Mr. Torres began getting angry and trying to push his way out, correct?
Say it one more time, please.
Between these two movies, of which there's about 9 minutes and 14 seconds, Mr. Torres begins to get angry and try and push his way out and get out of the suitcase, correct?
He had been angry on and off throughout the entire day.
Okay. You didn't tell us that earlier. You said it was a wonderful, fun day all day, correct?
That's because I lived.
Okay. But you did not tell us earlier today that he had been angry throughout the day.
When would I say that?
You described your entire day of doing puzzles, and arts and crafts, and outside by the dartboard, and you said it was a wonderful day and everything was fun until he was in the suitcase. Did you not testify to that earlier today?
I did.
Okay. My specific question between these two movies is, this is when he begins to get angry and trying to push his way out and to get out of the suitcase, correct?
Angry again, yes.
Okay. And he was expressing his anger in what manner? How did he say this?
At which point throughout the day?
Ma'am, you know very well that I'm talking about between these movies. Please answer my question. Between these two movies, how did he express his anger with you?
Told me that I was going to fucking die.
Okay. Now this is happening after he's already told you several times he cannot breathe in the suitcase, correct?
Correct.
And he's been in there for whatever brief amount of time it took you to zip him up, and the laughter stops, and then you go over and begin to film, correct?
Yes.
And you're filming. Your purpose of filming is to kind of teach him a lesson. This is your chance to say something to him when he can't say anything back to you, correct?
No.
Then correct me.
There was no lesson to be learned. It was just I wanted him to try to understand how I felt so maybe he could progress in being a better person the next day.
So you wanted him to understand how you felt in the past, and that's not teaching a lesson?
I just wanted him to understand.
Okay. All right, and so immediately prior to zipping him up and putting him into the movie, you had been upstairs, correct?
I'm sorry?
Immediately before coming down and zipping him up and then filming the first of the two movies, you had been upstairs in the shower, correct?
Yes.
I'm going to publish what has been labeled as image_1061, which according to the timeline was captured at 11:03 p.m., 31 seconds with her device. All right. Does this appear to be the suitcase that's in question in the two movies that are filmed at 11:12 and 11:23 p.m.? No? And it was your townhouse, correct?
Mine, yes. Flush hours.
When did you get him off the lease?
I don't
I'm
know
not sure
what just happened.
Year it was, but I don't think he was actually removed.
But you don't remember taking that photograph 9 minutes prior, captured. And we have seen that that is about 2 minutes and 3 seconds. Entry 31113 indicates that image_1063.move All right. Does this appear to be the suitcase that's in question in the two movies that are filmed at 11:12 and 11:23 p.m.? No? This is image 1061, taken at 11:03 p.m., 31 seconds. Does this appear to be the blue suitcase that's in the two videos that were captured at 11:12 and 11:23 p.m.?
Correct.
Did you take this image at 11:03 p.m.?
Okay, so she photographs the suitcase at 11:03. She takes the first video at 11:12. The second video at 11:23. That suitcase looks full to me. So I'm guessing he's already inside the suitcase. And that means that there's a 9-minute period between this photo being taken and the first video. So the follow-up questions are probably, what happened in those first 9 minutes? And then what happened in the second 9 minutes? Because at the end of the first 9 minutes, he's pleading for his life. And you testified that you didn't start fearing him until the second 9 minutes. So what was going on in the first one?
I don't remember if I did or not.
And again, we had, and by we I mean you and Mr. Torres, 2 1.5 liters bottles of wine and plus whatever was left over from the day before, correct?
That's correct.
So you don't remember taking this photograph?
I don't.
Do you remember whether or not Mr. Torres was in here?
I don't remember taking the photo.
Okay. So, what is your memory of what happens between 11:03 p.m. and 31 seconds when that image is captured, and then when the movie starts at 11:12:45? What do you remember?
I don't.
Okay. Do you remember anything from that night?
I do.
You told the police on February.
She remembers everything that happened for those periods that are beneficial to her case. We're supposed to believe that she remembers everything, that her memory is spot on. Outside of the testimony she's already given, she can't answer any questions about what happened that night. Her entire testimony that she's already given is unbelievable at this point.
February 25th, 2020, when they first showed you the video, that you didn't remember taking that. You remember that?
I do.
And your testimony is you do remember taking that video,
I do.
but you don't remember taking that photograph 9 minutes prior.
Correct.
Is there something, did you have more to drink in those 9 minutes?
I did not.
If you don't know what happened in those 9 minutes, how do you know you didn't have anything else to drink in those 9 minutes?
In that suitcase, the entire time between 11:03 when that image was taken, and then when the second video was taken at 11:23 p.m.?
I believe so, yes.
So for 20 minutes? Yes?
However long the time frame is.
Did he begin telling you that he couldn't breathe before the video, or do you not remember?
I don't remember.
Now, you testified moments ago that
I just want to point out that he asked her once if he was in the if George was in the suitcase at 11:03 when that image was taken, and she said, "I don't know." He asked it a different way just now, and she said, "I guess," regarding whether or not he was in the suitcase for the entire 20-minute period from 11:03 to 11:23 when that second video was taken. And she said, "I guess," whatever the time frame was. So she answered in the affirmative to that second question.
your two neighbors must have misremembered which night the loud noise was, correct?
Yes.
And now you're telling us that you don't remember taking the photograph at 11:03 p.m., correct?
Correct.
Did the police come out to your townhouse on Sunday, February 23rd, 2020?
Yes.
I'm talking about Sunday. This is the Sunday fun day when we're going to Publix twice. Were the police out of your residence?
No.
It was the day after, Monday the 24th, correct?
Yes.
And that Monday morning, you called 911, well, Monday afternoon at about 1 PM, correct?
Yes.
And between that time frame, you were the only person in your apartment plus Mr. Torres in the suitcase, correct?
Yes.
So if anything had been disturbed in your apartment, you had all the time that you wanted to undisturb them before calling 911, correct?
If I wanted to.
Okay. And you still, your testimony is there was no loud boom that shook the walls of your townhouse at about 11 PM the night of February 23rd, 2020, correct?
Correct.
To the best of your memory, correct?
Correct.
Now, that second video is 22 seconds where you just hear him say Sarah and you don't say anything. You're familiar with that video, correct?
Yes.
It's after that that you go upstairs, correct?
Yes.
How quickly is it that you go upstairs after that?
It was pretty quick.
And you grab the dogs?
No, the dogs were upstairs already.
Okay. Did you call 911 and let the police know that you had zipped somebody shut in a suitcase and they had not been able to get out for 20 minutes?
I did not.
Did you go to Brian's house and tell him, I had to zip Mr. Torres up in a suitcase shut? We need to do something about that before he passes.
I believe that's what the phone call was.
Okay. Well, what do you remember now about the phone call with Brian?
I know that I called him. I don't know specifically what it was about.
Now, your testimony, it seems like you spend day after day finding things to entertain Mr. Torres to do, correct?
Yes.
Almost like having a child. You have your own child, correct?
I do.
What you described sounded like having a small child, would you agree?
That's your interpretation.
Okay. Well, you take him from doing arts and crafts to doing puzzles, so on and so forth, correct?
When he's been drinking, yes.
And Mr. Torres was notorious for doing some of these things, correct?
What do you mean?
Well, you described Mr. Torres as being notoriously known for doing things. You described your ex-husband, Brian Boone, notorious for doing things like nagging and calling all the time. You remember your testimony calling people notorious for doing things?
Yes.
What would you say people would say you're notorious for?
I don't know.
And you would not answer Brian Boone, your ex-husband's phone calls, just so that you could let him know that you're busy and you have things going on, correct?
I knew that at whatever time it was that he was calling me, that he could wait for the few moments of me getting up to where Lucas gets out of school at 3 o'clock.
Okay. But you wouldn't return his call. You would let him call several times, correct?
That day, yes.
Okay. How about other days? Would he have to call to remind you to get Lucas on other days?
He wasn't reminding me, he was just making sure that Lucas was covered for a pickup or drop-off.
All right. You didn't mention to the sheriff's office on either February 24th or February 25th about going to Publix with Mr. Torres at noon or 12:17, did you?
I don't recall.
So the best evidence of that would be the recording of those interviews?
Correct.
Did you not remember going to Publix with Mr. Torres that day?
At what point?
At any point?
No, I didn't.
You had indicated to the police that it was about 4 p.m. that you all had started drinking after doing chores. Do you recall that?
I do.
And your testimony today was that it was really more after you guys went to Publix at about 12:17 p.m., correct?
Yes.
And you did not tell the truth to the police, correct?
I'm sorry, I didn't hear the question.
You did not tell the the truth to the police about that, correct?
I did not.
And when they were asking you about Mr. Torres's injuries, you told them that you had nothing to do with it, correct?
Yes,
And that was not the truth.
correct.
What did you all have for breakfast on the 23rd?
I don't remember.
Did you all have lunch?
I believe we had leftovers from, I think, something that we had in the fridge.
And do you recall what those were?
Not at this point, no.
And then I believe you mentioned having a sandwich of some sort for dinner?
No, I believe it was for, I'm guessing he and I ate at the same time.
And at one point, Mr. Torres called his brother Juan, correct?
Yes.
And do you admit that you were yelling in the background, telling Mr. Torres to tell his brother that he had been choking you?
I don't know if I was yelling. I know that he could hear me through the phone.
So how long had that been going on that day? When did you start getting on Mr. Torres about choking you in the past?
He and I had conversations about it because he didn't remember doing it to me. And the next day and the day of,
Is it fair to say that there are just points in time where you don't remember what you do either, correct?
are you talking about almost 5 years ago?
I'm talking about from drinking. Is it fair to say that you don't often remember things that you did while you were drinking?
I would not say often.
Okay. In the course of your relationship with Mr. Torres, are there things you don't remember happening that happened the night before between you and him?
I can't say that at this point.
But you said that you don't remember taking that photograph at 11:03 p.m. on February 23rd, correct?
Yes.
Was there anything else that you were telling Mr. Torres that he needed to tell his brother?
Not that I can recall.
Okay. Was there anything you were telling him that he needed to tell his daughters?
Not that I can recall.
Now, you indicated that Mr. Torres would use your phone to look at pornography.
Correct.
Were there ever any points in times when it was you that was used looking at pornography?
If I was, it was to go back and look to see.
Did you ever threaten to get Mr. Torres arrested if he did not do what you wanted him to do?
I wouldn't say threatened.
Okay. Well, were there ever points in times where you would like him to call you or return a call, and if he didn't do that, you would threaten to get him arrested?
It depends on if he had my keys or something that I needed from him.
Okay. And it was your townhouse, correct?
Mine, yes. Flush hours.
Well, when did you get him off the lease?
I'm not sure what year it was, but I don't think he was actually removed from the lease.
Okay.
I think he was made a different type of tenant.
And did you change the locks so that he couldn't get back in at the points in times when you kicked him out?
I did sometimes.
And then would you leave the key in the hiding spot that he was aware of?
were multiple hiding places.
Okay. On any of the 911 calls, did you ever mention that Mr. Torres was aware of where you kept your keys and that's how you got back into the house?
I didn't know I needed to.
Okay.
He would never break into my home.
All right, and it's your testimony that you did not push him down the stairs, correct?
Yes,
And in fact, it was him that dragged you down the stairs the night before, correct?
yes,
Now, by dragged, did you leave your feet?
yes.
And did you get scrapes on your knees or anywhere from the carpet?
I'm not sure. I don't.
Did you get any injuries, like bruises or abrasions or scrapes?
I was missing a lot of my hair. Yes, that was on the stairwell.
Okay. And you agree that you were photographed on February 24th when the police came out, correct?
The day of the incident?
Well, the afternoon after the incident. We're not sure when he passed.
Yes.
Some of those photographs showed ashtrays inside your house. I thought you said you guys couldn't smoke inside your house,
We couldn't.
but you did, right?
Sometimes, yes.
And you agree you would go to the hospital and tell them things that were not true, correct?
Yes,
There were times where you would go to the hospital and leave without getting treatment, correct?
yes,
And is it fair to say that you often had alcohol in your system when you were going to the hospital, correct?
sometimes.
All right, so just to summarize the day to make sure we understand it. You all wake up sometime in the morning, but it's an unknown time, correct? On February 23rd.
Or early afternoon. Yes, I had a problem with the detectives and them having me guesstimate times.
Okay. Are you the kind of person, like most of us, that uses your phone when you wake up?
No,
So the first activity on your phone may have nothing to do with when you woke up. Is that fair for you?
yes, other than looking at the time possibly.
Okay. So, at some point you wake up, it doesn't sound like you have breakfast, correct?
Correct.
You do some chores, correct?
Yes,
So that is true. That part of it is true. You did do chores before going to Publix at 12:17?
yes,
All right. After chores, you go to Publix and you get that 1.5 liter Magnum bottle of Woodbridge Chardonnay, correct?
I'm not sure what Magnum is.
1.5 liters. Instead of the 750s, it's the double size. It's like 2 bottles of wine.
Okay, yes,
So you got a 1.5 liter, right?
yes, it is the larger bottle.
And you got home, and you at 100 pounds and Mr. Torres at 103 pounds began drinking this wine, correct?
I'm guessing so. I'm not going to guess times.
Well, don't guess. I mean, you got home from Publix. When was your first drink?
I'm not sure. I mean, we could have continued to do whatever was left over from what we didn't do before we went to Publix.
Okay. So you may have started drinking even later, correct?
Then
12:30 when you get back from Publix?
I don't know.
Okay. Was it 1:30 or 2:30 when you began drinking?
I don't know.
All right. Was it before any of the phone calls to the brothers and his daughters?
Yes,
And so you drink what's left in the bottle of wine from the day before that's halfway labeled, correct?
at some point.
And then you drink 1.5 liters of wine, and he goes out and gets another one on his own without your permission or suggestion about 5:30, correct?
Correct.
And then you all consume that one as well, and it ends up in the trash can at the end of the night, correct?
Apparently.
Okay. At what point in the night does your memory tape stop? Because you described that it wasn't on at 11:03 p.m. when that photograph was taken. What's the last thing you actually do remember prior to these videos being made?
I don't recall it at this point. I don't remember.
All right, and so it ends in hide and seek after arts and puzzles, correct?
Yes,
He says, tag, you're it, but you run and go upstairs and hide, right?
yes,
So does that mean he's it and he's supposed to come find you?
No,
Okay.
that's just,
So you both hide?
no.
Okay. How does this work?
I don't know how to tell you.
Okay.
I was it and I went and hid.
I mean, my understanding of the rules of hide and seek is one person will be it, cover his or her eyes and count to like 20 and then go find the person that's hiding. Is that your familiarity with the rules too, or do you guys have house rules?
I understand how the
Okay.
game of hide and seek
So
works.
explain to me, what was your expectation? You go up to the shower, were you expecting him to come find you?
I was,
Okay. And after a while, he did not come find you.
yes,
And that's when you return downstairs.
correct.
And because of the way your townhouse is set up, you can kind of see over where the suitcase is and that he's trying to hide in there, but it's not successfully hidden just yet.
I mean, yes, you have to come down a good ways in order to be able to
Right,
do that.
right. But you testified that was before you got to the bottom.
Yes,
All right. And then you come over there and thinking that it's funny, you zip him shut, correct?
yes, we both thought it was funny.
Okay. May the defendant stand down?
Entered into the well?
Yes.
Yes.
Go down.
Deputy, could we release her into the well, please?
Is he going to ask her to get in the suitcase?
All right. Ms. Boone, can you demonstrate for the jury where Mr. Torres' head was and how his body was positioned in the suitcase, if you don't mind?
His back was this way and his head was here.
All right, and then is it fair to say his feet are kind of down here, which would be the front left corner from their perspective in the jury box?
Yes,
And then his knees are kind of tucked up towards his face?
if I remember correctly, yes, that's the position.
Okay. All right. Can you help me understand how it was that you zipped it shut? Can you show us where you say you left an opening that his hand got out of?
Would it be easier to put it on here?
I didn't want to make you go down there. If you're happy doing that, I'll let you.
Hold up. Does she need to be wearing gloves?
Yes.
Agreed. If she's going to be manipulating it.
What do you want her to do?
Just demonstrate how she zipped it shut.
Okay, well, where's the paperclip? And do you remember which one it was in?
This side.
Judge, the paperclip was on when this event occurred. When we pulled the suitcase out earlier, the paperclip was not attached. So now the prosecutor has attached the paperclip. We don't know if that's the way it was attached.
It's not even a paperclip.
We
Okay.
don't know if that's the proper way that it was attached. But he's asking her now to pull.
Is there an objection?
Yes?
Approach.
So what's the objection? So he's asking her to demonstrate how the closure of this suitcase. I don't think that he's asking for it to show the jury how she closed the suitcase. I think he's asking for it to show how much she closed the suitcase. The location or application of the paperclip shouldn't matter in that instance.
Objections overruled.
All right.
If you feel most comfortable, sir.
Madam Clerk, are you ready? Can we see how it was that the two zipper parts were positioned when you say that Mr. Torres was able to get his hand out? If you want me to do it, I'm fine to take your direction.
From what I remember, this is how the suitcase was. This was up here. This was not this hard either. So this was like here,
Okay.
right here.
About right there, ma'am?
Sure.
I assume this one was much closer? It's not over there? Where'd you leave?
You asked me where I zipped it.
When you say that it was zipped shut, show us.
Are you talking about how I zipped it, or?
When you're done zipping
With
it
the hole.
shut and he's inside of it, where are the zipper components?
Just tell me where it's at.
I mean, it was the corner. I mean, it's, the corner was
It was right
kind
here?
of open. I mean,
In here?
it's not. Yes,
Yes?
this one was pretty much, yes. From what I can remember. That's how he was coming with his hand out. It was like this from the
Nope.
corner part.
Nope. Wasn't like that. Nope. Couldn't have been like that, because if it's like that, he can get out. And he couldn't get out. He told us on the video he couldn't get out. She's lying.
Thank you. You can return to your seat. Did you ever change the position of those zippers once you put it in that position?
I did not.
And so once he was zipped into there, there's some amount of time, but you don't remember specifically before you start taking the 2-minute video, correct?
Yes.
And then that's when you say what you say, and that's when he says what he says. We've all heard it, correct? And then between there and that second video of the 22 seconds length, it's at this point where he's beginning to get angry. And then that's when you take the baseball bat that's in evidence, and your testimony is you start poking him with the end of it.
Did you say this was the second video?
Between the two videos, that's when you started hitting with the bat because he was getting angry and trying to escape, correct?
Right, I was not hitting him, yes.
Okay. Did you ever hit him with the bat while he was outside of the suitcase?
No,
So each time that he is hit with the bat, it's through this suitcase. And that's what leaves the marks on him because you didn't hit him with the bat outside the suitcase, correct?
yes, if you'd like me to demonstrate.
No, that's okay. The suitcase will speak for itself. And then you take the second video and you go upstairs and go to bed, correct?
I apparently went upstairs and I used the phone to make a phone call,
Okay.
and then I fell asleep.
All right. And at the point in time when you left and went upstairs, he was still inside the suitcase, correct?
Correct,
Was he still asking for you and calling your name?
not that I can recall.
Did you say shh to him again?
I don't remember.
Did you tell him that this was his problem and it's on you again?
I don't remember.
Did you do anything to help him escape from the predicament that you zipped him up in?
No.
No other questions?
Any redirect examination?
Ms. Boone, he just asked you the question that you poked him, and you didn't poke it. You poked, every time you poked him hard with the bat, he was inside the briefcase,
The suitcase, yes.
the suitcase. But you remember when he put his hand out, did you not hit him in the hand outside the suitcase?
Yes,
Okay, so that was the only time the bat touched Mr. Torres's body outside the suitcase,
yes.
was when you hit him with a hand. But all the other injuries were with you poking him pretty hard. I mean, you bruised your hand, correct? Doing that. Thank you. That's all I have.
Ma'am, you can return to council's table.
Judge, can we approach you?
Just a moment. Let me get her situated at table, and then we can approach. All right, come on up, y'all.
All right, I think that's the last we hear of her testimony. They're not going to let us hear what they're talking about up at the judge. Let's see what else we got here.
Discussions with Ms. Boone. And Judge, we've had discussions with Ms. Boone. And she claims that every time that he went to the hospital and the medical records would show that it was in relation to some type of domestic violence involving her, we've expressed to her that we do not wish to pursue it and introduce those records of Jorge Torres, of his medical records of the different times he went as it relates to their difficulties. Do you understand that?
Okay. Ma'am, earlier we had discussed, anything else to add to that, Mr. Owens?
Just that I've explained to her that the lawyers make those decisions.
Okay.
And I believe she's in agreement now. We just wanted to get it on the record.
Understood. All right, so ma'am, I just got a couple follow-up questions, similar to other conversations we've had over the last couple of days. I don't want to know about the specifics of any conversations you've had with you and your attorneys, just whether or not you've had them. You recall earlier today I'd asked you questions about certain rights that you had the ability to decide. Do you recall that conversation that we had, ma'am? It was before you testified.
Yes.
Okay. Do you recall that I advised you that the lawyers get to make most of the strategy determinations at trial? Do you recall that?
I do.
And do you recall that you said you understood that?
Yes,
And do you also recall that I advised you of certain rights that you have? Do you recall that?
I do.
And one of those rights was the right to testify or remain silent. Do you recall that?
Yes,
And did you understand that?
yes,
So this decision is a trial decision as to whether or not there's certain evidence that your lawyers are going to seek to utilize in your defense. Do you understand that?
yes,
Do you understand that they are exercising that trial strategy at this time not to pursue those medical records?
I do.
Okay. Do you have any questions about that?
I don't.
Are you on board with that strategy?
I am.
Are you still on board with the strategy utilized in your defense?
All of it, yes.
Are you satisfied with your lawyer's representation of you in this matter?
Yes.
All right, thank you. State, anything else we need to address before we
My
retire
understanding.
for the evening?
Sorry.
That's okay.
My understanding is the last civilian witness they intend on calling is arriving at MCO at 9:03 in the morning tomorrow.
It was either 9:03 or 9:05, yes.
And plan will be to depose her in the evening at 5:30.
Okay.
Then, just scheduling purposes, we're trying to figure out when we would need our rebuttal expert, Dr. Werner, to appear.
I know Mr. Owens had said they were endeavoring to finish by Friday, but I don't know if Dr. Harper's availability issues for tomorrow is going to change that anticipated timeframe.
I'll try to reach out to her by text. That's usually how we communicate. But
Well, assuming she
All right,
testifies.
so the rest of this is just them dealing with matters that don't really matter to us. So we've heard Sarah Boone take the stand. We've heard her on direct examination. We've heard her on cross-examination. And where are we at with respect to whether or not Ms. Boone's testimony is credible? Where are we at with respect to the battered spouse defense? Where are we at? Let's hear from you guys. So Natalie says, so if she hits his fingers with the bat because she saw him trying to get out, that means she purposely tried to break his fingers so he couldn't open the zipper to keep him trapped. Yes, that's exactly what that means. But that's the nature of this particular defense. So her defense is essentially, I have the right to kill him because I was in fear for my life. So my use of force was justified. The use of force that they're talking about in this case is the decision not to extricate him from the suitcase and the violence that was inflicted on him to keep him trapped in the suitcase. So yeah, it's okay. Now that they know that they can get that defense on the verdict form, it's okay for them to tell the jury, hey, I'm trying to keep him trapped because I'm in fear for my life. Whether or not I'm trying to kill him, I'm trying to keep him trapped. It's okay for them to say that. They have abandoned this was an accident defense at this point. I can't imagine how they could sustain both of those defenses at the same time. And they've elected to go with this one. It's probably the better one to go with because it was an accident thing is totally debunked by the video. So that was never going to work in the first place. This is the much better defense. I'm not saying it's a great defense. I'm just saying it's likely better than it was an accident defense. Natalie says, Boone is just making this too confusing for me. Her story is everywhere. Maybe I would feel different if from the beginning she said I feared for my life, but no, this is phony baloney for me. So yeah, and that's kind of the problem that the defense is kind of has been trying to deal with this entire time. So that's why on direct examination, they elicited from her that she lied to the police officers. They had to get her to say, yeah, I lied to the police officers and offer some explanation for it because the explanation that she provided might sway some of the jury members as to might bring some of the jury members to her side, because they might be able to relate to her statement that the only reason she lied was because the last time she called the police, she got arrested, and she's trying to avoid getting arrested in this instance. So, yeah, she's all over the place. But I mean, maybe a juror believes that, you know, she was lying then, but she's not lying now. So it's kind of, they had to take the case where it was at the point that it got dropped onto their lap, or that they elected to have it dropped on their lap in this action. And that was, you know, only a couple months ago at this point. That was what, late August that they came on to this case, and trial was scheduled for the beginning of October. So they had roughly a month to prepare, and this is what they came up with. And it's probably the best they could do. Tread says Nathan needs more ties. I've seen that one. Oh, Tread. You know, some of my ties I like better than others, so I probably wear them more often than I wear others. But, you know, I don't really keep track of which ones I've worn on the streams. So what can I do? Natalie says that the prosecutor started off good. Are you saying then that the prosecutor ended poorly? So I think that toward the end, he was trying to get at some things that some other witnesses that are subject to recall might be able to call some doubt to, if that makes sense. So I'm with respect to the suitcase, the gap that she says she left in between the zippers, the zipper pulls. I'm wondering if one of those videos shows where the zipper was, because he followed up that demonstration with, and you didn't change at any point where the zippers were located after you initially zipped them up. And she said no. So now we have that picture that he just displayed. We have, and we have two videos. And I doubt that the defense team has had the time to go through frame by frame on each of those videos to determine whether you can see where the zippers are in relation to each other in those videos. But the prosecution has certainly had the time to do that. And they also have the team at their disposal to be able to do that. So perhaps somebody else is going to get up and testify, or he's going to have a blow up at the during his closing arguments, extracted directly from either the video or the photo that'll show where those zipper pulls were in relation to each other. Natalie, both Boone and the prosecutor were having trouble moving those zippers, but again, he wasn't putting her on to show how easy or difficult it was to pull the zippers. He just wanted to know where the two zipper pulls were in relation to each other. So I'm hoping at this point that the prosecution is able to introduce some of the evidence that might lend to our belief that there was domestic violence both ways in this relationship at some point, either in their redirect, in their when the defense is done with their case and the prosecution has the opportunity to go again. I'm hoping that they can introduce something here to show that the domestic violence was going both ways. But we shall see. I don't know who they're going to call. I don't know who defense team is still going to call in this case. But at this point, I think they may have been able to convince at least one juror, and we just got to wait and see. So it is now 6:08 in the p.m. Court is done. We will be right back here again tomorrow to see day number 4. And I just want to point out that the prosecution got done in just about 2 days, right? They went in, they weren't done with their case in chief at the beginning of today, at the end of the day yesterday, but all that was left was the cross-examination of their final witness. So it kind of took them just 2 days to present their entire case. I think the defense is probably going to take a little longer because they ramble, for one, and two, I expect that there's going to be some surprise witnesses, surprises for us, probably not for the state, but only time will tell. But for now, we are going to end this particular stream. And as always, if you all have any questions about what has happened up to this point, any questions about anything you have heard here today, any questions about this trial, please put them in the comments to this video, not in the thread during the video. And I'll respond to any comments that you have. I'll try to respond before we go live tomorrow. I ask that all of you join me here tomorrow. Anybody that's still here that hasn't mashed that like button, please do so. It does help out the algorithm. And as always, my name is Nathan Saunders, and this is The Legal Good. Good night, everyone.